Good morning and welcome back to the LawNewz Network. I'm Jesse Weber. Thank you for joining us today. So we have a couple of things on the agenda for today. First up, we're going to be continuing our coverage and discussion of the Casey Anthony trial. In fact, yesterday, July 5th, marked 6 years since the verdict was handed down in that case. So just to give you a recap about what this case is about and what we actually have on the agenda for today, because it's pretty exciting. So this case, I'm sure many of you already know about it, but I'll give you a recap anyway. This is when 2-year-old Kaylee Anthony, she went missing in 2008. Casey Anthony, her mother, was originally arrested on child neglect. Now, police searched Casey's car and a dog discovered scent of human decomposition in the trunk. Now, the skeletal remains of Kaylee were actually found in a wooded area near the Anthony home. Casey was charged with first-degree murder, aggravated child abuse, aggravated manslaughter, and 4 counts of falsifying information to the police. The prosecution took the argument that Casey killed Kaylee by knocking her out with chloroform and then duct taping her nose and mouth, which suffocated her. She did this is their theory, so she could rid her life of the responsibilities of motherhood. They sought the death penalty against Casey Anthony in this case. Now, the defense team of Jose Baez and Cheney Mason argued that Kaylee died as a result of an accidental drowning in a pool, and Casey and George Anthony, who's her father, covered up the death. But she did not in any way cause the death of Kaylee. Now, the 7-woman, 5-man jury deliberated for 10 hours and 40 minutes before coming back with a verdict of not guilty of first-degree murder, not guilty of aggravated child abuse, and not guilty of aggravated manslaughter. However, Casey was found guilty of 4 misdemeanor counts of providing false information to law enforcement, and she was sentenced to serve some time in jail, but with already time served, and she was actually released in July 17, 2011. So, this case sparked the nation. Everybody was following this case, and even to this day, there's still discussions about it. And whenever we talk about another trial, this case is used as a benchmark to try to explain how on earth this woman was acquitted and what was the techniques used by the defense and the prosecution. Some people are surprised at the verdict. Some people weren't surprised. Now, later on this morning at around 10:30 Eastern Standard Time, we are actually going to be interviewing Cheney Mason, who was the defense attorney for Casey Anthony. And as you can imagine, I have many questions for him as we mark the 6-year anniversary of the verdict. So you're not going to want to miss any of that. We're going to be continuing our coverage and analysis of that. But later on, we're also going to be talking about the Holly Bobo case. Now, Holly Bobo was a Tennessee nursing student who disappeared in April 2011. Now, Bobo, her brother, had actually told authorities he saw her go into the woods with a man dressed in camouflage. Her remains were discovered 3 years later near the home of Zach Adams. And Adams, along with 2 other men, John Dylan Adams, who's his brother, and Jason Autry, they were also charged with the woman's murder. Now, all 3 have pled not guilty, but what we're talking about now is the trial for Zach Adams, which is to begin on July 10th. Currently, we have jury selection continuing today. Now, this case is very strange in the sense that whenever you have a missing person and who's, trying to find out what happened, we're dealing with kidnapping, potential rape, and murder. Obviously, there's going to be lots of issues about what evidence can be brought in, what can't be brought in, and we're going to have to discuss that as we move later on and play some clips from this case. But actually, I want to talk back about the Casey Anthony trial. And to help me talk a little bit about this, we've brought in criminal defense attorney Adam Sostrin on to help explain a little bit about this case as, again, we mark the 6-year anniversary of the verdict in this case. Mr. Sostrin, it's good to see you.
It's great to be here. Thanks for having me.
Oh, thank you. So again, yes, we are talking about it's been 6 years since that verdict was laid down. Just from a general standpoint, all these years later, what still resonates with you about this case even today?
Well, I mean, it's a fascinating case. 31 days went by before there was any statement to the police saying, what happened to Casey's daughter. It's just so bizarre, and her explanations were so I didn't make any sense. Of course, that's how she ended up getting the 4 convictions for her false statement to the law enforcement officers. But yet she still came away with a not guilty, not having testified in the case.
Now, were you watching this trial live when it was occurring?
Bits and pieces, I think, along with the public and everybody else. I think I saw some of the salacious stuff.
Yeah, what was your initial reaction when you saw the verdict? Were you shocked?
I guess in the very, I don't think I was that shocked. I kind of thought, sort of towards the end, that the prosecution was trying to build a case that didn't have the strongest of foundations. I think that was my reaction towards the end.
Right. So in other words, that they spent more time, the argument was, attacking her character and who she was as a person, as opposed to building the evidence against her in a first-degree murder count and a manslaughter count. Obviously, she was convicted of falsifying information. I don't think there was any denial about that. I just want to start from the beginning. What do you think about this case took the nation by storm? I mean, we have cases. We've covered cases here on the LawNewz Network where you have a child who's been killed. And what is it different about this case that really took the nation? Everybody was interested in it.
Well, I think everybody's maternal instinct came up, loud. And how could it possibly be that a mother does nothing with respect to a daughter whom she loves for over a month? It just doesn't make any sense. So everybody assumed, and I assumed, and I still think that, in some way she's responsible for the death, but what exactly happened is the problem, and that's why perhaps the prosecution didn't get over that hump, and they weren't able to get the convictions they wanted.
Now, we didn't know, speaking of not knowing what happened, we didn't even have an exact cause of death. We had a theory about what the cause of death was, in the sense that the argument was that Casey had used chloroform to knock Kaylee out and then duct taped her nose and mouth, thereby suffocating her, but we didn't have an exact cause of death. And in fact, the jurors have said, or at least of some of the jurors, that because they didn't have an exact cause of death, that was one of the reasons that they had to grant a not guilty verdict. And I'm curious, in your practice and seeing this case, when you don't have an exact cause of death, is that hard to pinpoint to actually find a guilty verdict?
Well, sure. I mean, it's hard to figure out what happened. So how do you come up with the first-degree premeditated murder? How do you come up with the manslaughter? You don't know what occurred. They didn't find any evidence of Anthony with respect to the, I think, the tape that was sealed over her mouth with the chloroform. They didn't find that. They did find an internet search, however, with respect to, and that was a big part of the trial, the chloroform. But we just don't know. And that of course the defense medical expert testified that even they weren't certain. Of course they weren't certain. It was the defense, but there was just enough confusion and enough things that weren't made clear, weren't spelled out, weren't defined, that the jury almost had no choice but to come back with the not guilty.
Yeah, that's what makes it so eerie about these kind of cases, when you don't know what happened. I mean, look at, we covered David Criado out of New Jersey, where we didn't know what the cause of death was, and that was determined to be a mistrial. So, when we have those kind of situations, not having all the answers and going in, it can result in what we saw here.
And can I tell you how bizarre it is that, I read that Casey Anthony is living with the investigator who handled the case. So the whole thing is just so bizarre.
I actually want to bring up a little bit about what's going on with her today. I mentioned earlier that we are going to be interviewing Cheney Mason, who is a defense attorney, along with Jose Baez. We're not interviewing Jose Baez, but we are interviewing Cheney Mason. And one of the things that struck me is that she actually did an interview, I'm looking for it right now, with the Associated Press. And she said, I'm still not even certain as I stand here today about what happened. About the drowning defense, she says, everyone has their theories. I don't know. As I stand here today, I can't tell you one way or another. The last time I saw my daughter, I believed she was alive and was going to be okay, and that's what was told to me. So, my question to him later, to Cheney Mason later on, and what I'm curious what your thoughts are, and if you have a defense that this young girl drowned in a pool and it was Casey Anthony and her father, George Anthony, who covered it up, how do you say you still don't even know what happened? It doesn't quite match up. Am I correct?
No, it doesn't at all. And this would just be another statement that doesn't make sense, that finds contradictions with respect to what the types of things that Casey says.
Yeah. Let's talk about a little bit. This is the social media case that I don't know if it's of the decade, of the century, whatever. They say this is the biggest social media case that we've had, and it really occurred when different forms of social media were really up and coming. But the counter side of that is there's been arguments that this case is a reason for why cameras shouldn't have been allowed in the courtroom. She was vilified there was public outcry against her based upon what people were hearing in the case, based upon social media. The idea that this was an argument for why cameras shouldn't be allowed in a courtroom and it shouldn't have been a private hearing. I'm curious what you thought about that. She was already convicted in the minds of the public, and the social media and cameras were a way to do that. But then again, we had a right to know about this trial and see what was happening. So when you hear those kind of arguments, what do you think?
Well, I think so too, but of course that can be said. Well, first of all, anytime I'm in a trial and I have my client next to me, my client, despite all the voir dire that I do, despite all the questions that I do to the panel, I think most of them assume my client's guilty first, right? And then I have to somehow prove my client's innocence, which is just an unfortunate thing that happens with the American jury system. And the public is different than the jury. The public, the public is not, the 12 members of the jury that are sitting there listening to the evidence. It's something completely different. So I understand her feelings. OJ could say the same thing. In any big trial, they could say the same thing. So, that sort of falls on deaf ears for me. The public wanted to know, and the public wants to know, and I think it was acceptable for that trial to be out in public, for it to be displayed on everyone's TV. I think it was fine. I think it's great that we can see, right, how our justice system works, how people examine witnesses, what a closing argument looks like. I think that's, our judicial system is so interesting and amazing. I think it's great that we can see how it all works.
And I agree with you. That's why we're here on the LawNewz Network, to exactly do that, to provide people, to provide viewers an insight, behind the scenes, if you will, look into our court system and how it works, and what is the evidence that's presented, what are the issues that come up with that. And you can make a determination for yourself, if you're a viewer, as to what happened and what evidence, if you were a juror on that trial, how you would have, how you would have cast your vote. I want to actually talk a little bit about the style of the defense and the prosecution. Jose Baez, who was the defense attorney for Casey Anthony, dare I say he became even more famous from that trial, and became a common household name from that trial. His style in the trial, particularly his opening and closing arguments, what did you think of it overall, how he handled himself in the trial and how he presented the case to the jury?
Well, to tell you the truth, I think when I watched Jose Baez do the trial, I don't think that I was that. I think it's impressive what he did, and I think he probably, let's just say, he probably gained a lot of confidence after the trial. I think it's impressive that he was able to put forth a defense that wasn't supported by witness testimony with respect to the pool. So I just have to say, as a defense attorney, that's incredible. I guess that's all I have to say on Jose Baez.
But what's so interesting is, like you said, he came up with a theory about pool drowning, and does that not give other attorneys moving forward, hey, you know what? Why don't I just come up with an alternative theory? It doesn't really have to be supported by the facts. It doesn't have to be supported by testimony or evidence. Put it in the minds of the jurors. Give them something to think about. Is that what reasonable doubt really is? Just coming up with some alternative theory?
Well, that's the thing. Sometimes the judge will say, well, just because there's a chance that an alien could have put the knife in the hand of the defendant and, spoken in his mind and told him what to do, just because something could happen, because it's possible, doesn't mean that it's reasonably possible. So, I think most courts have problems with sort of putting up evidence that you have absolutely no basis for. He said it, of course, in his opening statement. I'm entitled, I guess, if my client and I have a theory that this is what happened, I would cross-examine the witness on that theory, even though there's no evidence, let's say, that we can put forward that would support it. The idea being that we would hope that we would actually glean that we get that information from the witness. So it's tricky putting out things that there's no, that at least from the outside we can't find a basis for. But if you have some good faith reason for doing it, you can. If you don't, it's a type of conduct that an attorney is not supposed to engage in.
Mm-hmm. Was there anything about the defense's strategy? Ultimately, they prevailed in this case, but was there anything about their strategy or their style that didn't sit well with you, or you wouldn't have done yourself if you handled the case?
I don't want to make any. I don't want to make any judgments about that. I'd have to say that I am, as a defense attorney, just from that angle, it's impressive that he was able to create doubt with not much. So that alone is something that I have to say. That's what we try to do in our profession, as long as we have a good faith basis for it. And the fact that he was able to get the jury to find his client not guilty on the counts that mattered, I guess I'm impressed with those things. And I think he's probably become a better defense attorney since.
Well, it's funny you should say that, because he then defended Aaron Hernandez and also raised reasonable doubt in that case, and Aaron Hernandez was acquitted in that double murder. And I saw a lot of similarities in his tactics between the trials, providing an alternate theory about Alexander Bradley, what happened there, who was the key witness in that case, and saying that he was the one who was responsible. At the end of the day, when you have a case that's not built on a lot of solid forensic or evidence or eyewitness testimony, and you raise that kind of reasonable doubt and give that in the minds of the jurors, it could work. And I think it's very interesting. And you have, like you said, in that you may not like him, you may not like who he is, you may not like who he defended, but you got to commend him for doing that and putting on that case.
Oh, absolutely. I mean, a lot of defense attorneys, I think, in the beginning would say, well, what am I supposed to do with this? How are we supposed to get here? And it takes a lot of time to build up these things. And I'm impressed with how he was able to make this work. But having said that, the paternal instinct in me comes back and says, oh my gosh, this woman probably did something terrible. And but we have a system where it's got to be proof beyond a reasonable doubt. And if the state doesn't make its case, it's not guilty.
So let's talk a little bit about the fact that she might have done something wrong here, because the defense put out the theory that she was involved in at least a cover-up of what happened to her daughter. Now, that is a risky play in the sense that if you're saying that you have at least covered up to the death of your daughter, is it not past the realm of possibility that you were in fact the cause of the death of your daughter? So to even put that defense forward, that theory that it was a drowning that you covered up, jurors are everyday men and women who hear this. Couldn't that have backfired?
You know what? I think the idea being that if she denied absolutely everything, having anything to do with anything, and having made those four bizarre explanations, which ended up getting the other conviction, it just doesn't make sense. He's trying to explain, I think, the false statements that she put out, sort of the strange behavior that she exhibited. One way that could explain it would be, yeah, it was an accidental death, and I covered it up. The consequences of that are not life, which is what you get, or I'm sorry, in this case, the death penalty for her daughter. So I think that was probably a smart thing to do.
You know what? Let's take a little bit of a look at his Jose Baez's opening remarks. We were continuing the coverage yesterday of it, but Adam, I'd like for you to just take a look at it, see some points that we were talking about, see the style, and we could talk about it after if that's okay with you. We're going to play a little bit. We have a little bit more of his opening argument. This is CA3, so I would like to play a little bit of that defense's opening statement, and we'll be back here to analyze it with Adam Sostrom.
That I want to talk about. Everyone talks about the smell of this car. And there's some things you don't know. things you should know. And here they are. June 16th is the day Kaylee drowned. On the 20th of June is when Casey runs out of gas for the first time. Now, it's going to be the state's contention that Kaylee was in the trunk of Casey's car from the 16th through the 20th. Well, Casey runs out of gas, and she calls her boyfriend up, Tony Lazzaro. And she does what she's always done. Goes and gets the gas cans. They break into the shed, they take the gas cans. Now, Tony Lazzaro's testimony will go unimpeached. And that is, this young man cooperated with law enforcement from the very first day. He refused to speak to us, only at deposition. He wore a wire when the police wanted to investigate Lee Anthony, and he allowed them to bug his phone. He did everything that law enforcement asked. And on this day, Casey runs out of gas, and Tony picks her up. They get the gas cans, and they go to the car. It's in her family's neighborhood. Well, they pour the gas, and after they're done with one of the cans, Casey opens the trunk and puts the cans in the trunk. 4 days would be obvious, significant human decomposition in the trunk, in the heated trunk of a car. And that car would reek tremendously. But yet Tony Lazzaro doesn't smell a thing. And Casey doesn't go and handle the gas cans on her own. If she had a dead body in the trunk of the car, she wouldn't be calling the people to come out and come smell this car. So she opens the trunk, he smells nothing, and she puts the cans in the trunk. If she had a dead body in the trunk, she would have put it in the front of the seat, in the front seat. Wouldn't be opening up so that he could smell. And he doesn't smell a thing. But of course, by the time the cops question him, they don't like that. Are you sure you didn't smell anything? No. Well, maybe you were distracted by the fumes of the gasoline. And that's their explanation. That's their explanation. But the fact of the matter is, he doesn't smell a thing. And this is 4 days after, when he had complete access to that car and was right next to it, didn't smell a thing. On the 24th is when George files that famous police report. And he alleges this fight happens. Even though he doesn't tell anybody until 2 weeks after he reports Kaylee missing. He doesn't say he smells anything in the trunk, if you believe that argument ever happened to begin with. On the 27th, Casey is throwing out garbage. This is a picture of Tony Lazzaro's apartment complex. If you can see in the very front of it, there's a dumpster. People who live at this apartment complex must carry their trash to the front of the complex. Casey was staying there and she threw out the garbage. She threw the garbage in the trunk of her car. And like many of us forget sandwiches and leftovers and doggy bags, she forgot to throw out the trash. This is the same day she actually runs out of gas. That's where the smell comes from. This is the garbage from the trunk of the car. It's wet, sticky. And what do the police do when they're done with it? They take it into an air room and they dry it out. So it can't, and you will see, once it dries out, the smell goes away. And there's absolutely nothing that can be done to independently test or verify anything from this garbage. It's destroyed evidence. It's intentionally aired out. But this was in the trunk of the car for close to almost 3 weeks. The car is towed on the 30th. The tow truck driver doesn't smell anything. The tow yard company has to wait 4 days before they send out a notice. Your car is here. We have your car. Come get it if you want it. That would have been the 4th or the 5th of July. The Anthony family should have gotten that notice around the 7th or the 8th. Well, they don't go pick up the car until the 15th. George doesn't pick up the car until the 15th. Why? Why wait a week? They will tell you they didn't see the notice. But yet that car sat there for almost a week after they had notice. Again, answers, questions we will never be able to answer for you. So Mr. Anthony goes and picks up the car. And one of the very first things he does is he starts telling anyone that will listen, my granddaughter's missing. She's been missing. I haven't seen her for 30 days. I found my daughter, but I haven't found my granddaughter. And then he walks up to this car and asks for a witness to open the trunk. And as Ms. Strange-Burdick said, he'll come up here and say, oh, please don't let this be my Kaylee. And he will say, like he told detectives on numerous occasions, that he smelled a dead body in the trunk of that car. And it's a smell you never forget. Once you smell it, you never forget it. Of course, he's never, nor has anyone else in this case, had trash in the trunk of a car for 3 weeks in the Florida hot sun, so we don't know how to compare it to. But he is certain that what he smelled was a dead body. And what does he do? He doesn't pick up the phone and call Casey. Are you okay? Honey, are you okay? Where's Kaylee? Is she okay? He's a detective, an ex-police detective. He knows he's smelling a dead body, and this is a possible crime scene. And what does he do? He gets in the car and wants to drive it home. And then he goes to work, making 0 attempts after not seeing his granddaughter for 30 days. And all of these, day 1, day 2, day 3, day 4, suspicious activities that Ms. Strange-Burdick told you about, doesn't do a thing. He wants to distance himself. Stay away. Have nothing to do with this. What's interesting to you, that you should also note, ladies and gentlemen, is he also had access to this car. He shows up to pick up the car with none other than the gas cans. How'd he know that car was out of gas? He's going to tell you he hadn't spoken to Casey in over 2 or 3 weeks, and that they found out through the notice that the car was there. How'd he know to show up with gas cans? Well, he's going to tell you it was a lucky guess. Why doesn't he call the police? Why doesn't he call Casey to find out if she's all right? Or Kaylee to find out if Kaylee's all right? He doesn't do any of that because he knows. He knows exactly what happened and how it happened and when it happened. Questions that nothing the state will present to you will be able to answer. But he knows all the answers and doesn't say a word. Now, one of the interesting things that will happen is you'll hear that Cindy went to work too. Cindy did call.
Welcome back to LawNewz Network. I'm your host, Jesse Weber. You were watching a little bit of the opening statements of Jose Baez in the Casey Anthony trial. I'm here with criminal defense attorney, I was going to call you Jose Baez, excuse me, Adam Sostrin, to talk a little bit about that opening argument, specifically where he's talking about going after George Anthony, talking a little bit about the smell in the car, the trunk. I want to talk a little bit about going after George Anthony here. Now, the theory that was posited by the defense was that it was George Anthony who was involved in the cover-up of Caylee Anthony's death, that she had died from an accidental drowning, and that he is at fault here because also they came up with a theory that Casey Anthony was sexually abused by George Anthony in the past. Now, again, we talked about risky strategies. That is a risky strategy. I'm curious what you thought of that move going in this trial.
Well, I think the idea, perhaps, of talking about the sexual abuse was the idea that family's really good at keeping things under wraps. So this would be just another one of those things, right? Not just the sexual abuse, but covering up for the accidental death of her daughter. So it's a little strange, right? And I remember that when it was happening at the time of the trial, to sort of call out your dad like that. I mean, and I guess as you should if something like that occurs, but also he's a key witness to your defense. You want him in a way to establish, what happened with respect. Although, why would he do those things? He'd be risking some kind of a criminal liability, and of course that didn't really happen with his testimony. But sort of, you need him as a witness, but at the same time, you are coming down on with respect to his credibility.
Yeah, I thought it was a stretch to say that even if this is true, I have absolutely no idea if this was true or not, the allegations that were put forth that he somehow had an inappropriate relationship with his daughter. Even if you accept that as true, that this is a girl who spent her life hiding the truth and hiding her emotions and hiding what was going on, and that she was able to live a normal life. And that is why in 31 days she was able to live her life when Caylee was dead, just live her life. I would find that to be a stretch, but maybe for other people it's not a stretch. Then again, it's something seemed to have worked for their favor because she was acquitted. But again, the idea that even if this happened, even if she was a victim of sexual abuse, that explains her conduct now, it doesn't quite add up.
Well, the idea being that she's sort of a peculiar person because she comes from a peculiar family. And, how else would it occur that a month goes by before, she doesn't bother to report and all that period. So, in a way, it kind of works, and it worked in this case. Yeah.
Let's talk a little bit about that scent that was picked up by the dog in the trunk, the scent of human decomposition. There was a lot of back and forth about whether there was an actual scent, what was really in the trunk, that whole discussion. The idea that there was a scent of human decomposition, the fact that that evidence was put forth, that wasn't enough to find her guilty. I'm curious what your thoughts are on that particular piece of evidence, which I would say in maybe other trials might have been enough to secure conviction.
Right. Well, didn't they discover like 5 of the 400 elements that would sort of be around in the case of human decomposition, and that's sort of what the defense went at? I mean, it's a really interesting technical issue, but of course that has to be something that goes towards her guilt. If you're covering up the death, why are you letting the body just sort of lay waste in her car? It doesn't make any sense.
Yeah, and when you add it up to there was no, I believe there was no DNA evidence from Caylee or Casey on what could have been potential duct tape, and there wasn't enough other forensic evidence. Maybe that in conjunction with the fact that you couldn't 100% identify there was human decomposition in the trunk it probably added to why it was. But the very idea that a dog, a cadaver dog, was able to discover this, I would imagine in other cases it would have been enough to secure a conviction. I want to move a little bit on. Yeah, oh, I'm sorry. Please continue.
No, I think so. I feel like jurors just look for that, that one tiny thing to hang their hat on. You never know what's going to happen with the jury, but I think it was a really helpful, set of facts for the prosecution. But the fact that the defense was able to chip away at it, that was impressive.
Yeah. What did you think of the prosecution's strategy? Where do you think they ultimately failed? Obviously, they presented their case. They might have had issues in terms of the evidence, but we just talked a minute ago about how the defense really came up with a theory without really corroborative evidence and was able to secure a not guilty verdict. Where do you think the prosecution's failures lie?
Because I think that the motive, they really weren't able to establish that. Not that they need to come up with something that they have to, put in front of the jury, but the fact that, this is just sort of a girl who wants to have a good time and she doesn't want to deal with her daughter anymore. I don't think that was good enough.
You're saying there needed to be more, that idea, that theory, that this is a girl who's just sick of the responsibilities of motherhood, that's not compelling enough.
It's not compelling, especially anyone who has a child. That alone, it just doesn't seem like it's enough. So I think, let's say perhaps it had a really good motive, something that was really something that was explainable. They could have gotten there, but all they were able to do was, this girl wants to have a good time. Daughter gets in the way. It's time to kill the daughter. So I don't. They just couldn't get there where they had. That was not the fault of the prosecution. I think this was, in a way, it was a tough case for them. It's always a tough case when you don't have the verdicts. But in that, when that, you need a really good motive.
Mm-hmm, mm-hmm. I wonder, now, I didn't follow the cases so closely as other people, but it was my understanding and my recollection that the prosecution never put any evidence forward about Casey's past in terms of sexual abuse. So I could be wrong, but the idea that if you wanted to go that route and say, look, this is a girl who's had a terrible history, she really was sexually abused. She really did suffer from all these issues. And this is a girl who was troubled. Her notions of right and wrong were altered. And she was not a person that should have been a mother. And if you went that route, I wonder if that would have been something that would have changed the dynamics of the trial.
Like something of a more sociopathic route that would explain her conduct. If they could get to that, based on, witness statements of other witnesses with respect to sort of her psychology, but even if that were to be admissible in court, I mean that's a big question too. This is a bizarre person. Yes, it's a bizarre person. I think that the court would allow any of that kind of testimony. I think they were sort of stuck with what they had, and of course they didn't have. I don't think that they had the information right at the get about the sexual abuse that might have been established by the defense. I don't know what happened pre-trial.
Right. Right, and my question is going to be later on when we interview Cheney Mason, Casey Anthony's defense attorney. The question becomes that if this is true, if we accept the fact that George Anthony was a conspirator, if you want to use that word, in the cover-up of Kaylee's death, why wasn't he charged with anything? Why, if the jurors, after the trial, think about their verdict, think about what they did, if they think of the idea that, well, the George Anthony was never charged with anything, and if that wasn't true, if that was true, and the investigators, learned about those facts in the case, how come he wasn't charged with anything and maybe, was offered some sort of deal to testify against his daughter or something like that? I'm curious your thoughts on that idea, that if he really was guilty of something, why is it the first time we're hearing it is in the defense's strategy and the defense's arguments?
Absolutely. I think sort of jurors, they always, unfortunately for the defense, but not in this case. They kind of go with what the cops decided to do. If the cops decide, if it seemed clear to them, although they're not supposed to look at things outside the record, but they're humans and then we do. If the cops are making an arrest, well then, what good really is the evidence of his involvement? I agree. But maybe in this case, let's say they did the job. They didn't go sort of outside the scope, and then they said to themselves, well, okay, we're not even supposed to get there. Is it probable? Well, there's a pool. She'd like to go in the pool. There's a lot of accidental drownings in Florida. I guess it's possible for them to get there, and I guess it's possible for them not to the police to make a mistake. I feel like I'm flamming here, but I think that's the nature of the Casey Anthony case.
Mm-hmm. Right. Good point. Well, I'm here with Adam Sostrom. We're analyzing the Casey Anthony case. Yesterday marked 6 years since the verdict was released, was rendered in that case. We're discussing the case here. Later on, we have Cheney Mason, Casey Anthony's defense attorney, coming on. But I'd like to turn right back now. Again, we're going to continue our coverage of the defense's opening statements. And Adam and I will continue our coverage of this and talk a little bit about more of the defense's strategy. So let's continue on with CA3, the final part of Jose Baez's opening statements in the 2011 Casey Anthony trial.
Well, Casey did send her a text, major problems, and we don't know when Cindy Anthony found out what happened, or if she does to today. But there's one thing for certain too, she went back to work, and people were already asking questions about this car, because she had to leave work to go get the car. And just like the pregnancy, they were asking questions. And they said, Cindy, you need to call the police. And Cindy says, no, I'll call Casey later. I'll deal with it later. So what does she do? She goes back to her desk and starts to work. It's not until one of the co-workers get the supervisor and make Cindy go home that she has to now confront reality. Just like the pregnancy, you're faced with reality. You heard what Ms. Drain Burdick said about Casey. She's walking down Universal Studios. Oh, come here. This is my office over here. Let me walk down this way. And then faces reality. Well, this is the way she was raised. And think about that for a second. She takes law enforcement down this path, down to an office that doesn't exist. This is how this family lives. This is how Casey learned to deal with her problems. And now Cindy has to deal with this problem. So Cindy calls and finds Amy Heisinger and confronts Casey. Casey doesn't know what to say. So you hear her blame the babysitter that doesn't exist, that everybody knows doesn't exist. Or do they? And one of the most important and telling things that you're going to hear when you hear these 911 tapes is not what you hear, it's what you don't hear. There's going to be a time where Cindy, who is hysterical on that 911 tape, she will turn and say, George, Casey says Zanny took the baby a month ago. And you hear dead silence. I want you to listen to that. When you hear that 911 tape, and you hear Cindy Anthony hysterical, and when she turns to George and says, the baby's missing, he doesn't say a word. He doesn't say, what? What do you mean she's missing? Who has her? Let's go get her. Nothing. Doesn't say a word. And that's because he knows where she's at. He knows what happened. This is no surprise, but he will distance himself from it. And in fact, in one sworn statement, he says he wasn't even there when Cindy called 911. Keeps wanting to say, I was at work. I was at work. I don't have any part of this. I'm just George, just your average grandfather. Casey's the wild one. Casey's the one with all the stories. He's saying this while he's with his mistress who's paying him money and he's pretending he's working. And that you're going to hear. Crystal Holloway gave him money so he could pretend he was working. Cindy thought he was working. But you're only here about Casey's fake job, not about George's fake job. You can get the dry erase. I want to touch briefly, and I'm just about to wrap it up, on some of the forensics that you'll hear throughout this case. You're going to hear about the car evidence and a possible hair, one hair. But what Ms. Drain-Burdick didn't tell you is the FBI lab analyst was telling everyone, and she'll probably come and tell you too, that she can't say for certain that that hair came from a dead body. In fact, she sent out a request asking to find more hairs. And they did. We hired Dr. Henry Lee, one of the world's greatest forensic scientists, to go in and search that car. And he found 17 different hairs, 17 more hairs. And before you start wondering, what is Kaylee's hair doing in there, in the trunk of the car? Well, Casey's hair, other people's hair was in the trunk of the car. We often shed hairs very easily. None of them, absolutely none of the other hairs, I think there was a total of 27 that ended up being inspected, had what they call the banding, the discoloration. This was a problem for them. So when we went and took the depositions of the analyst, they got a bright idea. They decided to conduct a study. After we took their deposition, they realized that they had something that was not validated, so they did a study of live hairs in trunks, in water, it's exposed to all different elements, and they found they had a couple of what's called blind examinations that showed that there were some characteristics shown from live hairs. This is very questionable. And you will hear that it is rarely, if ever, done on one single hair, this type of analysis, because you need more. You need to be able to be certain. And this hair means nothing. You'll hear about, again with the hair, with the car, this dog. Well, this dog is retired. No longer works for the police department. But what Ms. Drain-Burdick didn't tell you, she told you about the backyard, how they came out, the dog alerted, and how they dug there. But she didn't tell you they came back the next day, and the dog didn't alert. There are things called false positives, handler bias that you're going to hear about. And it's interesting that the dog, at the very same exact spot, wouldn't alert the next day. You'll hear that when this dog went around the car, he broke every rule in the book. He didn't do a proper lineup. There should be multiple vehicles. The police officer should not know which is the suspect vehicle, so that gives you credibility. It lets you know that this is real. This isn't the dog the handler queuing off to the dog, because the dog wants to please its master. These are called tools. And that's what the dogs are. They're just simple tools. There's a confirmatory test that must be done. And the dog, he knew exactly which car it was. And you'll hear conflicting testimony with whether it was one car or two cars. He's the only one that says he searched 2 cars, that they were side by side, while the other detectives and the CSI people will tell you it was just 1 car. And the most telling part about this dog is they took this dog out to Suburban Drive after they had finished sifting and collecting all of Kaylee's remains. There were still several bones missing. And you will hear that, knowing that there were remains at this location, the dog never alerted. The reliability of this dog is questionable. I'd like to question the dog, but I can't. I'd like for you to hear it straight from the dog's mouth, but that's not possible. None of that's going to be possible. And the reason is that a dog should not be testifying in a trial. And let's not test it out in a death penalty trial either. This air sample, as Mr. Greenberg told you about Dr. Arpad Voss, a very interesting man. Again, throughout the United States, this evidence has never been admitted in a court of law. And this is an experiment that he conducted, nothing more. An experiment in which you will see flaw after flaw after flaw. It's never been validated. It's never been independently tested. And he can't find a single person in the entire world that would agree with his theories. That's going to be long, drawn out, and boring. But the fact of the matter is that they're getting desperate. Air samples. Pure desperation. You'll hear that this scientist is somewhat of an inventor. In fact, what he's doing is he's invented a sniffer machine. It looks like a metal detector, so that he can sell it to law enforcement agencies across the country. And what he's using to determine the chemical composition of human decomposition is this database. Well, it's now being validated in this courtroom. And he holds a patent to that machine. And he stands to make millions, and has an inherent bias by his testimony. You'll also hear that he has some other great ideas, like putting electronic leashes on flies to find dead bodies. And he also claims to be able to find hidden graves with a coat hanger. He's an interesting individual, and you'll get to hear plenty of his testimony, and it will be highly debated. Now, this is the evidence that Mr. Aimberdick talked to you about. Let me get this. But I'm going to tell you some of the things she forgot to tell you about. Remember what I told you, they spared no expense on trying to investigate Casey. Well, Mr. Aimberdick didn't tell you that they searched all of her clothing. They did a search warrant on the home. And they took every piece of clothing that Casey had in her closet, and they searched and they did the blue light to see if there was any blood or any suspicious stains. All came back negative. They took all her shoes, every pair of shoes that she owned, and they tested them for soil samples to see if they matched Suburban Drive. Negative. They took textile fibers. Sorry if you can't. I know my handwriting's getting pretty bad there. They took textile fibers that they found off Suburban Drive. They compared it to her car and to their home. No match. They checked the duct tape The duct tape had no fingerprints. They ran every kind of fingerprinting exam you can. No fingerprints on the duct tape. One of the easiest ways of being able to lift fingerprints is off of duct tape. Yes, the duct tape was deteriorated to a certain extent, but they still tried at the FBI. They also searched the duct tape for DNA. No DNA of either Casey or Kaylee. But yet they want you to believe that she had duct tape wrapped around her mouth and was decomposing, completely decomposed, and not a shred of DNA on there. Misspeak. There was DNA on there. DNA from an FBI analyst. They contaminated the duct tape. DNA is so sensitive, so easily attachable, that an analyst in the documents department contaminated the duct tape. And there's also another profile on there who they don't know, partial profile, someone they don't know. But it's only at what's called one marker. So it's impossible to find who that DNA belongs to. But it is not impossible to exclude both Casey and Kaylee. They're completely excluded. There's usually what we call 13 different markers where they test DNA. And unfortunately, this is one, only one. Could be contamination or could not be. But there's one thing for certain. There's no forensic evidence that ties Casey to this. Again, she's too stupid to, she's dumb enough to leave the body off the side of the road, but yet smart enough to leave zero forensic evidence. Something's not right here. Something doesn't make sense. Well, they tested more hairs that they found. They did all kinds of tests. They all came back negative. Negative, negative, negative. The only thing that they are trying so desperately to tie Kaylee to is the car. But one, if we get back to its basics, if we get back to the very basics here, that is, how did Kaylee die? How did Kaylee die? The car doesn't shed any light on that. At best, it tells you she was transported. But you'll hear some testimony about a lie that George Anthony told, that Casey was driving her mother's car on one occasion, and that George chased her down the 408, which is a highway here. And they asked him for the toll records. They said, you should have the receipts. He said, oh yeah, I'll get them for you. We didn't get them. The investigators had to go get them. And they found out he lied. But he didn't get arrested for lying to law enforcement. At the end of this case, when you go back home and you're back in Clearwater and you're sitting around the dinner table and someone says to you, why did you find Casey Anthony not guilty? You're going to say, well, I was fed a wealth of information, like a V. All this information came, but it all boiled down to one thing. They couldn't tell me how she died. They couldn't prove this was a murder. They couldn't prove this was a manslaughter case. There was no evidence of any child abuse. And that's why we voted not guilty. You're going to see throughout the entirety of this case getting desperate here with this marker, that we use a color. I'll do it down here, it's probably better. The prosecution, can we lift this up? The prosecution in a murder case is supposed to prove their case beyond and to the exclusion of every reasonable doubt. Not a forced doubt or speculative one, every reasonable doubt. They've got to present to you a case A to Z to prove their case. Well, if the A is George Anthony and saying that he was the last person that saw Kaylee, you really can't trust that now, can you? In fact, if you remember the indictment, it says from June 15th, not the 16th. Makes you wonder if they even believe him. If you can't trust George Anthony, and they don't know how she died, because the medical examiner will testify that her death was a homicide, but by undetermined means. They don't know how she died, but they're going to tell you it's a murder or at the hands of another. So if you don't have this, you don't have A, and Mr. Kronk represents Z, you don't even have that. You all swore to uphold the law, to hold the state to its burden. There's evidence here, a reasonable doubt to show you how Kaylee really died. Why did we end up in this bizarre situation? We'll never be able to answer all those questions. And partially because it was never looked into. But the fact remains, this is not a murder case. And this is certainly not a manslaughter case. And there's definitely no evidence of any child abuse. When you've heard all the evidence, we're going to ask you to render a verdict of not guilty. All this aside, as important as some people think this case is, it's not nowhere near as important as it is to Casey. They didn't know her. They didn't love her the way Casey did. They didn't breastfeed Kaylee every 2 hours when she was born. They didn't wake up every 3 hours to feed her. They weren't there when she first walked. They weren't there to take care of her. Casey was. And you can never bring Kaylee back for Casey. But you can help end this nightmare by sending her home. I'll ask you all, individually and collectively, to render a verdict of not guilty. Thank you.
Take those things down, please.
Welcome back to the LawNewz Network. I'm your host, Jesse Weber. You're watching the final moments, the final statements of Jose Baez in his opening statements in the 2011 Casey Anthony trial. I'm here with Adam Sostrin helping to analyze a little bit of this case. Yesterday was the July 5th, was the 6-year anniversary of the verdict in that case, and Casey Anthony was found not guilty of first-degree murder or manslaughter or child abuse, but she was found guilty of 4 counts of falsifying information to the police. Now, Adam, we were looking at that closing argument. I thought the closing of the opening argument. I thought it was very strong, and he said, Jose Baez said, look, said to the jurors, at the end of the day, when you render a verdict not guilty and you're asked why, you're going to say you did it because there was just not enough evidence of a murder or a manslaughter or child abuse or anything of that nature. And in the end of the day, that was a very strong way to close it because that's what they found.
It was was excellent. It was sort of, and you were about to say closing argument. It definitely seemed like a closing argument. You know, one of the things you're supposed to do before you go to trial is you're supposed to know your closing argument. And I mean, gosh, he really did his homework with respect to everything, every nuance. You know, he predicted what was going to happen by the end of the case. You know, came up with all the theories and all the reasons why you couldn't find for guilt for Casey Anthony, and yeah, he did an excellent job in that closing of the opening statement.
Mm-hmm. You know, I think it was Judge Perry in this case who actually said afterwards that he was very likable. Jose Baez was very likable to the jury, and if you want to know who you should believe, you believe, I think he compared him almost to a very good car salesman. This is a guy that you like, this is a guy who's believable, and at the end of the day, relating to jurors is what it's about, am I right?
Oh, absolutely. The fact that he's able to talk to them in their language, spell everything out, you know, make clear sort of what they're going to have to, how they're going to view, what lens they're going to use when they view the evidence as they listen to it. He was clear, yeah, you know, lucid. He couldn't have done a better job as far as explaining and, you know, asking for not guilty at the end of his closing. At the end of the opening statement is what we all do. But it was really excellent, you know, pointing out all the flaws in a way that was sort of conversational, that was friendly. It wasn't, you know, it wasn't overly, you know, coming down on the jurors because you're upset with the prosecution. It was just having a frank discussion, and I think he did come across as very credible.
There's been talk out there that the verdict that was rendered was not a failure on the part of the prosecution or a win for the defense, but it was, for lack of a better word, the fault of the jury. And maybe it was the makeup, who knows? It was, I think, 7 women, 5 men coming from all different walks of life. Many of them had children. They were all not opposed to the death penalty. They said they would do it if they felt the circumstances were correct. I'm curious that, you know, that argument that if there was another jury in place, would we have seen a different verdict? Obviously, there's no way to tell. But the idea that it was the jury's fault for people who find that Casey Anthony is guilty and should have been found guilty, what do you think about that? How would you answer them?
I suppose there's other cases that you'd really want to blame the jury for, but I can't blame the jury for this with respect to the type of evidence that came out, sort of the lack thereof of the forensics they need, the lack thereof what they need for a motive, the lack of a sort of a timeline. You know, it would be pretty hard, I think, and maybe that's just because Jose Baez did such a great, you know, the defense team did such a great job. It would be hard for me to come back with a not guilty verdict, but juries are a funny thing, right? Where you think the appropriate verdict is not guilty, they find your client guilty. Where the appropriate verdict might be guilty, they find your client not, you know, just vice versa. It really depends. But if I were sitting on that jury, if I were listening to the evidence, I think I might come back with a not guilty. And so I can't blame the jury for what they did here.
And let's not forget, they're secluded from all forms of media contact. They didn't have they had absolutely no idea about the circus that was going on surrounding this trial and how Casey Anthony was deemed the most hated woman in America while this trial was going on. And you would have to imagine that that could affect anyone's opinion or their chances of rendering a guilty or not guilty verdict. All they saw was that the evidence was presented to them. They were in a bubble. So it's difficult to say, you know, playing Monday night quarterback, what should have been done, what should have been rendered. I mean, when you're in that situation, who knows what you're thinking about and what the deliberations are. I mean, they deliberated for what, 10 hours and 40 minutes? They considered the evidence. That's a good, you would say that's a good enough time to deliberate. It wasn't like they came back with a verdict in an hour. They really deliberated on that, no?
Oh, absolutely. They took their time with it. That was plenty of time and then some. You know, it could be deemed to be a thoughtful deliberation if they did it in 8 hours, if they did it in 6 hours. So I think clearly the jurors gave the evidence, the weight they felt that it was due, and they made the decision that they thought was best. I think just sort of based on, of course, we're in the public, we're watching it from the angle of the news, but if you just listen to the evidence that came out, I think it was probably an appropriate verdict, although it is a sort of a sad case because it does, to a lot of people, seem as if Casey were in part responsible for what happened, but this is how it works. Proof beyond a reasonable doubt. The state has to meet its burden, and that's the way we want to keep it.
Right. Well, I have another question for you before we turn to our next clip of when George Anthony took the stand. Casey Anthony didn't testify. You don't have to testify if you're a defendant, and just because you don't testify, that can't be used against you in the verdict that you render for the jury. This is used in the jury instructions. I am curious, in these kind of cases where a parent is charged with the murder of their child, it's not uncommon to see the parent not take the stand. I'm curious, did you think that, was there a specific reason that she was not put on to testify? Is it that maybe she would have come off unlikable? Is it that she might have given something away? Is it something that might have hurt their case? In the end, she didn't testify and the defense was able to secure a non-guilty verdict, but I'm curious about what you think of her not testifying.
Well, I think it was all of the above. I think she probably would have come across as being likable. She would have given something away. She would not have been helpful to the defense's case and all the false statements that she made. And you can only imagine the cross-examination that would happen with respect to all the pretend things she said occurred during that 30-day period in which her daughter was missing. So that's the right decision. We always wonder, or the jurors always wonder, why the defendant doesn't take the stand, especially if it's your kid. But I think it was, of course, this is Monday morning quarterbacking. This seemed to be the appropriate call here.
Yeah, but then again, the way it works is the defense came up with the theory that this is a woman who did lie. She was used to lying. She had to cover up many things that were happening in her past. And just because she was lying about a cover-up to cover up what happened to her daughter, but didn't mean she caused the death of her daughter. So, the idea that this is, I don't know how surprised they were when she was found guilty of falsifying information, because that's the very theory they put forward. This is a woman who's lied. She had to lie to save herself. And so the idea that they didn't, put her on the stand because she would have been caught in her own lies, that's their own doing. Am I right?
Well, yes, in a way, but I can't imagine that, if she were to take the stand, after she, puts her hand up and testifies under penalty of perjury, then she has no trouble lying to the juror. And you would only wonder how she would explain, the last time she saw her daughter, and her explanations as to that. I think she probably could have opened up a few too many doors. I understand the defense created this issue, but there would have been too much room for the prosecutor to get a good cross-examination of Casey.
Right. Yeah, you make a very solid point, and I think that's probably why that happened. Let's turn right now to another clip. We're going to go to CA4A. This is when George Anthony was called to testify on behalf of the state. And again, it was the defense's theory that George Anthony helped cover up the death of Kaylee as a result of an accidental drowning. And as you said, Adam, when you have a witness on the stand, they're prone to cross-examination, and that was very interesting in this case, especially with this witness. But let's start off with how he began his testimony. So let's turn to CA4A. Adam, I don't know if we're going to have time to analyze because we are bringing in the Cheney Mason, who was Casey Anthony's defense attorney. But again, thank you so much for your time today and analyzing this case, and we really appreciate you taking the time to talk about it here on the LawNewz Network.
Thanks for having me. It's always a pleasure to be on with you guys.
Great, thank you. So yes, we are going to turn now to CA4A, and we'll talk a little bit about it after. Thank you.
Thank you. Would you just please start by stating your name for the record?
George A. Anthony.
Mr. Anthony, are you the father of Casey Anthony, the defendant in this case?
Yes.
And are you the grandfather of Kaylee Anthony, the victim in this case?
Yes.
Would you please tell us, first of all, where are you from originally?
Originally from the Warren, Ohio area, which is the northeast section of Ohio.
And is that where you grew up?
Yes.
Now, earlier in your career, were you employed as a law enforcement officer?
Yes, I was.
About what age did you begin your career in law enforcement?
Right about 23, and I left right about the age of 32.
During your time as a law enforcement officer, did you meet a young lady by the name of Cindy?
Yes, I did.
Where did you meet Cindy?
I met Cindy at a local hospital where my sister was being attended to.
And was she employed there?
Yes.
And how was she employed?
She was a pediatric nurse.
Did you come to develop a relationship with Cindy and eventually marry?
Yes.
And when did you marry?
In 1981.
And where did that occur?
Also in Warren, Ohio.
Now, at the time that you met Cindy, were you working as a law enforcement officer then?
Yes, sir, I was.
And in what capacity were you working when you two first met and began to see each other?
I was working as an undercover drug agent with the Sheriff's Department, where I was employed.
In your time with the Sheriff's Office, could you just describe for us what different positions you held or responsibilities you had?
Well, I had a brief stint as considered an auxiliary officer. I was immediately asked to become a full-time officer, which I did. I was in 2 years road patrol. I advanced pretty quickly to become a detective, and I was working at different times in auto theft. I mean, it was a lot of different things, and homicide. I did a lot of different varied things as a detective.
How big an agency was the Sheriff's Department? Well, is it Warren, Ohio Sheriff's Department, or?
It's called the Trumbull County Sheriff's Department.
Trumbull County Sheriff's Department. How big a Sheriff's Department is that?
At the time that I was employed there, we had a road patrol, or at least a full-size staff of about 110, maybe 112 sheriff deputies.
And how about the detective divisions? How many detectives did you all have?
Somewhere in the neighborhood about 10 to 12. It wasn't a real large agency, but I would say roughly about that.
So during your period as a detective, did you investigate a number of different kinds of crimes?
Right. I originally started out with, as far as, like it says, the auto theft and also like break-ins and things like that. But from time to time, you would be brought into other realms of investigation.
And occasionally even homicide cases, I think you just said.
That could happen from time to time, yes, depending on what was needed and the number of staff that had to be utilized.
Now, during your marriage, were you blessed with children?
Yes, fortunate enough to have 2 children with Cindy.
Okay. And the oldest, could you tell us the name and gender of that child?
My oldest is my son, Lee. He is going to be 29 years old this year.
And what year was he born?
In 1982.
And how about your daughter?
Casey, which she's a female. She was born in 1986, and so now she's 25.
Now, did there come a time during the time you lived in Ohio when you got out of law enforcement and got into another line of work?
I got out of law enforcement for 2 reasons. My father had asked me to come back into a family-established car business. And after numerous incidents that occurred within the Sheriff's Department through being hurt on the job, different other things made me change my mind to get out of law enforcement and go back into a family business. That I know, number one, would be more stable. I would be able to provide more for my family. Now,
were you still working as a law enforcement officer when Casey was born, or did that happen during your second career?
Let me see. Casey was born after I had left the Sheriff's Department.
And you said you went into a family business. What type of family business was that?
My father started a automobile agency back in 1947, so he had been in the business for numerous years.
Did there come a point in time when, so you did go to work for your father then?
Yes.
Did there come a point in time when your father left the business or you left his business?
Oh, my father was sort of in like a semi-retirement when I joined him in 1984, and shortly thereafter, we had some incidents that occurred between him and I. We decided to part ways, and I believe that was in 1987. I'm roughly thinking about that was probably the time.
And did you decide to basically go out on your own in that same type of business?
Right. I started to start my own automobile agency, a small used car dealership, and provide for my family, yes.
Now, when Casey was born, were you still working for your dad, or were you on your own at that point?
Casey had just been born, and it was like about a year after Casey had been born that I went out on my own, or I started another business.
Now, at some point, did you and your wife decide to leave Ohio, where you had grown and lived, and move to Florida?
Yes, we decided for a lot of reasons. Number one, my parents had retired here in Florida. Cindy's parents also had retired in Florida. And through my job, or not job, but the company that I had established was suffering financially. Just a lot of different reasons came into play for us to decide, well, the children were young enough. Why not go to Florida? I mean, that's somewhere where both sets of grandparents were at. Fresh start. Give us just another opportunity to start over.
Now, during your, pardon me, during your marriage, through the birth of your children, did your wife Cindy continue to work?
Cindy she started working part-time when Lee was first born, to provide for him and be there for him. And she started working full-time, and I know she took some time off a little bit when Casey was born. And she still worked. I can't remember the exact many of hours she had been working during the week, something like that, but it wasn't a lot. She took time to help raise our children.
Now, about what were the ages of your children when you all moved to Florida?
Lee was just shy of being 7 years old, and Casey was just 3 years old.
When you got here to Florida, did Cindy go to work in her profession?
Pretty much immediately. She was hired by a orthopedic clinic in Winter Park, and it took me about 3 months before I was employed.
Had you considered going into law enforcement when you got to Florida?
I did go down to the Orlando Police Department and look into being hired by them, and because of having a law enforcement background, I thought it would be an easier chance for me to get reestablished and start having pretty much established an income right away.
And did you decide not to pursue that?
Right after thinking about some of the drawbacks of law enforcement and how telling it can be and hard, it's a very hard line of work to adhere to every single day. It's very demanding.
All right. And was your wife part of that decision-making process?
All right.
Going back in?
I apologize. Yes, she didn't want me to go back in law enforcement because she's seen what could potentially happen. I mean, you could be going to work one day and not come home the next. It's a very tough position, very profession.
At some point, did you get into the private security field?
Yes, I was hired by the city of Orlando and started working at what was considered the Centralplex at the time, with the Orlando Arena, Bob Carr. What was that?
And in the years leading up to the events we're going to discuss, did you work in that field pretty consistently? Pretty consistently.
It's unfortunate that from time to time you lose a position or you have a chance to move on somewhere along, and you make some decisions to go into another line of work or get back into something that you know. And yes, I did some more security work, yes, over the years.
And did Cindy continue to work in her nursing profession?
Yes, Cindy has been very fortunate. She's only had 2 positions of employment since we've been here all these years.
Now, did there come a point in time when you learned that your daughter was pregnant?
Yes, I did. I think it was like May or June of 2005.
How did you learn that she was pregnant?
My daughter and my wife set me down in our living room and said they had something to tell me. And first hearing about it, extremely excited. Extremely excited to be a grandfather, to see my daughter be a mother, but also concerns about, how she's going to raise this child because she's a single mom. I never really thought too much about who the father could be. That was a discussion I wanted to have maybe a little bit later. I wanted my daughter first to be happy, to get through the pregnancy fine, to enjoy that special time of becoming a mother that I thought was very important.
Now, you kind of touched on this a little bit. At the time that you learned of the pregnancy, your daughter was not married at the time. As far as was she?
Yeah, Casey's never been married.
All At the time that you learned of the pregnancy, was she involved with someone where you would sort of assume that that person was the father?
Well, I really wasn't sure if Casey, I know Casey had dated at different times over the years, but I really wasn't sure about who she was maybe seeing on a more serious basis or anything like that. No, sir.
So, how did you and your wife begin to prepare for the arrival of a grandchild?
Oh, just doing everything we can to make Casey's life as easy as possible for our grandchild. Getting a chance to go to different times when she was going to be examined. Went through the ultrasound.
Did you go?
Oh, absolutely, I did. And when I got a chance to see that it was considered, I think it's called a pancake, I think it's the term, or something like that, of when you can see it's going to be a girl.
Okay.
Maybe that's not the proper terminology, but I was very excited. I mean, if having a grandson would have been terrific, but just knowing that she was going to be a mother and us be grandparents, it wouldn't have mattered. She could have had 3 or 4 children at once. It would have been fine with me. I just was excited.
At the time that you learned of the pregnancy, was Casey living under your roof?
Casey has always lived with us, yes.
Now, was she in school at that time? The time you learned of the pregnancy? Or had she already finished high school?
She already had finished high school.
To your knowledge, at that point, was she working?
She was working for a company called Color Vision, which is a subcontractor for Universal Studios.
Was it your understanding that that was one of those companies that take your picture when you walk in the front door and then offer to sell it to you
Yes.
later, that kind of thing?
Yes.
All right. So during your preparations for this, was there any question among the 3 of you as to where Casey and your grandchild would live after she was born?
No, I mean, we opened up. She's always lived at home, and we thought that would be not thought, but we knew that having Kaylee with us, or knowing that our grandchild could live with us until Casey got more established, better on her own, possibly job promotion or whatever it might be, she would stay with us until the time she felt that she wanted to leave.
Now, you mentioned home. Where was home?
Home is 4937 Hope Spring Drive, where we've lived since 1989.
Since when?
Since 1989.
89. And was that a house that you all purchased? Did you purchase it actually before you moved to Florida, or sort of early on?
Cindy had came down to Florida to see her parents, and when we decided we were going to be moving down here because of my work at the time and through other things, I couldn't get away. Cindy basically came down and looked the area over, found a realtor, found a home, and what they say, the rest is sort of history. That's the home we settled on.
And is this a home in which you raised your children and were intending to help raise Kaylee?
Oh, yes.
Could we show the witness State's Exhibit AN for identification? If you'll look at the screen for a moment. Do you recognize the photograph that we've identified as State's Exhibit AN for identification?
That is our home at Hope Spring Drive, 4937.
That's the one you described to us where your children were raised and
Yes.
where Kaylee was to be raised. This time, Your Honor, State would move into evidence State's Exhibit AN for identification.
What says the defense? There being no objections, it will be received in evidence as State's Exhibit numbered.
And may I publish, Your Honor?
You may publish.
Now, this, during the time that you were assisting with the pregnancy and waiting for your grandchild to come around, did Casey continue to work?
Casey worked up until I think it might have been about at least 2 or 3 weeks prior to Kaylee being born. I might be off maybe a week or so, but at least it's in that short time period.
Tell us about Kaylee's birth. Where were you when you found out? I'll try and help you with this. Where were you when you found out that it was time?
We were, Cindy, Casey, and I were all at home. And Casey had been starting to become a little bit ill, or she was showing signs of possible labor. I mean, she was throwing up. You know, she had some other small issues that made us think, okay, maybe this is something that's going on. It's something we need to look into and get her some assistance. So we took her up to the hospital, and I think in a few short hours, the doctor was called in, her pediatrician, and
You mean her obstetrician?
Obstetrician, I'm sorry. Oh,
That's okay.
Obstetrician, yes. And the lady helped her bring Kaylee into the world.
Were you actually there in the delivery room, or did you have to wait outside?
Oh, I was in the delivery room. I was in the delivery room for my own two children, but also being there for Kaylee, which was, to me, not only amazing, but also embarrassing to a point.
Sure.
And if I might say that there's sometimes in your life as a father, there's some things of your child you don't want to see again growing up. But you know something, it's just an experience that it's hard to put into words. It's just how elated you are and how happy you are to see your own child give birth to another child. It's just amazing.
And was the birth, Kaylee okay?
Kaylee was fine. I mean, there was a little complication here or there, but it wasn't anything that the doctor couldn't take care of, because the doctor was right there the whole time, and other nurses and things like that. So it was well taken care of.
Now, during the pregnancy, at some point, was the subject broached about who the father of Kaylee was or was thought to be?
I can't remember if we exactly talked about it prior to just Kaylee being born or right after, but I know then it was brought up because, yeah, I wanted to know, because I feel it takes two to make this child, and this father needs to be made aware of that he's going to be a father and who he could possibly be, and it'd be great to meet him and see what his obligation would be. And I felt whoever the fathers needs to have an obligation for the birth of this child.
Did you have an occasion then to meet the person that, at least at that point, was thought to be the father?
There was a name brought up that Casey believed could have been the father. All I remember is the last name was Baker, I believe, and that was about it. But if I can take another step forward,
sure.
Casey also had been seeing another gentleman who had been employed at Universal Studios by the name of Jesse, that I got to understand and get to know that he could have also been the father. So he was, one of two guys possibly.
Now, when did you first meet Jesse?
I met Jesse for the very first time on the day that Kaylee was born. That had been August 9th of 2005.
How did that go?
Not very well, truthfully. I was elated to be there to see my daughter, to see my granddaughter, but Jesse did not make the best first impression with me.
All right. Now, after Kaylee was born, did she and Casey return to your home?
Yes, I think it could have been the second day or maybe third day. I think it was the second day.
And did Jesse become, at least initially, part of sort of the family group with Kaylee as an infant?
Right. Jesse, we pretty much opened up our arms to him and welcomed him in and wanted to get to know him more. And just, if he was the father, I would just be happy to get a chance to know him and see what his dynamic was going to be as far as how he was going to take care of Kaylee and Casey, or at least help take care of them.
Did there come a point when it was learned through certain scientific testing that Jesse was in fact not the father of Kaylee?
Right. I'm not sure about how long after Kaylee had gotten home, Casey and Kaylee had gotten home, that Jesse went and got a paternity test done.
As Kaylee grew, what was your role in her upbringing in her life?
I'm just her grandfather. I probably acted sometimes maybe like as a father with her, because I was around her every day or nearly every single day. And to me, that was pretty awesome to have not only my daughter there, but also to have my granddaughter to be around. That's just, on a scale of 1 to 10, you have to give that probably a 20 or better, because it's double the excitement of
Now,
life.
What role did Cindy take in raising Kaylee?
Oh, just being a great grandmother. Helping any way she could, help babysit from time, or take care of Kaylee from time to time, same way as I did. I mean, Cindy did it more frequently than I did because of my work schedule, but to be a fantastic grandmother, help provide for Kaylee in any way that she could or I could.
As Kaylee began to grow and be able to speak, did she have names for you and Cindy and other members of the family?
Well, Kaylee started calling me JoJo, and I know how probably JoJo came about because my daughter Casey used to call me Papa Joe, and that happened to be through another friend of hers that we just became very close with over the years. But JoJo was just probably easy for Kaylee to say better than Grandpa, or grandfather or something.
So you were JoJo.
I was JoJo.
How about Cindy? How did Casey?
Cindy became Cece, or possibly Grammy sometimes, but mostly it was Cece.
Now, taking us now up into 2008, the winter, spring, early months of 2008. Tell us how Kaylee had developed. In other words, what could she do? How advanced was she physically, mentally, etc.?
Well, not only I'm just a bragging grandfather.
Sure.
But
we'll take it with a grain of salt.
But she was a very vocal child. I mean, she could put a lot of words together. She could. We have a remote on our TV. She learns how to do that. There was another little button she could push on the TV to get it to change channels, which I thought was amazing. She could turn on the VCR, put her own DVDs in. Oh my gosh, she knew to go inside of our pantry area and get the plastic jar of peanut butter. We had the small one, and go get herself a spoon, have her come over and ask you to open it up so she could have a spoonful of peanut butter. God, puzzles to go together, the way she'd bring crayons to you to color every day and make Play-Doh little things for herself. I mean, you name it, she could do it. And I knew from working with her, or from us doing things with her, she was a very bright child. You would sing a song with her once, she could sing it next time with you, which to me was just amazing.
So in terms of physical dexterity, she was able to open drawers.
Welcome back to LawNewz Network. I'm your host, Jesse Weber. Today we are recapping the Casey Anthony trial from 2011, and we are breaking out of that prior coverage of George Anthony's testimony in that trial because we have a very special guest with us right now, Cheney Mason, who represented Casey Anthony in that 2011 trial. Mr. Mason, thank you for joining us here on the LawNewz Network.
Oh, you're welcome. Good to see you.
Good to see you. So I'd like to start with the beginning, as yesterday was the six-year anniversary of the verdict in that case. Let's start from the very beginning. How did you even become involved in the Casey Anthony case? Because it's my understanding that your wife was actually hesitant about you joining the case in the first place.
Well, the short version of the story is that Mr. Baez, who was co-counsel, kept reaching out to me for some mentoring type advice, so call the old guy. And after a period of time, we met, and he came to the conclusion he wanted me to join the team. I told him I'd have to give that quite some thought because I was fully aware of the year plus of local media coverage and how negative it was about the case and Casey and him. And so, yeah, I had to talk to my wife. Would I dive into another one of these types of cases, which I've done before? And after we talked about it, I said, I really just have to. This girl is being treated very poorly by the press. She's been effectively tried, convicted, and all but sentenced by politicians and press and so forth. So no, not in my town. I'm going to agree to do it, and I did.
Mm-hmm. We'll talk about the media in a little bit, but I want to get back to Jose Baez. Jose Baez became infamous from that trial, and we actually covered his next trial, or one of his future trials, the Aaron Hernandez trial here on the LawNewz Network. I'm curious, what's it like working with him? What kind of attorney is he, and how did it go? You both had your probably different strategies going in, but what's it like working with the man?
Well, at the time, and it's the only case that I've worked with him on, I didn't know Mr. Baez other than the news media. Never heard of him. He's a young lawyer with, at that time, very limited actual experience. And but he was a nice young guy and very energetic and very enthusiastic about trying to build a defense and put in a lot of hours working. So he did his part and I did mine.
In general, is it difficult working as co-counsel in a case like this?
No. As a matter of fact, of course, the law is changing day to day, particularly here in Florida, but for a long, long time, for decades, the basic rule has been when you have a death penalty case, you got to have two lawyers. And one lawyer has to be experienced, what's known as death qualified, whatever that means, but experienced in having handled other cases. Mr. Baez was not, and I, of course, was. So we had different roles primarily to do, and my function was to bring my 45 plus years of experience at that time with trials and murder cases, you know, to everybody's attention and kind of override from time to time some ideas and strategies. And Jose worked on factual matters and some of the evidence details, and as did I. As you can't do it with one person effectively, in my opinion, not when a case is brought like this with the hundreds of potential witnesses. And well, you know how long it took to try the case. I mean, and it could have taken twice as long if the prosecutors had wanted it to. So it would not be possible for one person to do a proper job defending a death penalty case like that.
I'd imagine it'd be a nightmare for one attorney to handle alone. Let's delve into a little bit of the media coverage, which is, you mentioned before. When the Casey Anthony trial was occurring, she was deemed the most hated woman in America. Now, what's it like defending a woman where you know what's going on in the public, the jurors don't? When you know that's what she's being deemed, and you know that she's being ridiculed and already convicted in the minds of the public eye, what is it like defending someone like that in that kind of environment?
Well, in the first place, the jurors did know. I mean, that's why it took us the equivalent of 3 weeks to pick a jury, and there was no one in the whole multiple hundreds of prospective jurors in the pool that did not know about the case. You would have had to have been from Mars not to have known about the Casey Anthony case. And so the challenge was to deal with people and try to get a jury of folks that, even though they had been saturated with prejudicial news media, would still have the intellectual honesty and integrity to base a decision on the evidence and what happened in the courtroom, not somewhere else. So that's part of it. It was clear that Casey was not popular, and just as soon as the publicity was revealed for the news coverage that I was involved in it, well, it intensified, and there were lots of people calling and writing, and some actually physically threatening me for being a lawyer. And so we never really had a concern, at least I never did, about Casey being labeled the most hated woman in the world. I can certainly nominate a couple of others that would fit that bill. One of them's a news program person. So she's more hated than Casey is.
Mm-hmm. And to this day, do you still receive backlash?
I'm sorry?
To this day, do you still receive backlash over defending her?
Yeah, not nearly as much. It's pretty well subsided now 6 years later. And of course, with this anniversary and the attendance publicity about it, it may start up again. I don't know. But yeah, for a period of time, it was very difficult to go anywhere or be seen anywhere because the news media was constantly aggressive. There were a couple of local reporters, one female particularly, who, as it turned out, was basically a surrogate for the prosecution. And whenever they could, they would say everything in a biased manner and unfair and criticize. And of course, Casey had nothing to say about any of it. And so people made judgments on their own biases and prejudice. We were worried about, I was not worried about that, is I wanted to get a jury and get in the courtroom and try the case where it should have been tried and not in the media.
Right, not in the court of public opinion. Well, it's no secret that your feelings towards the media during this trial, and I have to ask, we have you on, I haven't spoken to you before. I want to ask you about that famous picture of you giving the middle finger to the media after the jury rendered their verdict. I'm curious, was that just a lot of pent-up emotion, frustration? What were you feeling about?
I'm glad you asked me that, because I have had the opportunity to tell the public about that in probably some 40 or 50 speeches around the country. So here it is. There was one particular little urchin who I understand was a stringer for a radio show that had stalked and harassed and berated us every day during the 3 weeks of jury selection over in Clearwater, came to Orlando and stationed himself at the intersection right in the corner of where the courthouse is and my office across the street, and would shout and yell obscenities and challenges and threats and just stupid stuff day after day after day. He wound up receiving a trespass warning to stay away from the courthouse, and and the sheriff's department and the police department would try to keep him away. And the fact of the matter is that on one particular day, he was stalking me and the entourage, if you will, the paralegals and assistants going across the street to the courthouse from my office. And we had all made the pledge not respond to him, ignore him, have nothing to say. But yet he was yelling some questions at the group, and his quote was, "What is the matter with you bitches? Are you on your period?" And when he said that, I decided he had crossed all lines of transgression, and it was time. And the truth of the matter is, I did drop my briefcase, and I intended to tune him up right in the middle of the road. But we had a bodyguard with us, and I guess it was lucky he pushed the guy away, and the rest of them kept me away. And I really intended, I can just confess to it, I was going to deal with him in the old-fashioned way. And I didn't, and so we went on the court, and when the case was over, and of course every day he did this, right up through the verdict, every day. And when the verdict was read and we got across the street through all that lynch mob, hundreds and hundreds of people, all they didn't have was pitchforks and ropes and torches, but the SWAT team had to be brought in to get us across the street to my office. And we went into the restaurant, which they closed and locked up, and police cordon to keep everybody away from us. And this guy was beating on the glass to want to try to get in. And when he did that, I saw him, and I said, you know what, here it comes. And so I saluted him, and I don't regret it. I can tell you I have signed hundreds and hundreds of pictures sent to me to be autographed. I've also been criticized for it. It certainly didn't please my wife, and whatever the case may be. But it wasn't directed like people have misconstrued. It wasn't directed at all of the media. It was directed to this one little gutless SOB, and he deserved it, and I would do it again.
Well, I think you could say it felt pretty good, didn't it? So let's talk a little bit about the media in general. This case captured national attention. First, before I get into the media, why do you think this case specifically captured the attention that it did? I mean, we cover cases here on LawNewz Network where there is a child who is killed and the parents are put on trial, at least one parent. And I'm curious, what is it about this case in that day and age? You know, that's when new social media was coming about. What is it that really spread, that everybody wanted to know about this case at that time?
Well, you might not be surprised to learn that I've been asked that before.
That's why I asked it.
1,000 times. And I don't know that there is a finite answer. My belief is, after considerable discussions and reflections about it, that it was the fact that little Kaylee was such a gorgeous child, and Mama Casey is such a pretty young woman, and they were white. And I think that's where the difference came in. People saw that, and there it went. And just as soon as there was some a little bit of attention, then there's more. And when there's more squared. And when there's more squared, there's more to the 10th power. It just keeps going. And that's why there were so many media credentials. I think the court administrator last advised that more than something close to 650 different media sources sought credentials to cover that trial. And it wasn't because the trial itself was so unique. And it wasn't because of the, and I have no problem, it wasn't the fame of the lawyers. It wasn't anything like that, but it was very attractive, middle class, young, white woman with beautiful white child and no explanations. And there it went. Ironically, as you say, there have been hundreds of other cases of parents being accused of manslaughter or murder of a child that have gotten virtually no coverage other than local blurb when it first happened. This case was unprecedented. And it was also unprecedented, I think you said the word, social media. You think back in 1991, the OJ case, there was no social media. There was none of this stuff existed. So now it got to the point where everybody was a reporter. Everybody was a journalist. They thought they were. And so it just kept going.
And there's been talks that since this case, because of the attention that she received in the media and because she was already convicted in the public eye, the idea that cameras shouldn't be allowed in courtrooms and that there has to be a limit in terms of what the public in general sees of a trial, particularly in a social media age when people can tweet things that happen in the courtroom in an instant. What are your thoughts on that, restricting that ability to see what happens in a courtroom in general? Obviously, for us on the LawNewz Network, we don't really want that. We cover trials here, but I'm curious, what are your thoughts being at the center of it?
Well, remember, you're talking to an old school lawyer. First 15, 20 years I was practicing law, there were no cameras allowed in the courtroom at all. And the generation since then just can't conceive of that. I've tried, I don't know, 15 or 20 cases that were fully televised from beginning to end. I have mixed feelings. The media is critical in an effort to try to keep the court system honest. But when the media turns themselves into being judges or juries and make decisions and broadcast it to the people who don't know any better, then it's gone bad. All I can say is that media in the courtroom affects the whole process. And only those lawyers like me and some judges know this to be a fact. Every single person that comes in there officially acts differently. The judges act differently. Some, not in this case, but some others, get makeovers and hairstyles, and they and kind of pomp, for the media. The witnesses do. The lawyers do. The jurors, even though the jurors are not being seen, everybody acts differently when they think they're going to be on television. So that causes an artificial environment that is not necessarily the best for wading through conflicting evidence and making hard decisions to arrive at a just verdict. So as a general rule, I don't like it. I think it has been abused. We now have to go through the process of making sure that jurors can't take their cell phones or iPads or anything with them into a jury room or even into the courtroom. They have to be surrendered. So they can't do improper and outrageous things and mistaken information that they think is true. It's a real problem.
Yeah, and that's the goal right now, is trying to figure out how to adapt to it and see how courts deal with it. And like you said, it's a very interesting point that how people, witnesses, judges, lawyers, everyone who's being seen by that camera, how they react to it. You're being videotaped in a way that you would normally not have been. So that's an interesting way of putting it. Well, that's one relationship that we had in this case between the attorneys and the media. I'd like to move on to a different relationship, the defense's relationship with the prosecution. Specifically, I'd like to talk about the prosecutor, Jeff Ashton. We actually had Mr. Ashton on Law News yesterday. You've made some comments about him in the past in terms of you were actually surprised that he was elected to be state attorney in light of the Casey Anthony trial. I want to play for you very quickly some of his comments that he made on Law News yesterday, and I want to hear your thoughts on it. So if we can, let's play that clip, and we'll hear more from Cheney Mason.
From the Casey Anthony trial by the defense attorney, Jose Baez, and we're joined now by former prosecutor from that trial, Jeff Ashton. Jeff, you wrote a book recently where you really went after this defense team, specifically Jose Baez. You said that their defense was, quote, a crock of crap. You called him smarmy. You called him arrogant. This guy was doing his job from a legal perspective. Why did it get so personal between the two of you?
Well, the comments in the book were for purposes of sort of honestly admitting a bias. You know, I felt in writing the book it was important that when people were looking at how I evaluated him, that they understood I didn't like him. I didn't find him, during my time knowing him, to be a very honest or ethical person, and I didn't care for him, and that really hasn't changed. It's softened somewhat over the years, but I think when you're writing about somebody, it's only fair that you are honest about how you feel about them. So that was sort of the purpose of those comments in the book.
Casey Anthony originally blamed this on some fictional nanny who never existed.
Right.
And then the defense team had this theory about Kaylee drowning in the swimming pool. You said in the book that you think the defense team came to mirror Casey Anthony in the fact that she was a liar. Do you think that Casey told the defense team that Kaylee drowned, or do you think that the defense team made this up?
No, I think that actually this probably generated in the public, because when you look at it, the first mention of Kaylee drowning in the pool ever is through the media, because there's a point in one of the conversations between Cindy and Casey when Casey's in jail where Cindy says to Casey something to the effect of, "Did you hear the latest theory?" And Casey says, "No." And Cindy says, "They're saying she drowned in the pool." And Casey shakes her head like that's the most ridiculous thing she ever heard, and just goes, "That figures." So I think that was started really by the media. And Casey, when she thought about it, went, "Hey, if my other thing doesn't work, this is pretty good." And it was developed that way. So I think really the media kind of came up with that. And Cindy, and not Cindy, but Casey eventually, and Jose ran with it.
So, Mr. Mason, what we were looking at was a clip of Jeff Ashton yesterday on the LawNewz Network explaining to our host, Amy Dash, that he said that he didn't find Jose Baez to be a very honest or ethical person. In his book, he called the defense's theory a crock of crap. He also said that the theory of Kaylee drowning was first created by the media, not Casey or the defense team. So those were his comments. I'm curious, what are your thoughts on him and the comments that he made?
Well, in response to those comments, my word would be edited by you. It'd be hyphenated. He's wrong. Jeffrey, look, defending murder cases is an intense process. It's an emotional process. And no pun intended, it's a trying process for any involved. I got that. Mr. Ashton got very overly emotional, and I noticed from shortly after I entered the case that there was a great deal of animosity built up between Mr. Ashton and Mr. Baez. And part of it was, I think, because Jeffrey Ashton had eminently more experience and qualifications, but Jose was holding his own. He was there to represent his client and doing battle with him. I did not know of, nor have I been made aware of any incident in which he was unethical or dishonest. On the other hand, you have it on film, actions by Mr. Ashton that were clearly unprofessional and unethical. Not to say anything about the closing statement, but you may remember he started smirking very unprofessionally, like some kind of junior high school kid in the closing arguments of a death penalty case. And Jose turned around and dressed him down in some fashion, pointed at him about this laughing guy here. And at that point in time, objections were made, argument flared, and I got into it. And I told the judge, I said, well, why don't you deal with what really happened? The judge said, well, he didn't see Ashton. Okay, I can grant that, because there was a big display board that probably was blocking a good deal of his view towards the prosecution table, whereas he was looking at the jury and Jose was pointing out some things on the board he had. So I told the judge, well, why don't we just go back here in the media room and look at it? This is one of those instances where I told you the media had value of making things honest. He said, okay, let's look. Ashton didn't want to. He didn't want to be part of it because he knew that he was guilty. Jose said, you know what, never mind, let's don't do it. And I said, no, for the record, we're going to make this clear. And so the judge and I went back into the media room. I can't remember whether one of the other prosecutors, Frank George or Linda, I don't remember. But the bottom line, sure enough, there was the videotape, clear as it could be, of Jeffrey Ashton smirking and acting up at the counsel table like a child. So in that situation, it was Ashton that was wrong, and Baez was being magnanimous by just wanting to let it go. And I wanted to make a record of it. Jose never did any of the things that Ashton tried to accuse him of, at least to my experience, and not the entire time I was in the case. This concept about suggesting that the media talked about the drowning as a media theory, that's bull. The fact of the matter is, we knew what we believed had happened, and only we knew, that is the defense team, what happened. We had photographs, one in evidence, of little Kaylee demonstrating how she could open the door, reach up, undo the lock on the screen door of the Anthony home, and go up the ladder into the pool. So that wasn't anything the media created. It's where Mr. Ashton would come up with that, just part of his bizarre imagination that he had from time to time. Remember, this is a guy that prosecuted this case for a death penalty that couldn't make up his mind what the theory was. He's the one that, in closing argument, his part of closing argument said, more likely than not, and couldn't make up the mind of whether there was chloroform used to drug the child or chloroform was a product of decomposition or had anything to do with it at all. So, you know, I don't know what he's had to say in his book. I haven't read it, and I bet he hadn't read mine either, because mine is factual and it lays out all the details and documents of wrongdoing and what happened in the case.
Well, we saw the tension during the trial between both sides, and I do want to talk a little bit about the prosecution, because at the end of the day, they did not prevail in convicting Casey Anthony of murder or manslaughter or child abuse. So I want to talk a little bit, you mentioned he couldn't make up his mind. Do you think that the prosecution overcharged Casey Anthony?
You know, I don't know that. I can suggest to you that it is likely, in my judgment and experience, that if they had charged her with a much lesser crime, like culpable negligence, manslaughter or something, the jury would have had a more likely shot at convicting her for not being on watch, not being on guard or something, as opposed to charging her with premeditated first-degree murder and seeking the death penalty. So, yeah, it changed everything. It changed the whole method of the trial, the composition of the trial, the requirements, all the details to try death penalty cases would not have been part of it had they chosen a more discretionary route.
Now, was it, you talked a little bit about the mistakes or the problems in the strategy from Jeff Ashton. There's been talk that what the biggest fault of the prosecution was that they tried to do a character assassination as opposed to using the evidence to support their claims. I'm curious, what do you think the biggest fault of the prosecution was in their strategy? And do you think that if Jeff Ashton was replaced by someone else, if another attorney had been on board, it might be tough to say, but I'm curious, do you think if another attorney might have found some success by going to a different strategy? Obviously, the prosecution made some strategic errors, but I'm curious what your thoughts are on that.
That's a lot of things.
Sorry, we'll unpack it. First, let me ask: do you think that what in your eyes was it the character assassination point as opposed to using the evidence as a way that really hurt their case?
Yeah, look, my generation is dramatically different from all of them. I was, several years older than anybody in the courtroom. In my life, 10 o'clock at night is lights out. And half of the world, the younger folks, 10 o'clock at night is time to go out. And so I don't understand that there was any real value in trying to besmirch Casey's character because she was a 20-year-old that went out with other 20-year-olds and went out to clubs and danced and those various things. I don't think that helped them a bit in the case because it had nothing to do with the facts of the case. In my judgment, of course, again, in hindsight, they would have been better off not to do that. And they would have been better off, and I think, to let Linda Drain Burdick, who was actually technically lead counsel of the prosecution, take the lead role rather than let Jeffrey Ashton do it. Now, Mr. Ashton has a history of inappropriate histrionics in court. His personal actions in many trials have resulted in convictions then being reversed and thrown out by the appellate courts, a number of them. So, that's just, but then how can you explain with that sort of attitude, he got elected after losing the biggest case in the history of recorded United States criminal law. He lost, and he got elected. And in first re-election, he lost again, and he's out. So I don't know. Jeffrey's a good lawyer. I mean, he knows what he's doing. He just doesn't know when he's doing the wrong thing. And that's the best I can say. Right.
All right, let's talk a little bit about the defense's strategy now. When you're defending a case, it's only you need to show that there's reasonable doubt. You don't necessarily, if there's a case where you don't know who the killer is, you don't have to prove who the killer is. You just have to raise reasonable doubt. Now, the idea here that Casey was not the cause of Kaylee's death, you didn't necessarily have to present the case that Kaylee's death was a result of an accidental drowning, and it was George Anthony who was complicit in covering this up. But you did. And the risk could have been, correct me if I'm wrong, the risk could have been that if George and Casey were involved in at least covering this accident up, couldn't the jury have seen this? Well, if this is a woman who covered up the death of her child, is it not so fair to say, is it not so far of a reach to say that she was actually more complicit in the actual cause of her death? You could see how the risk might be there, and I'm sure that had to have come, when you were deciding to present the case, what the danger might have been of coming up with this notion, this story for the jury. But at the end of the day, if you don't present something to the jury, it might not sit well with them in the end.
Well, again, that's a lot. It assumes a lot of things. First of all, there is a significant amount of scientific evidence and a significant amount of scientific evidence that was not there, that could not be proven. Remember, they had no ability to prove the time of death, the cause of death, the place of death, and who, if anybody, was with her at the time of death, which I told the court in motions and the jury in closing argument. It's hard to, and it'll sound corny to some folks. Listen, taking on the responsibility to defend anybody in a criminal case is a serious responsibility. Making it a capital murder case where that person could be executed depending on what you do or don't do in your diligence, and of course what the facts are. I have long believed in all these years, I've been a criminal trial lawyer now for almost 48 years, and I've tried hundreds and hundreds of criminal cases. I believe that juries get the right result, though sometimes from very convoluted and to us illogical routes. I believe the jury was right. And whenever I try cases, I believe that they will be right if you are candid with them. If you try to cover up and lie and play games with the jury, they'll get you. I think if you're sincere and genuine and believe in the position taken, the jury will get that. And I believe that's what we did. I believe we presented as best evidence we could that we were allowed to get to the truth of what happened the best we could. And all I know is there was 12 jurors and 4 alternates that agreed with that, no matter what Mr. Ashton said or some of the news media said.
Right, and like you said, the prosecution was putting on more of a circumstantial evidence case. At the end of the day, they didn't have enough to secure a conviction. But, you know, we see a lot of times in cases where there's a lack of a precise cause of death of a child. And my understanding is that at least some jurors have said that was a really strong reason for them finding that Casey was not guilty. In your opinion, in your practice, when you don't have an exact cause of death, obviously the theory was that Casey had used chloroform to knock Kaylee unconscious and then used duct tape to suffocate her. That was the theory, but it couldn't be precisely identified what the cause of death is. When you don't have that, that really hurts the prosecution. Am I correct?
Well, it hurts the prosecution. It hurts them when they vacillate between competing theories, with Ashton did. Was she chloroformed to knock her out? No. Gee, they have no evidence of that. All they had was a claim that chloroform was a byproduct of decomposition that was found in the trunk of the car after various analysis, and then that was destroyed. And so you had on the one hand trying to argue chloroform was looked up on a computer and made by somebody in the Anthony residence and used to knock this child out and kill her. And other was no, she was suffocated by the tape because they had no evidence of chloroform, or where the chloroform came from, or how many searches for chloroform, how many outrageous. I mean, you remember that part. There was this claim that there were 84 searches for chloroform. Mm-hmm. That was more bull. That was one. And the computer company admitted that there was a mistake in the program and tried to correct that and come back and clear up that, testify. The prosecution objected, and the judge wouldn't even let them come back on their own expense to prove the truth to the jury that there was a mistake in trying to read a program of 84 searches for chloroform instead of 1. That's the type of stuff that happened, and one has to say, well, if there is some major karma out there that's going to deal with the truth got them.
Well, you mentioned the chloroform, and you mentioned Judge Perry. I don't know if you're familiar with this, but he's actually stepped down from the bench, and he has actually provided an interview about what he theorized happened to Casey, specifically about the chloroform, and he said that he thinks it was an accidental use of chloroform on Kaylee. I'm going to play you that short clip, and we'll be back here to talk about it afterwards. But let's play that short clip. It's from I believe, a Fox affiliate, where basically he provided an interview of what he thought happened in this case, and I'd like to hear your thoughts about it after. So let's play that clip.
Thing that occurred in my eyesight, based upon everything that I know about the case, was that she did not intentionally kill her daughter. I think based upon the evidence, the most logical thing that happened was that she tried to knock her daughter out by the use of chloroform and gave her too much chloroform, which caused her daughter to die.
So you don't think she ever anticipated the result that occurred?
No, I don't think she ever anticipated the result. I mean, the question is asked, was there sufficient evidence to submit the case to the jury on the theory of murder in the first degree? The answer to that question is yes. The question that was posed to me, what do I think happened based upon my view of the evidence? And to me, that was the most logical thing, looking at the totality of the entire situation. There was never any evidence of abuse of the daughter that was documented, that was presented anywhere. One of the things that was overlooked was the fact that why was she searching for chloroform? Well, most folks forget that chloroform was used as anesthesia back in the day before there was real anesthesia to render someone unconscious. So considering the high levels of chloroform that was found in the trunk of the car, that was my logical deduction for what happened. That's just a person that actually knows what happened is Casey Anthony.
Welcome back to LawNewz Network. I'm here with Cheney Mason, Casey Anthony's defense attorney in her 2011 trial. You were just watching the statements of the judge, Judge Perry, who was the judge in that case. He since stepped down from the bench, and he provided his theory about what happened to Casey Anthony, what happened to Caylee Anthony in this case. So, Mr. Mason, we were talking a little bit as we were watching the clip. Again, if you could just tell for our viewers a little bit about what your thoughts are on now the judge in this case providing his own theory of what happened.
Well, like I said, I've heard what he's had to say on various times, and different things were said at different times, perhaps to different questions. Let's just take a simple, undisputed fact. There was no evidence of chloroform in this case, period. The only person they claimed to talk about chloroform was Jeffrey Ashton, a prosecutor. And when they made the forensic testing and samples of air and trying to find what whether there was chloroform in the trunk of his car or whatever. We had a chemistry doctor who testified who was part of that process. He said no. He said what was detected by that forensic test was not chloroform. It was gasoline from the trunk of the car. There was no chloroform, nor ingredient, nor anything about chloroform ever found, despite the fact that the law enforcement executed search warrants, I don't even know how many times, maybe half a dozen times on the Anthony residence. There was none. There was this claim about the computer having 84 searches for chloroform. That was a complete mistake utilized by the state to perpetrate a horrendous fraud. When it was discovered, we tried to correct that because we knew it didn't happen. And the gentleman from Canada that designed the program that was used admitted it was a mistake. They had misused the program. He tried to come back down and testify to correct that mistake, and the judge wouldn't let him. So, all I can say is the jury saw through that. And I said, well, what's going on here? There was no chloroform in the story.
Let's talk a little bit about those searches. There was, I believe, a search that was introduced into evidence about neck breaking, as you said, and also about chloroform. But many of the searches afterwards were said that they were overlooked by investigators, and I think there was some surprise that the prosecution had trouble or didn't introduce more evidence of Google searches that were put into evidence at the trial. What did you make of all that in terms of the actual Google searches that were introduced by the prosecution or that were failed to be introduced by the prosecution?
Well, I think it's a myth, because I can guarantee you that if they had any relevant evidence that they could remotely tie to it, the judge would have let it in, and they'd have all been there. They wouldn't have missed a lick on that. They found nothing in the searches. Listen, I can link it to one thing. Someone found in the woods across some suburban drive near where the remains were found, 40 feet or so away, as I recall, a little piece of torn cardboard from a box that had a heart-shaped sticker affixed to it. And the media immediately ran with that, saying this is proof that it was somebody that loved the child, they killed her, blah, blah, even though they cannot connect that in any regard to the remains or this case, and ignoring that this is among a bunch of trash thrown in these woods, and there is an elementary school across the street. So they didn't think about dealing with the truth. They just jumped on that, and they went and searched and searched and searched the Anthony residence to find that, lo and behold, this little girl had some stickers there, and some were heart-shaped and some were animal shapes and whatever. None similar to the one that was found in the trash across from the elementary school. And though the media tried to make a big deal out of it, it had nothing to do with anything. Oh, but it got put into evidence, let the jury speculate about what it meant. It had no evidence and no value to anything.
Well, let's talk a little bit about a witness that really did have something to do with this case, George Anthony. This is Casey Anthony's father. Now, it was the defense's theory that was put forward that that Kaylee died from accidental drowning, and George Anthony was there to help cover it up. And then was also put forth to the jury that Casey was a victim of traumatic sexual abuse in her past by George Anthony. I'm curious, when you wanted to go forward with that, was there any concerns, any trepidations, any risks that you saw about going towards the idea of we're going to start pinpointing this case towards Casey Anthony's father?
Okay, so there's a couple of things there. Number one, I don't know of there being any direct evidence of George Anthony doing anything to cover up this situation. I know there's been lots of talk about it in the 6 years intervening, whatever, but I don't have that evidence. We know that he testified against his daughter in the grand jury. We were never allowed to see that testimony, despite proper motions in the law allowing us to see it for impeachment purposes when he testified. The judge never let us see it, so I don't know what he said. I know he did testify. I think that he was recalled to the stand 14 times. I may be wrong with that number. That's the number I've been told. I can't remember. I got tired of hearing. Know that he'd sit in the courtroom and hear somebody testify, and then the prosecutor would call him to the stand to explain that. That again is another issue of the judge allowing improperly, wrongfully, and unconstitutionally allowing George and Cindy to sit and hear the entire trial and then testify repeatedly about. That's the exact reason why we have a rule to prohibit witnesses, called a rule of sequestration. But nevertheless, he was allowed to do it. I don't know that George had anything to do with particular covering up. Next issue, you said and you may have meant it generally, but not as to me. The claim about George Anthony having improper or illegal, whatever, sexual contact with Casey was not something that was new at the time of the trial. It had come out, and there had been conversation about it. And the fact of the matter is that I had personally interviewed George in the presence of Mr. Baez and George's wife, Cindy, in my office to tell him that there were some jailhouse letters that were being put into evidence that were going to be made public by the prosecution to the media on next Monday. And that you needed to know, George, that there's allegations in there about you sexually abusing your daughter, Casey. To which he was in a long pause with no response. When I said the same thing to moments later, and alone with Cindy, she broke into tears and cried. I don't know any more than that or what there was, but there was the letters from Casey to another woman in jail that did come into play in this case. So when it came time for the trial, an opening statement, I will tell you that Mr. Baez surprised me by immediately making an opening statement about George sexually abusing his daughter. My experience told me, how in the hell are we going to prove that? There's only one way to prove that. George is not going to admit it. He's not going to admit to a capital sexual battery and give him life in prison, which is what would have happened if he got on the witness stand and admitted that. So that meant then that Casey would have to testify. And I had made that determination early on based on my experience in so many murder cases. I'm not going to put her on the witness stand and testify. There's nothing she can do other than deny and be subjected to all manner of abuse and assault, relevant and irrelevant. And Linda Drain Burdick was prepared to do it. She had a notebook, 8-inch ring, 3-ring binder of stuff to try to cross-examine Casey with. No way. So knowing that she could not and was not going to testify, that was a high risk. And like I said, Mr. Baez did that without consulting me. I was surprised.
Well, I can tell you, I don't think you were the only one that was surprised. I think everybody that was watching was a little surprised that that came out. But the idea was that was put into the jurors' minds that if Casey Anthony is a woman with a traumatic past and she is someone who's suffered a lot and she's had to cover up what has happened in her life, and the idea that she's had to live in another way, hide the lies or hide things that were happening in her life in order to have a normal life, then here, this is kind of the same situation. If this is a woman who knew about what happened to her daughter or was involved with what happened to her daughter, since she's had in the past had to hide the emotions that she's felt, this is just another instance of this. Now then again, that the idea that if this is a woman who has been used to lying in the past about things that's happened to her, then the idea that she's lying about her child, is that really the same thing, or couldn't it have backfired and said to the jurors, well, wait a second, if this is a woman who has to hide things, then isn't it possible she could have hid the truth of what really happened to Kaylee? Is that not a concern that might have come up when you did have the chance to speak with Mr. Baez about this?
Any of those theories could be possibly true, but you're missing the one that I think was really there. Casey, as we established with an expert witness at the end of the trial, grieved and comprehended differently than everybody else of what happened. She went into what I call Casey world. She shut it out. Your questions and the other interpretations are suggesting that she knowingly and intentionally covered up and did things. Not if her mind was so blown by the huge tragedy of losing this little girl. She didn't know what she was doing or what she was saying. And I knew that. And that's why I was real clear. She wasn't going to be made to testify. There were times that she said she wanted to be able to tell because she knows that she did not do this. And we had long discussions about that, the risk and consequences. Defendants testifying is always a high risk thing. Some lawyers like to do that. The more experienced lawyers, the serious experienced lawyers know, no, that's very rare that you would be competently required to put on a defendant to testify. So let's not assume then that Casey knew anything and therefore tried to hide it and therefore was lying to try to hide it, etc. That's too many assumptions. If in fact her being suddenly made aware that this child so precious to her, which was video proof, shown in court, all the videos of them playing and interacting. She was close to, bonded to, and loved that child who was perfectly healthy, perfectly clean, dressed, well-nourished, no instance of any prior injury, no abuse whatsoever. That's the truth. And when it went away, as a grief counselor expert told us, she just snapped. And I'm telling you, I've told others before, and I'll say it again. When that testimony came out, I was sitting next to Casey, and I don't remember whether I had my arm on her shoulder or was just holding her hand there while that testimony was going out. But she started shaking and shivering, and she cried, and a look on her face. And all that time I had known her and all the conferences I had seen her, I had never seen this. It was clear to me, my personal opinion, that was when for the first time she consciously was absolutely aware that her daughter had died. Now, I won't tell you, people say, oh, now how can that be? Well, people grieve differently. And the best proof I have of that is that during this trial, and within 2 weeks before that testimony, there were two people, members of my defense team, who lost immediate family members who had died during the trial and that 2 week period before that. And nobody knew of it except me, because they were able to completely compartmentalize and control that and deal with that because we had a job to do. So people grieve differently, they react differently, and that's contrary to most people's what they think is common experience.
So, in other words, Casey actually gave an interview with the Associated Press recently, and I'm curious, this sounds pretty much like what you were just explaining, but I'd like to hear your thoughts. She said, "I'm still not even certain as I stand here today about what happened." And when she was asked about the drowning defense, Everyone has their theories. I don't know. As I stand here today, I can't tell you one way or another. The last time I saw my daughter, I believed she was alive and was going to be okay, and that's what was told to me. Now that sounds, what you're telling our viewers is that a little bit like everyone reacts in a different way and that they grieve differently. Now you could see how people would read that and say, well, how do you not know what happened? And is this just someone who's covering it up? I mean, especially if you want to take the idea, the idea that was put forth that if this was an accidental drowning and you knew about it, how do you not know what happened? So you can see how people might view this in a certain way and how other people might view it the way that you say.
Not only that, of course I can see that. It was as recently as last week, I received correspondence from someone out of state who has before sent me detailed protesting what's gone on before and absolutely affirming to be the truth that Kaylee is still alive and she was living with this person at this address and so forth. I know that's bizarre. It's ridiculous, but there are people that believe from that scope, that far into the line there, to those who believe that she plotted and planned to kill this child and got some chloroform and whatever. So anywhere in their spectrum of people can use their imagination. We don't use imagination. In this business, we deal facts and try to deal with the truth the best we possibly can.
But that's even the point, even if the idea was that this was an accidental drowning and she still would have been involved or knew about it some way. No, we're not talking about planning a murder or anything like that. If this was, as the defense put forth, this was an accident, then again, people are going to see that and see how she's responding today, 6 years later, and still saying, you don't know what happened. How's that possible? We're not talking about you planning a murder or being involved in that way. But you still don't know what happened. You could see how people still, and I know that Casey is living her life and she's trying to have some semblance of a life now, but you could see how that would rub people the wrong way.
That doesn't bother me that people look at it differently. There's all kinds of reasons to have different opinions and thoughts. What I'm telling you that is consistent is that I believe that Casey's mind in some dimension, I guess the common word is say snapped. She didn't go sniveling crazy by any means, but blackout, completely a blackout of what went on and what happened, no matter what we talk about of the evidence and the doctors and the scientists and the chemists and on and on and on and on and on until that morning trial. How do I know? I wasn't there. I know what my reactions are. I know what I bring to the table of dealing with people. I am 73 years old. I've been around for a while. And all I can say is my instinct, my intuition, my judgment was that the first time that Casey had an absolute then belief, at least temporarily, was in trial when the grief counselor was talking about her, that she had a result of much displeasing to her that the child was dead. And that doesn't mean that she was awakened from a hypnotic state at that time. It means that was an awareness. And I'm certain that to this day, it's been a while since I've talked to her, but I'm certain to this day that there's any number of questions that could be asked and she would look and not know the answers to, or say, well, maybe it was this, or maybe it was that. We know what we believe the theory was, and that's why it's presented by the defense. That the child went out early on the morning, unsupervised, on her own. She was able to unlock the door to get out and get in the pool, and she drowned. And on that morning, as is customary, later George found her, brought her in, and as I heard, the claim was that he yelled at Casey, "Look at what you have done. Your mother will never forgive you." I wasn't there. I don't know all that didn't happen. We don't know what happened thereafter. What we do know is all the matters they came up of evidence to prove. And people just have a hard time understanding this. If that happened, who disposed of this child's remains, when and how? Keep in mind that when the remains were found, Casey was in jail. And when the remains were first found, before they were actually retrieved, 3 months or 4 months before that, Casey was in jail. And remember where the remains were found. People just ignore this. The remains were found, the site of the remains measured 17 feet and 4 inches from the edge of Suburban Drive. And that's a very small step. And in that period, that location, they weren't found. And we were able to establish through investigation approximately 162 people that had searched that area, besides the sheriff's department, news media, and all kinds of volunteers had searched that very area, and there were no remains. And then when they were found, all that period of time, from the searches where there were no remains until they were discovered on December the 10th, Casey was in jail. So we can say conclusively, that Casey could not have put those remains there. Therefore, simple human logic dictates that somebody else did. The question then is who and when, etc. Answers we don't know.
Well, I can tell you, Mr. Mason, I think everybody still has questions about this case and wondering how it goes. And I know myself, I have more questions that I'd like to ask of you. Unfortunately, I know we are limited in our time. So my final question to you before we let you go, and again, thank you so much for joining us here on LawNewz Network, is my final question is, what are your final thoughts on this case in terms of you moving forward in your life? How has it impacted you and the nation in general? So people are still talking about this case 6 years later. What would you like your final statements to be here on the LawNewz Network as people still process this case?
Well, I can tell you a short answer that you didn't invite necessarily. I have written a book that's very definitive about this called Justice in America. And all the other news people and programs that have contacted me and talked about it have read the book and have the answers to all the questions. Now, that doesn't mean everybody accepts everything, but I did indeed include documents and references to transcripts and so forth. It's in the book. The questions to be answered. There are going to be people who, until they die, are going to believe that for one reason or another, unknown, that Casey killed her child and somehow was able to hide her body from being in jail. I'm not going to be able to convince those people contrary, any more so than you could convince the intelligent electorate this last November. I mean, all kind of weird things happen, and all I can say is the truth of the matter is the jury did the right thing, and those who were not part of it are not going to accept it. And that bunch of social fools that were made up the courtyard of the lynch mob after the verdict that tried to want to get to the defense team, those are people who need to reflect about where they were, when they were, why they did what they did, and would they like it to happen again. All I can tell you is there will be more cases like this. There will be more reactions. It'll carry on. Every time I go in the courtroom, there's some reaction to do it. I've handled 3 homicide cases since Casey, and you wouldn't know about it because we keep it out of the press when I have a chance to. So it's going to go on, and people like Mr. Perry, the former judge, is going to have talk about what theories he now has. Mr. Ashton will talk about his theories that he attempted and failed at. All I can tell you is we'll have ours as well. And the good part about it is the jury agreed with me.
Cheney Mason, thank you so much for joining us here on LawNewz Network. Really appreciate your time in explaining this case, as yesterday marked the 6-year anniversary of the verdict in the Casey Anthony trial. Thank you so much.
Tell me this: is this going on live, or
Right now you are live. Everyone's watching this as we speak.
Okay. Hi, folks.
So everybody is here, and thank you so much. We all appreciate your time. Thank you again.
Well, all right. Bye.
There you have it. Cheney Mason, Casey Anthony's defense attorney, along with Jose Baez, in the 2011 murder trial. I want to turn right now back to our clip that we were showing. It was the CA4A. This is the George Anthony testimony, Casey Anthony's father, his testimony in the trial. We are going to be continuing our coverage of the Casey Anthony trial, as well as talking about a little bit of Holly Bobo later on in the day. So let's continue our coverage of this case, and we'll be back more here. I am signing off, but our next host will be joining us soon. Thank you so much.
open doors, things of that sort.
Oh, right. There would be no thing that she couldn't accomplish. I mean, we've seen that. We put the proper security plastic knobs on doorknobs and stuff like that because, yeah, she could open things up for her age. She was really something.
Now, in the early summer, late spring, early summer of 2008, did you believe that your daughter was employed?
That's sort of a two-part answer for me.
Sure.
Yes and no.
Okay. Explain that for us, will you?
I always wanted to give my daughter the benefit of the doubt of working and providing for her own daughter because she was a single mom. But at different times, and I would question about her money or things like that, how she was providing for Kaylee.
Okay, let me stop you for a second because I don't want to go too far afield of this, but what was it that she told you about her employment, let's say in May and June of 2008? What was it that she told you
Well,
about
that she was still employed by Color Vision. She's moving on as an event planner, I believe, through Universal Studios at the time, but also she was starting to work a part-time job at Sports Authority, not too far away from our home.
And as far as the Universal Studios job, did you believe that she was actually working there in May and June of 2008?
I was wanting to believe that she was working there, yes, because, I mean, she still had a Universal ID. Every time I would be talking to her and asking her prior to me going to work, are you going to work today? Yeah, I've got something going on at Universal. I'm doing this event planning and things like that. So, yeah, I was believing and hoping that she was working there, yes.
Did she have a routine reflective of someone going to work?
Pretty much so. I mean, I know she worked a lot more like a early afternoon to an early evening type shift. She went at 1 or 2 o'clock and may not come home till like 8 or 10 o'clock at night. I mean, it could vary. I know working in event planning that she had explained to us, sometimes you could work just during that particular event that you're scheduled for, which could be 4 or 6 hours long. So I just took it as she was there for that period of time, yes.
What did she tell you? Well, at this point in time, let's say May and June of 2008, was Cindy working with your wife?
Yes.
What was her work schedule?
Cindy was Monday through Friday. She could be leaving the house anytime between 7:30, 8 o'clock, and she would work till 5, sometimes 6 o'clock in the evening. Could be a little bit later, but generally that was her general work schedule, Monday through Friday.
How about you during that same period of time? What was your work schedule?
I was working an afternoon shift. I was working 3 p.m. to 11 p.m. Some people call it a second shift or an afternoon shift. I was working in security for a company out of Altamont Springs.
And were you working the same Monday through Friday schedule as Cindy or different?
No, I worked Sunday through Thursday. I was off on Fridays and Saturdays.
Now, during the periods of time when Casey, you believed, was at work, and you and Cindy were both at work, did she indicate to you who was watching Kaylee?
Well, there was a name that was brought up, and I don't think it was maybe a year prior to all this stuff occurring from us. I think it was probably just shortly after the first of the year that I can basically remember. A girl by the name of Zanny's name was brought into it, or I guess the name came out later on as Zenaida. But that's what I was told. So this lady was taking care of Kaylee's, his name was Zanny.
She was a babysitter when you and Cindy were not available.
Yes.
Now, I want to direct your attention, to June the 16th. Well, before I do that, could we have State's Exhibit A? Let me unpublish first. Do we have State's Exhibit A for the monitor for the witness? You recognize that picture?
That's Kaylee. That's my granddaughter, Kaylee.
This time, Your Honor, move into evidence State's Exhibit A for identification.
What's that? There being no objection, it be received in evidence as State's numbered
and I've published it to the jury. Do you know approximately when this was taken in terms of its proximity to the last time that you saw her?
This would have to be probably the early part of 2008. I'm just going to guess somewhere in that January to March, April time. I'm just taking a wild guess. Probably in that first quarter of 2008.
Does this fairly and accurately depict her appearance the last time you saw her in terms of general appearance and hair and all those kinds of things?
Generally, yes, it does. I mean, she could have her hair back from time to time. She could have glasses on. But this is definitely Kaylee.
Now, take us to the morning of the 16th of June of 2008. It was a Monday morning. Tell us how that morning began for you.
With me waking up probably about the time that my wife had just left for work or going to work. Me getting up and having my normal cup of coffee. Just starting my day off a little bit early like I generally have. And having Kaylee come out and be able to spend some time with her.
Was that a normal course of events for you to have some morning time with Kaylee?
Oh, absolutely. I mean, there would be times that after she'd be in Casey's room with her, she would come out and I'd take her. First thing is to make sure that she would freshen herself up, brush her teeth, go use the facility or whatever that she needed to do because she was starting to do that, and just, maybe wash her face off and just say, hey, this is how you want to go with JoJo and get some cereal and things. So that was the start of our day. That was pretty much not an everyday occurrence, but it was pretty regular.
And is that how it went on this particular morning?
Oh, absolutely. It was a great morning to just have some fun together. Her and I act silly and dance around and watch a video or whatever it might be. So color.
What was her favorite video? Did she have a favorite?
Oh my gosh. Lady and the Tramp was a fantastic video for her to watch. 101 Dalmatians that she called Dalmatians. There was just a lot of different things that just captivated her that she loved. I wish I could remember more right now, but those two I know she watched quite frequently and enjoyed the most.
Now, this particular morning, do you recall when you first saw Casey?
Probably could have been about 9, 10 o'clock that morning, roughly right around there, her just getting up and getting her day started and just, I can't remember exactly what she did to get ready that day for work or something like that. I know to me, it was a lot of precious time for me to spend with Kaylee. So whatever Casey could have done that morning, been on the computer, whatever she was doing, I'd let her do her thing, because when you got time with your grandchild, your own child sometimes takes a back seat to that.
Okay. Was it just a normal morning? Anything out of the ordinary occurred? Anything different than the usual mornings that you had? Not
really anything I can really say that really stuck out at all. I just know that I was just so thankful to have time with Kaylee, talking to Casey. I'm sure we had a conversation about work or something. I don't remember the specifics about that aspect of it, but I do know that it was, when people talk about a typical or routine morning before they went off to work, it's probably just one of those typical times that we all sort of just take for granted sometimes.
All right. So did there come a time when Kaylee and Casey left the house that day?
That is something that is forever in my mind, that I can't forget that day, because that's the last day that I saw Kaylee and Casey together. I was watching a specific program on TV. It's on the Food Channel on one of our local cable TVs. And this gentleman who has this show called Drive Up Diners and Dives, I've just been amazed by his stuff. I just like him going around. But what's really just amazing is, I remember the time because it was a commercial break on TV, and I remember Kaylee coming out from Casey's room, dressed in a nice little pink top. She had her blue jeans, little shorts on, her white sandals, pink socks, her white sunglasses, her hair pulled back, and she had a little backpack on. And I said, "Where are you going?" And she says, "Going with Mommy." And I said, "Oh, really?" I said, "Where are you going?" "I am going to see Zanny." And I said, "Really? Great." You know, I'm just excited. I'm just knowing that she's happy, and I can see excitement in her. And within a few minutes, Casey comes out and, you know, dressed. And she says, "Dad, we're going to work. I might be home late, or I'll let you guys know I might be staying over."
Staying over where?
She said, you know, probably Zanny's house, because Zanny was, I guess, lived somewhere close by, or she didn't want to come home too late. And plus Kaylee would be in bed between 8:30, probably 9 o'clock. And I said, okay, it's something that happened every once in a while. It wasn't an occurrence that occurred all the time. It could be every once in a great while. She would stay with a friend or stay at Zanny's house or something like that. So
up to this point in time, had you ever met Zanny?
No, I never met Zanny, never had any reason to, because I thought that's who Kaylee was seeing.
You told us about the conversation with Kaylee and with Casey. What happened?
I went out. Like generally, like I did when I could see them when seeing Casey going off to work, and walking out with Kaylee and seeing Kaylee getting placed in the car, getting buckled in her car seat. Just a normal type stuff. And I did. I'd blow her a kiss and say, "Josie, I'll see you later," and she'd blow a kiss back and give Casey a hug. And just told her, you know, drive safe, make sure you come home, not too late. You know, just normal father, grandfather type things to do.
And did you see them leave in a vehicle?
They left in Casey's car, which is a Pontiac Sunfire.
That's a white Pontiac Sunfire?
Yes.
Did you ever see Kaylee again?
I've never seen Kaylee since June 16th. I haven't seen her since.
Now, Mr. Anthony, I need to ask you some questions about something else. Have you ever sexually molested your daughter, Casey Anthony?
No, sir.
Have you ever committed any sexually inappropriate act with or in the presence of your daughter, Casey Anthony?
No, sir.
Were you present in your home when Kaylee Anthony died?
No, and when I heard that today, it hurt really bad. Because if I would have known something would have happened to Kaylee, we wouldn't be here today.
Now, let me just ask you a couple of questions. When you were a law enforcement officer, were you trained in CPR?
Yes, sir.
Is there any extent that you would not have gone to save Kaylee's life?
I would have done everything possible, humanly possible, to save my granddaughter. If what was stated prior would have happened, I would have done anything I would to save my granddaughter.
Did you dispose of the body of your granddaughter?
No, I did not.
Did you obtain duct tape from your shed or garage and place it over the nose and mouth of Kaylee Anthony?
No, I did not.
Did you have any role or any knowledge that Kaylee Marie Anthony died on June 16th, 2008, prior to recent revelations?
No, sir. I never had any duct tape. I never knew of anything that happened to Kaylee until our life started to unfold on July 15, 2008, and when Kaylee was found on December 11th.
Your Honor, I have no further questions of the witness at this time. I would like to reserve the right to recall him for additional areas of testimony.
Cross-examination.
Hello, I'm Tamara Holder. I am guest hosting here on the LawNewz Network, and you have been watching the Casey Anthony trial. Casey Anthony's father was just on the stand. Of course, this is a replay of a trial 6 years ago, she was found not guilty. 6 years ago yesterday would be the anniversary of her not guilty finding of first-degree murder, aggravated child abuse, and aggravated manslaughter of a child. So she completely escaped for the most part. She was, though, found guilty of lying to the police, which is always something that is easy for law enforcement to get, lying to the FBI or lying to the police. And she was ordered to pay over $200,000 in fines to the city of Orlando. So with me today is a host that you know very well, Aaron Keller. He is here on this side. Thank you for being here with
Not
me.
a problem, not a problem.
So I like having you here because you, I feel like I can beat you up a little bit.
Well, why would you do such a thing? I'm a nice guy.
Sometimes. No, that's
Sometimes.
That's what makes you easy to beat up on, because you're such a nice guy.
Okay, well, throw some things at me and I'll see whether I agree or disagree.
All right, so what I covered this trial. I don't know if you did, but
No, I was in law school, so I did not pay attention to this trial. I was working and studying.
Okay, well, I was out of law school, and this is one of the first cases that I covered. And of course, Nancy Grace really sensationalized this case because out of the gate, Casey Anthony, in the mind and the court of public opinion, was found guilty. She killed her daughter. How could she not report her daughter missing after she's been missing for a month?
Well, let's dial back. Is there a defendant that Nancy Grace ever gave a fair shake to?
No.
Okay, so that said.
But this case was different because I think that this case really showed the way that media can sensationalize a case. You have a little girl, a little innocent girl. You have really shady circumstances, but there's not a lot of evidence, and it was really easy to just plant ideas in the minds of the public. So my first question to you is, I'm kind of everywhere because obviously the viewers have been watching George on the stand. And one of the things that I found really interesting in that case was that he said that it smelled like, that the car smelled like a decomposing body, and that he put two and two together, so it made sense that that was Kaylee's body. Why do you think then he didn't call the police? And also, why would he be able to say something like that on the stand? He's not an expert.
Well, I mean, it's an impression of his for what it's worth, and it opens him up to attack for not being an expert. Well, I don't know, was it a body or was it a chicken McNugget that got stuck underneath a seat? We don't really know. The jury could see it potentially as a nugget of information that would point towards guilt, or they could see it as just a random observation from someone who didn't take it seriously enough to call the police. And
right, because decomposing bodies, you don't call the police if you smell a decomposing body in the trunk of your car.
You don't have to. I mean, well, you know that there's really no duty to report. I mean, you don't have to go call the police if you see something. Many people do out of a moral obligation, but there's not a legal obligation to do it.
Anybody, and I don't want to really get stuck on this. I just found that it was a really interesting comment that stuck out in my opinion, because a decomposing body is a smell that nobody wants to ever smell in their whole lifetime. It's an atrocious smell. It's something that, especially if the body's been in the trunk for a long period of time.
I would assume so. I've never smelled one, but yeah.
So even though you're right, there's no duty to report per se. Why do you think that he didn't call the police? Why do you think that he didn't take it in, I don't know, to the car wash or something and say anything about it before he got on the stand?
Your guess is as good as mine. Maybe he was trying to protect his daughter. Maybe he wasn't sure of his own impressions. Maybe he came up with this idea after the fact to try to stitch facts together that didn't make sense in his head at the time he sniffed the foul scent in the air. We don't really know, but it does just inject another piece of odd information into a case that, from an evidence standpoint, was odd in many ways.
Right. Okay, so let's go back to one of the things that I found was the most bizarre, is that Kaylee was last seen alive June 6th of 2008. She was not reported missing until July 7th, 2008 by the mother by Casey's mother, Kaylee's grandmother, Cindy. This is a child who lived in the grandparents' home. How do you make sense of that the granddaughter that they see every day that they've raised is just gone and they're not doing anything about it until 5-6 weeks later?
Well, I mean, again, it's bizarre. And I think this is why we wound up with an acquittal in a case that, as you pointed out, everybody or most people who were reporting on it were just charging down the path of assuming that it was an easy guilty conviction.
Right.
And we know it's a sad case, but does that necessarily mean that this particular defendant is the one that has to pay for it? The answer is no. And you're pointing out all of the facts that the defense used to wedge reasonable doubt into the government's theory of the case. So the evidence was what it was, the jury saw it that way, and people watching certain TV channels saw it another way. It goes back to what used to boil me in the cases that I covered, where I used to sit as a reporter and say, hey, look, the government has the burden here, so as a journalist, I more often than not was asking tough questions of the prosecution to try to figure out if their case made sense.
Right.
And also trying to make sure I was conversing with the defense as much as possible to try to ferret out what their, what their theory of the case is as well. Jose Baez, in this case and in the Hernandez case, has come up with extremely clear theories of alternate liability, and the juries really latch on to his style. A lot of people love to hate him, but it works.
Right. They hate him on the outside looking in. If they're charged with murder,
they'd be calling him up immediately.
So I want to go back to something that I noticed with George Anthony's testimony just recently. In the end, the camera went to Casey, and Casey, who seemed throughout most of his testimony to be very stoic, in the end started shaking her head and really seemed shocked by the things that her father was saying. Now, remember, the opening statement by Jose Baez was something that shocked everybody, which was that her father, George, molested her as a child. Do you think that the jury was swayed at all by Casey's response just in that short moment? Because it seemed believable to me, and I'm not defending her or not. I'm just analyzing it at this stage, looking at everything again. How much weight do you think that had? Is her reaction to her dad while he was testifying against her?
It may have had some weight. I think that the bigger weight was thrust into the room. The 500-pound gorilla was thrown into the trial when Jose Baez came out of the gate and started airing all of this alleged dirty family laundry. And he had a quote in his opening statement where he said, "You can drive down the street and see houses and never know what's going on inside. And in this household, this is what was going on inside. So you have to remember that the way that Casey Anthony was raised is unorthodox. She's got a lot of problems from it. There's bad blood in the family." So Jose Baez immediately set the tone that whatever came out of the family's mouth was potentially going to be untrustworthy, or even if the jury trusted it, that it would just be looked upon with this really odd supposition. Jose Baez turned the father into the monster in the courtroom, not the defendant.
Right. That's a very good point. All eyes turned to George, and especially in a case where there isn't a lot of evidence. There's a decomposed body, a badly decomposed body. There's a smell that some people smelled, but that's
Didn't
it.
do anything with, yeah.
Right. There's no chloroform. There's no nothing. And so it's really hard to prove a case.
You've got the weird internet searches too. There's some of the forensic internet computer technology that raised a lot of questions.
And her behavior.
Yes, I mean, and her behavior in this courtroom vacillated back and forth between stoicism to trembling to head shaking, and I think there were probably 5 or 6 other layers of emotion on top of that. So she was reacting in interesting ways, just to put it mildly. You might be able to come up with a harsher word for it, but at a minimum, that's what it is. And again, Jose Baez has this strategy in this case and in the Hernandez case that we kicked off the LawNewz Network covering, where he really, from what I can tell, looks at the witness list and says, which one of these people can I make into a demon and take attention away from the defendant,
Right.
because he did it in the Aaron Hernandez case. He turned Alexander Bradley into the demon.
But it's not just that. It's the fact that these cases have also lacked a lot of evidence. The Aaron Hernandez trial, the second one, it was an older case. So it lacked a lot of the things that the Casey Anthony case lacked. Evidence, eyewitnesses, all of the things that really make for a strong defense. Not to take anything away from him, but it helped. Now, I want to jump to something before I forget. So the judge, even though Casey was found not guilty of murder in the first degree and all the main charges, she was found, like I said, she was found guilty for lying to the police and was sentenced to 4 years in jail. As a criminal defense attorney, I've never heard of somebody sentenced to 4 years in jail, which means it's a misdemeanor offense, not a felony. Usually it's, a year or less. Anyway, my question for you is this. The judge ruled that she owed $95,000 for the search, $119,000 to the police for a total of about $217,000. She was found not guilty. Do you think that defendants should be found liable for, or should be ruled to pay for this kind of search?
For the government search.
Yes.
Okay, as opposed to civil liability, because then we're in a different area. I just want to make sure we're splitting.
No, she wasn't sued for anything.
Yes.
This is the judge ruling you owe fines and costs and you have a duty to pay back for the search and the police. But why did the judge do that? If she was found not guilty, why is she liable for that?
I mean, a lot of states try to force defendants to pay costs associated with a prosecution, and this has turned into one of the hotter areas of debate in criminal law, as you know, between defense attorneys and prosecutors and people studying the legal system. Because if you're not guilty, in the eyes of the law, you didn't commit that crime. Why should you pay for all of the search? The theory is that we have law that is promulgated by all of us, and that as a society, as a state, it is the state of Florida, the people of New York versus someone where the people swoop in to try to provide justice.
And the taxpayers pay for that. The taxpayers pay for the search. The taxpayers pay for the prosecution.
Yeah, if I have to pay a quarter this year to prosecute a murder case somewhere where I'm a taxpayer, then that's a burden that I'm willing to share. Okay. But we've seen more and more scholarly studies done of this whole issue of people being forced to pay hefty fees even when there's a not guilty verdict or an acquittal of some sort. Especially true with drug cases. I know that there was a big study on this in New Hampshire a few years ago where I had my first law license. And again, should we be forcing people to pay? A lot of people would sit on the sidelines and say, look, if you're acquitted or the government can't prove its case, you shouldn't have to pay for the prosecution. You shouldn't have to pay for the police officers' overtime, whatever else is going on. But a lot of states have these hefty fees built into the court system. And an argument could be made that some prosecutors' offices really push crimes forward knowing that they might end in an acquittal, but that they can still shake a couple of dimes out of the defendant's pockets, and that the fees are the punishment that the actual constitutional burden of proof would never be able to exact. Now that, I think, is an issue. And if what happened in this case with the fees that she was assessed are somehow analogous to that, then I would have a huge issue with it. For whatever reason, a lot of state legislatures and a lot of judicial branches want to keep moving in this fee model because legislatures are pulling more money back from court systems to try to cut budget corners.
Well, and also judges are given a lot of discretion. So what is the person going to do, right? Are they going to appeal it, and then the appellate court is going to say, you have nothing, you have the judge in his discretion, this is what he ruled was appropriate. And so they can avoid going after somebody civilly because and risk the trial and motions and summary judgment and all of those things if a judge with discretion can just backdoor it and say, here, this is what you owe. But it's a hefty amount of money, $217,000. Do you think that the judge saw that because of how much media attention this garnered, that Casey was going to write a book or she was going to profit off of this, and therefore she would be able to pay this? Because as we know so far, she hasn't.
She did an interview with the Associated Press, which I don't believe the AP pays for interviews. I mean, there are some tabloid publications that will, but I know it caused a scuttlebutt in her circles, as small as they may be these days, that maybe she should have done an interview where she could make a couple of bucks and pay for something that she needed. That didn't happen. She did an interview with the AP, and presumably no money passed hands as part of it. Maybe that did enter the equation. I don't know.
Okay, so I asked on my Facebook for people to ask questions. So we're just going to hop around because this isn't a live trial. Everybody knows. People just want to ask questions. This is a very serious legal question. Where is Casey Anthony hiding?
Well, she's living with the investigator who handled the investigatory services for her defense, is my understanding. I haven't dug into it very much beyond that.
Okay. Do you think that people who are found not guilty should be given... What do we do with people in society like Casey Anthony? She was found not guilty. It wasn't like the OJ case where she was found liable in a civil case. As far as we know, the public, she didn't commit this crime, but her life is presumably over. What do we do?
She's been complaining about that.
Right.
Yeah.
She's been, but what do we do with people? And this is just more of a social argument versus legal.
Which is surprising because, but anyway,
because this is a law show. But what do we do? Because it's easy to not hire people who have felony convictions, right? Or any kind of conviction, a misdemeanor conviction. Their background is scary. We don't want them in our place of business. But here's a woman who, in the eyes of the law and the jurors, what was it, 7 women and 5 men, 10 hours and 40 minutes of deliberation, they ruled that she was not guilty. So you said she was complaining about it. What do you mean about complaining? What do we do?
Well, she was complaining about this feeling that she apparently has that her life is pointless and meaningless. I forget the exact quote at this point. But I think it goes back to some self-reflection by all of us who sit and watch these cases. We have to have some degree of respect for judgments. The judgment of the jury, who sat and listened to all the evidence that was admissible, and most of the rest of the world didn't, found her not guilty of the most serious charges. Respect the judgment, okay? That's the judgment of the jury of the peers, and we have lost this sense of respect for juries. You know, people will sit and watch, and this used to bug me when I was a journalist. I'd go to the grocery store and people would come up to me and say, you know, that story you're reporting on, that guy just seems guilty, guilty, guilty. Why is it, if I were on that jury, I would do this. Why did the jury do that? And I say, well, how much of the evidence did you listen to?
Right.
3 or 4 minutes of it, 5 nights a week? Well, you know, as a journalist, I did everything I could to be fair, but the back end of the bargain is that the audience needs to realize that I'm providing a headline service, okay, when I was reporting as a daily news reporter. And even if a cable show blows out an hour of programming to analyze a trial, well, the jury heard 7 hours of testimony today. The audience on the show heard 1 hour. So, you know, people are quick to make judgments. People are quick to lash out at juries. I sit and say, hey, look, the jury heard the whole case, not just 10% of the case.
Right.
And we have lost a sense of respect for judgments. But I'm just saying that because I'm a nice guy. I'm sure you'll beat me up now for that.
No, but there's another part of this as well, and that's I feel that we've lost respect for defense attorneys as well. Jose Baez, I was in a room with him years ago, and people were freaking out. They couldn't believe that this guy was around and seemed very angry with him. And as we joked about this at the beginning of this discussion, he's not very well liked, but except if you need him, right?
Yeah.
So I want to. Are we going to go to defense questions of George Anthony?
We need to go into a clip.
We're going to go into a clip. Sorry, this is my first full experience here, sending you off into a clip. Okay, so we're going to go into a clip of the defense questions of George Anthony, who is Casey Anthony's father.
until our life started to unfold on July 15, 2008, and when Kaylee was found on December 11th.
Your Honor, I have no further questions of the witness at this time. I would like to reserve the right to recall him for additional areas of testimony.
Cross-examination.
Mr. Anthony, when did you first find out your daughter was pregnant?
I believe it was sometime in May or June of 2005.
So she was 7 months pregnant when you first found out?
6, 7 months. It could have been right around that time, yes.
Do you recall going to a wedding that was Cindy's brother's wedding?
I went to Myrtle Beach, South Carolina, but I did not attend the wedding.
Were you ever confronted by Rick, her brother, about Casey's pregnancy?
We had a brief discussion about it, but I told Rick it was none of his concern, none of his business. Whatever was going on with Casey would be handled through Cindy and I. We're there for Casey. You don't have to worry about it.
So is it your testimony today that you knew she was pregnant and you just didn't want him to know, or you didn't know she was pregnant at the time?
I didn't have an exact knowledge of the time that she was, when I found out that she was pregnant, I didn't have that exact knowledge at that time. Did I have a feeling? Possibly, yes, no. But no, I mean, I did see a change physically in Casey, but nothing that I know that Cindy and I weren't going to, help her with or attend to.
So the photograph that you saw here today, you don't believe? Yes.
Yes.
Show you what is marked Defense Exhibit A.
Could I ask the counsel to explain to the jury that aren't in evidence?
Mr. Baez, if it's not in evidence, you may.
Is that a fair and accurate representation of Casey when you went to the wedding?
Oh, absolutely. Like I said, I did not attend the wedding. I was there, but I didn't go to the wedding that day. But as far as that being Casey and Cindy together, yes.
Judge, unless there's any objection, I'd like to move Defense Exhibit A into evidence.
Yes, Your Honor. Object, counsel, moving that to evidence.
Sustain.
We'll call him back for that.
Cross the side, Bob.
So we can all be clear,
Just a
Mr.
second. Just a second. You may proceed.
So we can all be clear, Mr. Anthony. Did you know your daughter was pregnant the day the photograph was taken?
Not exactly. I mean, I had a feeling that she was, but then again, like I've stated, until we knew for sure, until we could take her in for some kind of test or something like that.
So the answer is no?
Yeah, the answer is no. I mean, does it look like it at that point, that photograph? Yeah, possibly.
I didn't ask you that. I just asked you, did you know if your daughter was pregnant the day that photograph was taken? Your answer is no?
No, not exactly no.
And you were a father of two?
Yes.
And you were a father of two when that photo was taken?
Yes.
And is it your idea that your daughter had a beer belly?
I think the term was considered at one point maybe with retaining water or something like that. It's possible. I mean, I didn't believe that my daughter could be going to have a child right at that time, but stuff happens. I mean, it's...
Did anyone know that Casey was pregnant when that photograph was taken? Anyone outside?
Sustain.
Did you tell anyone at that time that Casey was pregnant?
No, not at that time. I did not know.
And when you were confronted with her pregnancy, you didn't want to talk about it, did you?
The first time I heard about Casey expecting a child is when Cindy and Casey came back to our house, and we sat down on the couch together, or very close to the proximity of our couch in our house. And Casey and Cindy told me that they have something that they wanted to tell me about.
And you didn't have a clue that Casey was pregnant up until that moment?
Like I said, maybe a feeling or an intuition to a point, but when they told me, I was elated. I was excited.
You have no problems with your vision, do you, sir?
No, sir, I do not.
Okay. And was there an explanation given by your daughter lived with you, did she not?
Yes.
Every day?
Every day.
And you saw her every day?
Pretty much so. I'd say probably 99% of the time I would see her, yes.
And 6 months prior to that photograph being taken, did you see her retaining water then?
Well, I really don't believe that you see a person or a woman. Each woman is made up differently. Each woman is going to show a pregnancy differently.
My question to you, sir, is 6 months prior to the photograph being taken, did you see your daughter retaining water then?
6 months? No, did not.
Have you, prior to Casey being pregnant, had you ever seen her retaining water prior to that?
When Casey was younger, I know she put on weight here and there when she was involved with athletics and things like that. Casey was a very athletic young lady growing up.
And when she was younger and putting on weight due to being in athletics, did the weight gain in her stomach or elsewhere?
Stomach, it could be in her hindside or her butt. Some people would consider it could be in her shoulders, and she would work out and it would sort of go away. She was an avid runner.
So as she was an avid runner, she would gain a belly?
No, I'm not saying that. I'm saying through her activity, if she shouldn't be running as much or being as active, I think anyone is going to put on weight with inactivity.
Now, you mentioned that you were in the delivery room. Is that correct?
Yes.
And you assisted in the delivery?
No, I did not assist. I was there and observed my granddaughter being delivered.
And you didn't know who the father was up until that day?
No, I did not. Did not know that.
You didn't ask?
Not up to that point I didn't, because when I found out that I was going to be a grandfather, Casey was expecting a child, and we went through the different tests, and we went...
My question to you, sir, is did you ask?
I think it was shortly thereafter, or right around, maybe just before she had delivery. I'm not sure of the exact time when I finally did ask. And I remember a name of Baker was brought up.
So the answer is yes, you did ask.
Yes.
Now, how soon after finding out that your only daughter is pregnant did you ask? Who's the father?
I don't know. It could have been, like I said, just prior to her delivering Kaylee.
So
I'm not really sure. I don't have an exact timetable. You're asking me to be specific.
Just a second. Please let the witness finish answering the question before there's another question.
Yes, sir.
Continue.
Are you finished, sir?
Yes. Okay. Yes, I am.
Now, after you find out your daughter is going to be giving birth to your first grandchild, how long after did she give birth?
Well, if I just found out in May or June, we had Kaylee was delivered in August, so it was over 2 to 3 months. You know, give or take a few weeks.
So in the entire 2 months, you never stopped your daughter and asked her, who is the father of this child?
Sustained.
You didn't ask her up until just before the child was born.
Sustained.
The day after.
Hello, everyone. Tamara Holder here with the LawNewz Network. I am guest hosting today, and I have on Skype the wonderful Beth Karras, who covered this trial really from the beginning. And she was in court for pretrial motions and jury selection and everything from even before the trial started. So, Beth, are you there?
Yes, I am. I hear you loud and clear now. Sorry for the problems earlier.
That's okay. I'm sorry for the problems. I'm not a techie, so I have no idea what happened, but good to have you. Thank you for waiting. So I want to ask you first, because you know everything, so I'm just going to throw a bunch of questions out. I'm sure that everybody just wants to hear your take on all of the different pieces and parts of this. I first want to talk about the search in August, where Kaylee was missing. She'd been reported missing for about a month. They had not found her. And there was a search in August, and she wasn't found. What do you know about that, and what do you want to share with the audience?
Well, just before you took the host seat, Tamara, I was listening to Cheney Mason's interview with Jesse, and he said the area where her remains were found, about a quarter of a mile from the Anthony home where Casey and her little daughter lived with Casey's parents, George and Cindy, that area had been searched by searchers and also the volunteer searchers, Texas EquiSearch, who help look for missing people around the country, and they parachuted into the area from it's late August until like September 7th. He says the area was searched. She was not found there, and that when the remains were found, Casey was locked up. She couldn't have put the remains there. What happened to her? Where was Kaylee in the interim? Okay, all good questions. What he neglected to say was that Tropical Storm Faye hit the area on August 19th, 20th. By the time Texas EquiSearch was searching, the area where Kaylee's remains were found were underwater. It was not searched because it was underwater. All right, and her remains, the way they were, the condition of the bones and her skull particularly, I've seen photos of that skull. Vegetation was growing up through it, indicating it had been there for a long time, for months. There was nothing to indicate at all that those remains were anywhere but where they were found from the time they were originally deposited, long before they were found. So it is believed, and the evidence supports, that those remains were there probably close in time to when she disappeared in June of 2008.
Which is what I was going to ask, that George Anthony, when he was on the stand, he said that the trunk smelled very strongly of a decomposing body. It doesn't really add up, or that alone isn't enough, because it takes some time, without getting too gory, for a body to decompose.
Decomposition starts immediately upon death. Yes, in terms of like liquefying and all that, and I'm not a scientist, that stuff, you're right, takes longer. It depends upon environmental factors. You're talking Orlando in the middle of the summer. If she indeed was put in that trunk after she died, or died in that trunk, it is going to expedite the decomposition process. There's all kinds of bug activity. We saw some testimony about that from entomologists who, at least I remember hearings with entomologists, because I had one sitting next to me during a live shot, and I had seen his testimony in a trial in California as well, regarding what stage of decomposition or how long the body had been there for certain bug evidence to be there. In any event, the odor may not occur within 24 hours, but she abandoned her car, what was it, on June 28th? Her parents picked it up on July 15th, and it was in the car where Cindy found, Casey had some stuff in there that she found Casey's friend's name and number, and as she went, she called that friend and then found her, and then the two of them went to Tony Lazzaro's apartment where Casey was. She had been lying for a month to her mother and her father about where she was and where little Kaylee was. And then, of course, her parents, called the police. Cindy called the police the next day, or not that night, and she got arrested the next day because Casey couldn't tell a straight story. She led the police down all kinds of dead ends about her daughter. If her daughter had drowned in the pool, and it was all a mistake and an accident, and George disposed of the body, why is Casey telling the police all these lies about a nanny? Why is she telling the police after she's arrested? And we've all seen the jailhouse video where she says, "You've been such a good father, and I love you, and you're a great grandfather to my daughter." None of it made sense. But it didn't matter, because the defense planted a seed, as you guys rightfully said, making George the bad guy. They deflected attention away from Casey, and as juror number 3, Jennifer Ford, has gone public saying, our finding of not guilty was not a finding of innocence.
Do you think that the tropical storm is essentially what saved Casey Anthony, for lack of a better word, because all of the evidence that could have been pulled, I guess a month or 2 months after she was found, Kaylee was found, was gone. But but at the same time, I'm trying to make this simple, but at the same time, she wasn't reported missing for a month.
Right.
So there was obviously going to be a lot of evidence, assuming that she was murdered around that time. We don't know really when she was murdered, but that makes it hard.
The defense would say, or if she was murdered, they say it wasn't a murder.
So accidentally died for defense purposes, which doesn't make sense, by the way. I don't believe that. But really, the question is, do you think that had it not been for the tropical storm, that there would be a different verdict?
Well, there certainly would have been more evidence, and that's a good question. If the storm wasn't there, it hadn't arrived, Tropical Storm Faye, the area wouldn't have been underwater, and her body probably would have been found. That around it had been searched.
Okay, so I want to switch, because we don't have you for very long. I'd love to have you for the whole day to talk about this.
For another half hour,
okay,
but
well,
I blocked out 12 to 1.
Okay.
Eastern, so.
Well, I want to talk to you about jury selection. Actually, first, let's talk about the pretrial motions, because that was outside of the presence of the jury, I presume. What did you make of that?
Okay, there were lots of motions as the defense was, I haven't reviewed the motions for today, but as the defense was trying to keep certain evidence out, what is interesting was that on December 11, 2008, Casey's now been charged with murder for 2 months. And there's been no body, right? The remains were not found, but the state was confident enough to bring the charges against her despite there being no body. It does happen occasionally. Very hard to get death when you have no body, because not having a body is the classic case of lingering doubt or residual doubt, which the defense can argue at the penalty phase. If you have a lingering doubt, if you have a residual doubt having no body, is there a possibility the person is still alive? So anyway, the state wasn't seeking death. They had taken death off the table or never put it on the table. Well, on December 11th, there was a hearing, and Jose Baez had waived any speedy trial rights at that point. I mean, he was going to litigate this thing thoroughly, and he did. I mean, Jose Baez was not that experienced a trial attorney at the time. He brought in a very experienced attorney, Cheney Mason, a very good attorney, and they were going to litigate it to death, and they did. That day, though, I remember sitting in a coffee shop. I've told this story a few times, but probably not to you guys. I remember sitting in a coffee shop next to the courthouse where my live shot was, and a lot of people were in there from the media. And I looked up at a TV monitor that was on in the restaurant, and there was aerial news footage, helicopter shots of an area being searched, a wooded area being searched, and the banner on the bottom of the screen said, body found, remains found, child remains found. Everybody raced out to their live shots, and I didn't have a mobile satellite truck. I was stuck at the courthouse. I had to stay there waiting for reports coming out of the Suburban Drive area. And indeed, I stayed in Orlando for the next 8 days. On December 19th, those remains were identified conclusively as Kaylee's. And that completely changed the case, because the state said, change circumstance, we now have the remains, and then they put death on the table. So that was a big deal. But many say the state overcharged here because you can't tell exactly when she died and how she died. A very effective argument by Cheney Mason at the end. The jurors said, yeah, they hung their hat on it. They're like, yeah, we don't really know what happened here. There's reasonable doubt. But as Jennifer Ford said, at least speaking for herself, it wasn't a finding of innocence. It was not a finding that Casey didn't kill her daughter.
Well, do you think also it was premature prosecution on the part of the prosecutors? They could have followed Casey around for a while, watched her moves, watched what she was searching for. I know that this is what the feds do a lot when they're following drug dealers and cartels and whatnot. They're following people. And she was charged so quickly that there really wasn't an opportunity to follow her and see what she was doing, give her an opportunity to talk to people out at the bar, because we know that she liked to party, or maybe visit the scene of the crime, which a lot of people do. We know that who was it? Scott Peterson went out to the harbor when he killed Lacey.
Right.
So there are behaviors that killers exhibit that the prosecutors didn't give her an opportunity to do because they locked her up so quickly.
Well, you're talking about a 2-year, 10-month-old child, right? She was going to turn 3 on August 9th. And they didn't know if she was dead or not. They didn't know if it was a kidnapping. So they charged her with child neglect right away. Yes, that was the charge, and then the lying to police, the next day on July 16th. Which was, by the way, the second day of Jodi Arias' arrest, when she started giving statements to the police. They were both arrested at the same time, same year. They wanted to find this little girl. They thought it might be a kidnapping. So I think that they wanted to put some pressure on her to try to find out where the baby is. They might have followed her around if circumstances were different, but here you had a vulnerable little child they were trying to find.
Right. Well, but by locking her up, it doesn't help them much, except, like you said, pressure on her to get a confession, which obviously she never gave, and she wasn't going to be helpful at all. I think
she's a great liar,
yeah.
A great storyteller, and a smart woman.
Yes.
She was in a room at Universal Studios. She was adamant that she was working at Universal Studios, and her parents believed she worked there. And the detectives had called Universal Security and knew she didn't work there and had said, look, we're coming by with her. Just act as though it's normal. So the detectives walk in with Casey just before she got arrested. And Casey's like strutting down the hall with the detectives behind her as though she's walking to her office.
Right.
And like halfway down this hallway, she finally stops and turns around and says, okay, you got me. I don't really work here. Then they take her into a room and they start interrogating her. We've heard those interrogation tapes. And it's unbelievable. With seasoned interrogators, with seasoned detectives, they couldn't break her. That young woman held her own.
What about, what do you make of the whole lie about Zenaida the babysitter? I remember when that happened, it was a wild goose chase and everybody was just crazy over this revelation. What do you remember of that?
Yeah, that's very interesting. Zenaida Gonzalez is the name that she gave, and she pointed to an apartment, I think it was like 208, at Sawgrass Apartments, and she pointed to it. That's where she took the police the day that Cindy reports Kaylee missing. So it's the evening of July 15, 2008. She's in the back of a police car, and she's pointing out landmarks and places, and that's where I dropped her off. That's the last time I saw her. Of course, Casey is wrong. At first, she says June 9th, and then she does her math and realizes, oh, June 16th. But she did give the wrong date at first. So the police go to, they check out Sawgrass Apartments in the next day or so, and they find out that the apartment she said Zenaida lived in had been vacant since the previous February. But interestingly, a woman named Zenaida Gonzalez had filled out a card at Sawgrass Apartments to be, to apply, to be on a list, something like that. But it wasn't the Zenaida Gonzalez who ultimately sued her because that Zenaida says her reputation was hurt because people thought she was the nanny. There was never a nanny, but Casey had given a physical description of somebody, not the woman who actually who sued her. Some people say Zanny is the nickname for Xanax, that maybe she was drugging her daughter. Some people think that Kaylee was getting to the age where she could talk, she'd be able to communicate, she'd be able to tell her grandparents, Cindy and George, what she was really doing during the day. Casey's password on her, I think it was her MySpace and Facebook, was timer 55. From the time that Kaylee went missing on June 16th, at least the last time anyone saw her, outside of besides Casey, no one, no number of friends, Tony Lazzaro, the boyfriend, nobody saw Kaylee. June 16th was the last time anyone outside had seen her, and that was George. Timer 55 was a number of days to Kaylee's third birthday, from June 16th. So there are all these little clues that people started putting together, saying, oh, maybe she was counting down. She knew that by August 9th she was going to have to tell her mother where her child was because she couldn't keep lying to Cindy, but of course she got discovered sooner. It's a mess. To me, at a minimum, she should have been convicted of child neglect. Who doesn't report their child missing?
So because Casey was found not guilty on all charges except lying to the police. I want to really focus on what you think the flaws are flaws were in the case, where the prosecution went wrong or the police went wrong, what the defense did right. I also have Aaron Keller here, who you can chime in when you want. But Beth, you were really in there. Starting with the motions, what motions did you see where you thought, wow, that's a point for the defense, or wow, that's a point for the prosecution? Anything that comes to mind? If not, I'll move on to jury selection.
Let me just say, because I don't have all the motions in front of me, so I don't know if I can answer that really well, but let me just say that maybe seeking the death penalty was too much for the prosecution. I suspect, I didn't hear Jeff Ashton's interview yesterday, but I've spoken to Jeff. I've stayed in touch with him. I don't know that he would have done things any differently, except a computer search that they screwed up on because they only checked an Internet Explorer search engine. They didn't check Firefox, which is what Casey used to use, and even Jose Baez says later, I can't believe they didn't find, the stuff that we found, which was very incriminating about, this is on June 16th, a search on Firefox for suffocating, how to suffocate someone. So, but I think that probably seeking death was made it too hard for the prosecution, because you can't tell exactly how she died or when she died, even though the state's position was the duct tape, which I saw the photos of the skull picked up out of the muck, and these two or three layers of duct tape were not, there's no tissue on the skull, but hair was still attached. The hair fell into the back. And the duct tape was still attached to the hair, and it appeared that it was over the front of the skull as though it had been covering the nose and mouth. The width was enough to cover on her little skull, nose and mouth. So I think probably the biggest issue was the way it was charged. Also, the defense was masterful in jury selection. They say cases will rise and fall on your jury. That's absolutely true. In jury selection, which was in a different county, in Pinellas County, which we could all watch. Actually, it wasn't at jury selection. I watched it because they allowed a television camera. We just couldn't show the jurors. We heard it. The defense started planting the seed of sexual abuse. So from jury selection, they were advocating their position that Casey was sexually abused. They did it in sort of general terms. Then an opening statement, Jose Baez comes out with his bombshell. There was no murder. The manner of death was accidental. It wasn't homicide. It wasn't natural causes. It was accidental. It was an accidental drowning. And then George and Casey basically covered it up. And she was too afraid of her father because of all the sexual abuse. So I remember thinking after the opening statement, which blew me away, thinking, wow, Casey has to testify. Unless George admits it, there's no way through the rules of evidence to get in evidence of sexual abuse unless Casey testifies, which of course she didn't do. And the defense has a right to change their mind and not put her on. So they were able to plant these seeds of sexual abuse with zero evidence of it, zero evidence of sexual abuse by George. And jurors didn't like him. They didn't like him because of these seeds that were planted that were never substantiated.
Do you think that if that opening argument, even though it's an opening statement, but the opening position, if you will, of sexual abuse, if that was not part of the position of the defense, that Casey would have been found guilty? Do you think it was just that was enough to change the jurors' minds, that this was not a case guilty beyond a reasonable doubt?
Well, listen, George didn't help himself. Demonizing George was great, and there was a lot to work with, not just this statement of sex abuse that was never backed up, but George attempted suicide in January after the body was found. He attempted suicide. People, gave the defense an opportunity to argue that he felt guilty for what he has done, for his role in all of this, when in fact he was just simply depressed. He was despondent over what happened to his granddaughter. He didn't have anything to do with it. And also he had an affair with somebody who was a volunteer during this, and that person testified. Crystal Holloway was her name. She testified for the defense, and she said that George told her that he believed this was an accident that snowballed out of control, that played right into the defense's hands. So they had a lot to work with. If they didn't have any of that and couldn't demonize George in any way, I think it would have been a very different case. However, I don't know that she would have been convicted.
Why not?
Jimmy Mason was very good. Now, Jose Baez is very good in addressing the jury, he was still kind of green when it came to the rules of evidence and getting evidence in, but he had Cheney there, and he had other more experienced attorneys there with him. The judge could be hard on him a few times, but when it came to standing in front of that jury and addressing them, he was pretty smooth.
What do you think was missing then in this case? Was it forensic evidence? Was it? I mean, obviously, we're looking into a crystal ball here, but
I know I don't know, Tamara. I don't know. What if they weren't seeking death? If maybe they only charged manslaughter, a lower charge, maybe they could have. But there was one incident that I've spoken of a few times, where the media had to sit in a balcony. The courtroom was kind of state of the art at the time for televising trials and for a high profile case, and the media was in the balcony, so we had a bird's eye view of the courtroom. And in the public gallery down on the main floor, some media could sit, but that's where the family and friends and other people were. So I was always up in the balcony looking down, and looking down facing the judge. The jury was on the left, and the defense table was directly across from the jury. Instead of being next to the prosecutor, across from the judge, there were so many on the defense team that they put a long table, put tables together. It was a long table, like the length of the courtroom. And they sat Casey, I think, in a lower chair because she looked really diminutive. She's 5'2". She was like 105 pounds when she was arrested. She's little, but she even looked littler. And they dressed her in dowdy clothes, and her hair was not the image at all of the hot body contest that she engaged in on June 20th, just days after her daughter disappeared. And I was watching the jury one day. We all had to wait till the jury filed out when the court was in recess. And I'm watching, and I'm standing there just waiting, and the jury, a young man who was a gym teacher who became the jury foreman, but we didn't know that at the time. He became the foreperson. He stood there, and he looked across at the defense table where Casey still was, and he lingered for a minute, looking in the direction of that table. I have no idea if he was looking at Casey, but he was a young, good-looking guy, age appropriate for her, and he was looking over in that direction, and my heart skipped a beat, and I thought, uh-oh, red flag here, because this guy's connecting with Casey. And indeed, he led the jury to an acquittal. So, a different part of the country, it might have been a different result.
Do you think that there's a lot of that in jury trials, what you just brought up about the fact of one juror having this crush or affair, mental kind of affair with a defendant? Because it seems like that happens more often than not.
Well, you got to have a likable defendant, I mean, you got to have a likable defendant, right? And she didn't testify. All this young, good-looking guy knew about her was what each side said in the photos of her, and he could just look at her. And she would cry. You guys were talking about that. She would cry. She had all kinds of, she had a range of emotion. I think you were mentioning that, Aaron, and that's true. She would be crying a lot. She might smile sometimes, shake her head, nod her head. That's how she emoted. That's all we got from her during the trial. So, I mean, I don't know, in hindsight, what would have made the difference? An Orlando jury might have convicted her and not a Pinellas County jury.
What do you make of her reaction when her father was testifying? Because she was very stoic. It seemed, what we had just played before you came in, that she was pretty stoic, and then towards the end she shook her head a lot, and there was a lot of nonverbal communication. Do you think that helped her?
Well, since she was acquitted, yeah, I do. She was basically sending a message to jurors. If any of them were watching, I don't know that they were, but if they were looking over at her while George is on the stand, she's basically saying, no, that's not true, don't believe him. So, that's good for her.
I want to continue again, or continue more about the jury selection. It was 7 women and 5 men. What was the conversation like once the jury had been selected? If they were... everybody was happy. I mean, nobody's ever happy in a case. But were there any issues with the jurors that you can remember?
No, not that I remember with that jury. Of course, to be sitting on a capital case, they all had to say that they could, under the right circumstances, recommend the death sentence. Now, at the time, the death penalty scheme in Florida was they just needed a majority vote. 7 votes or more one way or the other, was a recommendation or an advisory sentence to the judge, and then the judge sentenced. That has since been overturned by the U.S. Supreme Court in a Florida case, Hearst v. Florida, and Florida now has to be unanimous in the death penalty phase. But it was one of a couple of states. I think the only other state that doesn't have unanimity at the penalty phase is Alabama. That should be overturned also because it violates another case, Ring versus Arizona from 2002. In any event, where facts, if certain facts have to be found that go to sentencing, they have to be made by a jury, not a judge. That's what Ring stands for. And in Florida, they were still allowing the judge to make the ultimate decision. Didn't get that far in Florida, but jurors were all death qualified, right? And death qualified jurors tend to be a little more pro-prosecution. Wasn't the case here, though, obviously. This was a huge win for the defense.
It's interesting, though, because you said in the beginning of this conversation that you believed that she was possibly overcharged, that the jury looked at her and said, we can't convict her of a death penalty crime. But at the same time, to get on the jury, they have to say, yes, I can do it. So right. It's something that may change over time, where finally, once closing arguments are complete, then they say, wow, even though I said I could, I can't with this one.
Right. I mean, that's obviously what happened. I'm not saying I don't think she murdered her child. I'm just saying that maybe seeking death was too much. I don't think Jeff Ashton would agree with me. I mean, and he knows more than anybody about the case. I know, what I covered, and a lot of discovery. 25,000 pages were released. It's one of the only states that allows all police reports and motions and everything. I mean, not just a court file, but transcripts of depositions. They take sworn statements in criminal cases of material witnesses in Florida. So we had 25,000 pages of discovery. Everybody knew this case. Everybody knew the prosecution's case. Nothing new came out. We just wanted to see how it unfolded in the courtroom. What was new, of course, was the defense. But I probably just wandered off your question. I'm not sure what it was.
That's okay. That's a good segue for me to introduce Aaron again, because he has a question.
Yeah, Beth, so I think you probably listened to the entire interview with Cheney Mason, and apparently at one point he said in the interview that his explanation for what happened is that Casey Anthony blacked out.
Here we go, Jodi Arias blacked out at the time of the crime. I didn't hear that. I didn't hear that, Aaron. I checked in, toward, closer to my time to Skype in, and I said, oh, I forgot Cheney was on, and I was listening, and that's when he's talked about how the area was searched, and her body wasn't found. It's like, wait a second, let's talk about Tropical Storm Faye here. But that blacking out, I don't remember that from the trial. Of course, she didn't testify, so I don't know how they would have gotten that in without her testimony.
Well, it seems that everybody now is jumping in and relitigating this case several times over again. The defendant has given one major interview to the Associated Press, and we have the various attorneys coming out of the woodwork. The judge has said that he thinks that the defendant tried to use chloroform just to sedate the girl and wound up killing her. Okay, so apparently this is a new one on me, though, the old defendant blacked out litany that we always seem to hear in almost every murder case in some degree or fashion. It surprised Jesse Weber, who was the one conducting the interview, but I didn't know if it rang a bell to you or if you just think this is more hogwash getting thrown into this debate.
Probably hogwash. I hadn't heard it before. Aaron, I find that interesting because we heard about I was in a fog, not blacked out, but in a fog. That was Jodi Arias. At the critical moment when she's describing killing Travis Alexander, she can't recall because she's in a fog. Well, that's what this sounds like, too. Maybe it does happen that when somebody gets so, upset that they engage in conduct that is, whatever, you're killing somebody, you're stabbing them, you don't remember. I know that, we heard this in, I think, the case in Minnesota of the police officer who was just acquitted of killing Philando Castile. Didn't he say that or maybe it was Ray Tensing in Cincinnati, that he didn't realize he fired so many shots. So sometimes in the moment you don't realize what all your actions are. So, maybe it does happen. I don't recall ever hearing that about Casey, but Cheney talked to Casey. He knew her story. Did anybody mention that Belvin Perry, didn't Belvin Perry, the judge, tell after he left the bench a story of how the defense wanted Casey to consider a manslaughter plea in the middle of trial, and she refused? I mean, if they were so convinced that she didn't do it, why were they encouraging her to take a manslaughter plea?
What else? What other evidence did you see throughout the case and pre-trial, or just discussions that, with investigators that wasn't presented to the jury? Is there anything, or and part of that other question is there something that the prosecution that you think they forgot to bring something up that you were looking at it from the outside in, saying why aren't you asking about X? Okay. Is there anything like that that comes to mind?
There's stuff that they couldn't bring in because it would be like double hearsay. Casey's brother Lee, he testified, but my recollection is that he didn't admit to something that he told a friend, and the friend was interviewed by the police. So it's in the deposition of the friend, but the friend is repeating what Lee, the brother, said, and Lee didn't say it on the stand, which was that the day before Kaylee was last seen, right? She's seen on a Monday at 12:50 p.m. George sees Casey and Kaylee leave. The day before was Father's Day, and there was, according to this friend of Lee, there was a fight inside the Anthony home. I mean, look, Casey, was young. I mean, she didn't originally want to have the baby, and Cindy said, no, you're going to have this baby, when she got pregnant at 19. And Cindy had threatened more than once, so I've read, that to adopt Kaylee, to file for adoption, in full custody and adoption, if Casey didn't start acting more motherly. Although all Casey's friends say she was a good mother. Anytime they saw her with her baby, she was a good mother. So there wasn't any evidence that she was abusive or neglectful of her daughter. Yet this friend says Lee told him there was a big fight in the house and between Cindy and Casey. So it led some to speculate that Casey was like, maybe the fight was over, Mom wants to take my baby. She wants to adopt my baby. Because Casey had a new boyfriend and a different lifestyle. Like, she started going to clubs, and she had a new boyfriend, and maybe she wanted her freedom, is the theory. But it was never, no one ever ultimately admitted to that fight in the house, that maybe Casey left the next day saying, you're not going to have my baby, and nobody's going to have my baby, and killed her. But I don't know. I mean, they couldn't substantiate it, and Lee wouldn't admit that.
So I want to play, you're not going to be able to hear it, Beth, but I'm just going to give you a little bit of background. I want to play a clip, CA4C to the control room, where the judge explains that it's normal for the witness to discuss testimony with their attorneys prior to court. I don't know if you remember this, but it was a big discussion. So we're going to play that for our audience.
Okay.
Ladies and gentlemen, the jury, the court at an appropriate time in talking about judging the credibility of witnesses, the court will instruct you it is entirely proper for a witness to discuss their testimony with their attorneys prior to them coming into court, and that a witness should not be discredited by talking to an attorney. Instruction will read exactly: it is entirely proper for a lawyer to talk to a witness about the testimony the witness would give if called into the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may continue.
You currently...
Oh, we're back. Beth, were you there during that exchange with the judge?
I couldn't hear it, but I probably was. I mean, I was inside the courtroom, or at least listening from the satellite talk almost all the time. But I couldn't hear what he was saying. If he was telling them that it's common for lawyers to prep their witnesses, then I mean, I've heard that so many times from judges telling jurors that there's nothing unusual in that.
What did you make of the judge's exchange with the jurors and in the courtroom as a whole? Because as an outsider, I was just started doing legal analysis. He was a very strong presence in a case from the outside looking in, you were there. What do you think?
Oh, yes. Belvin Perry was no nonsense. This wasn't the first trial of Belvin Perry's I had covered. The very first trial I covered at Court TV, that was a death penalty case. My first death penalty case covering was an Orlando case, moved to Naples, and it was, I think, a 1995 murder. The trial was probably 96 or 97, and Belvin Perry was the judge. So he went to Naples with the trial, and Jeff Ashton was the prosecutor. So, I mean, I knew what Belvin Perry was like, but he's no nonsense, and he would tell new lawyers in his courtroom, the train leaves at 8:30 a.m., you better be on it, and you better be prepared. So he was one of these judges who was very punctual. You could count on him. If he says he's going to take the bench at a certain time, he's going to. He had, you know, a good rapport with jurors, but he was tough on the lawyers on both sides, and sometimes in front of the jury.
Do you think that's because of, like you said, one of your first cases that you covered was with him? Is that experience as a judge in the eyes of the media, he knew, or was he always like that from the first time you covered him? He's just a straight shooter kind of guy.
I think that he was always like that. That's who Belvin Perry was. I haven't spoken to him since he left the bench, but I've always respected him. I think he was a great judge. I mean, I respect most of the judges in the cases I covered.
Aside from respecting him, were there any rulings that he made where you thought were favored one side more than the other, or weren't fair?
You know, I don't remember any particular rulings, although he's a former prosecutor, and so a lot of people thought, you know, he came down more on the prosecutor's side. He wasn't always with this case. Stan Strickland was the judge before, who originally had this case, and he recused himself. There was a motion to recuse when he invited a blogger up to the bench, and he just complimented this blogger from that area in Florida, who had been blogging, I think, some kind of anti-Casey things. And so the defense is like, hey, you shouldn't be calling somebody up who's a journalist, blogger, to comment that you enjoy his blogs. And he ultimately recused himself. There could have been another reason, too, but that was the final straw.
Yeah, it seemed like, I'm glad you brought that up, because I was going to ask you, it seemed like kind of a weak recusal on his part. Do you think it was that he realized the amount of pressure that this case was going to have on his life and thought, look, I'll leave now?
Could be. You know, it is absolutely the case that in a case of this kind of profile, and this was a really big one, your life is under a microscope, and the press is going to scrutinize everything you do to the 10th degree. So perhaps he thought, I don't need this. Belvin Perry, I think, was the chief judge at the time, so he simply took it over.
So with regard to Casey, she, as we've discussed, and everybody, I believe, knows that she did not testify. Do you think that because she was such a good liar that's why they didn't put her on the stand? Or do you think that if she was on the stand, and I know this is all just throwing stuff out there, but there's nothing else to do, the trial's over 5 years, 6 years ago. But do you think that had she testified, there would have been a different outcome, because she was a great liar?
Well, you know, in the end, they didn't need her, right? The defense didn't need to put her on because they got the result they wanted. I mean, they must have seen that there were enough holes in the case and that they had demonized George enough that they could just ride on that and not have to put her on the stand. I don't know if they ever seriously entertained putting her on. It is a decision that defense lawyers will make as the case unfolds, and they'll see if they need it. And self-defense cases cry out for a defendant to testify because they're basically saying, I did this, but it's not criminal conduct, and here's why. Please don't label me a criminal. But that's not the case here. So, you know, if she had testified, you know, she would have gone head-to-head with Linda Drain Burdick or Jeff Ashton. One of those two would have cross-examined her, but she took on the detectives really well. And I don't know. I don't know what would have happened, but she probably would have hurt herself in the end if she had testified.
Can you explain for the viewers, and we went over this a little bit earlier, but I just want you to clarify the idea that George Anthony molested Casey, that came in the opening statements. I believe you said that it also came up earlier in a motion. I feel like it's hard to understand that the relevance of it in the legal term. How is this relevant to whether or not you killed your daughter? How did that get in?
Okay, so my understanding is the prosecution learned about 6 weeks before trial that the defense was going to be pointing the finger at George, and this is what they're going to be saying. what they needed was an explanation for why Casey was such a big fat liar. And this was their explanation. Her life was living a lie. From the time she was a little girl, she would get on the school bus after her father, and then Jose Baez was very graphic, but after she had to perform oral sex on her father, she'd then get on the school bus and act as though, everything was normal and that this happened for years. This is what he said in his opening statement. It was very powerful stuff. There had never been any indication of this, yet he dropped this bomb. And that's why I thought, wow, Casey's testifying, because there's no way the jury will hear this. Unless George admits it. So he's the very first witness that Jeff Ashton calls, and right out of the box, first time on the stand, he's like, no, I didn't do this. But by then the jurors are thinking, yes, you did, and you're lying. You're looking down while you say it, and you're lying. So jurors obviously didn't like him.
Is there anything else, I know that we've taken up a lot of your time, is there anything else that you want to share with the audience about your experience in this trial that really stands out, you want people to know that you weren't able to talk about at the time, or just reiterate?
Well, I just want to say that I was sitting in the balcony when the verdict came in, and I had to, exhale, because it kind of knocked the wind out of me. I was like, whew. I took a big exhale and sat back. I was like, wait a second, did I just hear 2 not guilties, and then a 3rd not guilty, and then 4 guilties of the misdemeanors? She got a year on each one of those, by the way, a year in the county jail, and then she got credit for time served, and then she had to serve just another 2 weeks, and then she got out. So I went back when she got out from the jail a couple weeks later. It was the end of July. She was acquitted and convicted on July 5th. And then on appeal, the appellate court threw out 2 of them. So she has 2 misdemeanor convictions only, and it was just time served. As long as it's misdemeanors, you can do your time in the county jail. Right. So I thought, well, that's the least they could do was convict her of for lying to police. I thought the police did a good job. I don't have any faults with the police. I thought Jeff Ashton tried his best to get some new science in. The judge was allowing the odor of decomposition, but the jury didn't buy it, and the defense also was able to poke some holes in it. It's still an area that, we allow cadaver dogs, then how they alert to the smell of decomposition. We allow that testimony, but they didn't, the jury didn't buy, and the defense was dismantling the smell of decomposition by humans who are familiar with the odor. Didn't work. It can work for dogs, but not for humans. One other thing I want to say, where the car was towed, and I forgot to mention this earlier, the lot where the car was towed, and it was there for 2 weeks before the Anthonys got the notice they had to go pick up this car. The guy testified, it was a hearing or at trial, who ran the lot, saying, yeah, that car, Casey's, smelled like another car we had here before, where a man had died in it. I don't know if it was suicide or a natural death. He had died in the car, and they didn't know he was in the car. So it was some days before his body was found. He said it was the same odor. Well, that was pretty powerful stuff.
Aaron and I were talking about the fines that the court imposed on Casey. It came out to about $217,000 in search fines for the police and the prosecutor's office and whatever else. Do you see that a lot in your reporting in the courtroom, where there's somebody who's been found not guilty and then they still make the person pay?
Well, she was found guilty of lying to the police, and she led the police on all kinds of loose, wild goose chases, right? So I think that's probably why, because she was lying to them. I think that if this had been an acquittal all across the board, she obviously wouldn't be fined unless it were in a civil case. And sometimes when a defendant is indigent, it's a little unfair also to assess hundreds of thousands of dollars when they're indigent. For though, she had licensed video and photos, or maybe Jose Baez got the money, because Jose Baez worked for no fee, so I think he might have received the licensing fee for her video and photos. I'm not sure.
All right, Aaron, do you have any Any questions?
Well,
for Beth?
it just seemed kind of odd that would have happened, because I'd really have to poke through my rules of professional conduct. That I didn't realize that an attorney could get a licensing fee for a client's photos and then accept that as form of payment. I'm gonna have to really.
He waived a conflict. It's a very yes, your red flags are up, Aaron. You're a good lawyer. There was a hearing about that. There was a conflict of interest. I mean, whose interest did he have? You know, his clients or his own in trying to get the biggest buck for the video and photos? But she waived any conflict, so it was not an issue.
All right, Beth, we are going to let you go for the day. You've been so wonderful. Thank you so much. It's nice to see you.
Likewise. Take care.
Thank you. And the viewers, we are going to play another clip. I believe this is, again, of George Anthony. Let's see, state questions of George Anthony.
In those areas?
Since Mr. Bias has raised it, tell us about the Sports Authority incident when you went to check on your daughter's work situation. What happened?
When I arrived at Sports Authority, I went inside and was met with a younger gentleman at one of the cashier areas. And I introduced myself. I said, I'm George Anthony. I'm Casey's father. Is Casey here? And the gentleman said, who's Casey? And I said, Casey Anthony. And I give her a brief description.
Sustained.
Your Honor, it's not for the truth of the matter asserted. It's simply to establish.
Mr. Bias, she didn't hear your objection.
If I
Go
may,
ahead.
it's not for the truth of the matter asserted, just to establish the events that flowed from the statement. I would ask the court to reconsider.
Sustained.
Now, based upon what the gentleman told you, what did you do?
I got a little concerned and I asked to see the manager.
And did you have additional conversations with him?
I had
Without telling me what they were, did you have additional conversations with him?
I had more conversation with the manager and found out that my...
Don't tell me what they said. Now, after that conversation, what did you do?
Knowing that Casey was not there, I got in my car and left.
At some point, did you address this issue with either your wife or your daughter or both?
First time I addressed it with my wife, Cindy.
All right. And tell us about that conversation.
It was not the best conversation to have with Cindy at the time because of feeling that I was invading Casey's privacy to a point, following her. Just should have just let it go and not
been
the detective of the house to go find what was going on.
Was your detective work well received by your wife?
No, it was not. It was not.
Did it create additional strife in a relationship that you were trying to repair?
Slightly, but we worked through it.
Did you address this with Casey as well?
I don't remember if I really addressed it immediately or if it was a short period of time after, or we just had a brief discussion. I don't think it was anything that was that bad. You
just let it go.
Just let it go.
Now, can you tell us when, in relation to the last time you saw Kaylee, this would have been the same year, the year before? Can you give us a general idea?
The last time I saw my granddaughter Kaylee was June 16, 2008.
I mean, the Sports Authority incident, when was
Sports
that?
Authority, I'm sorry.
Yeah,
Sports Authority incident, I believe was towards the end of 2007, could have been the early part of 2008. I'm not really sure of that generality of the time, but I know it wasn't all that long ago.
Now, let's talk about Mr. Kelly, the attorney that counsel asked you about. Had he done some work for you in the past?
He was my workers' comp attorney when I had a couple different injuries. He took care of that for me.
And how far back was that he worked as your attorney?
Overall.
How far back was it that he had actually worked as your attorney?
He helped me 2 different occasions. One time was in, I believe it was 1995, 1996, and again in the early part of 2000.
Subsequent to that, had your relationship with Mr. Kelly changed from lawyer-client to something more personal?
Oh, we've been just great friends for nearly 20 years.
And did you and Cindy socialize with his family? Did your kids socialize together? Was it that kind of relationship?
We've been out to dinner a couple different occasions, been to his home and shared a meal at his home with him and his family.
And when you had him come to your house the day, I guess the day after you found out Kaylee was missing, was he there more as a friend or more as a legal advisor?
Our friend, but also legal. I mean, it was a combination of both because Cindy and I didn't know where to turn, except to turn to someone that we considered our friend and had legal knowledge. So we were reaching out to just get some help.
How would you describe your emotional state on that day, the 16th of July, the day after everything was revealed, and the day that... How were you feeling? What were your emotions then? No, I believe this is the date that counsel was referring to.
Overruled.
Just tell us that.
Very tired, very edgy. Hadn't had nothing to eat or drink since probably earlier the day prior to that. You talk about running on fumes. I mean, you're going in so many different directions. It's hard just to sit down and just concentrate on one particular thing because your whole main objective is to find your missing granddaughter. That's whatever it took. I mean, to say how exactly I felt that day, I do know that we were just devastated.
No further questions.
Okay, may the witness stand down.
Subject to recall.
Yes. Okay. Thank you, Mr. Anthony. You may resume your seat. May...
This piece of molding is coming off.
Okay, we'll take care of it. Thank you, Mr. Anthony. Okay, ladies and gentlemen of the jury.
Hello, I'm Tamara Holder again. I'm here guest hosting on LawNewz, and that is Aaron Keller's hand that just went across the screen.
Well.
We are here discussing the Casey Anthony case. That was George Anthony Casey's father who was testifying against his daughter. Obviously, it wasn't a good enough testimony because she was found not guilty of all of the serious crimes against her, most serious being first-degree murder charge of her daughter, Kaylee Anthony. The reason why we're discussing this case is because it is the 6th anniversary, yesterday was the 6th anniversary, of the not guilty jury verdict. We are going to go into another clip. This is now a new witness. This is Anthony, or Tony Lazzaro, who's the ex-boyfriend. And he has some very interesting testimony to share.
Okay, the state may call their next witness.
Thank you, Your Honor. The state would call Anthony Lazzaro.
Sure. Anthony Lazzaro, and THONY-LAZZARO.
All right. Mr. Lazzaro, kind of take your time and speak directly into that mic. And when you go back and forth, it causes a few problems, but just take your time, speak distinctly. Mr. George, you may proceed.
Thank you very much, Your Honor. Good afternoon, sir.
Afternoon.
You are Anthony Lazzaro?
Yes, ma'am.
Do you go by Tony?
Anthony, Tony, don't matter to me.
Mr. Lazzaro, how old are you?
I am 24.
Are you currently living in the state of Florida?
No.
Where do you live?
I live on Long Island.
In New York?
Yes.
All right. How long have you lived there?
All my life.
Was there a time that you lived here in Orlando?
Yes, when I went to Full Sail University.
And when did you attend Full Sail University?
From 2007, August of 2007 to August of 2009.
We've heard a little bit about Full Sail. Did you graduate from Full Sail?
Yes, sir.
And what did you get your degree in?
Music business, bachelor's in music business.
Is that a BA?
That's a BSc.
BS. Are you currently working now?
Yes, sir.
What do you do?
I work at Best Buy, and I'm interning at a record label.
When you were attending Full Sail here in Orlando, where were you living?
I lived at two different places.
Okay.
First,
Well, let's talk about where you were living in May, June, and July of 2008.
Sure. Sutton Place.
Do you recall the address there?
Not the exact numbers, but it was off of University Boulevard.
It was off of what?
University Boulevard.
All right. Do you recall when you moved into Sutton Place?
I believe it would be either the end of August 2007 or the beginning of September 2007.
When you moved into Sutton Place, with whom did you live?
What? Excuse me?
Who did you live with?
Cameron Campana.
And was it just the two of you there for a while?
Yes, sir.
Did there come a time while you were living at the Sutton Place apartments that you had other people living with you?
Yes. Two of my friends have lived off my couch, slept off my couch.
Who was that?
One was Clint, or Roy House, and Nathan Lezovich.
When they stayed with you, did they pay any rent or utilities?
No, it was just a friendly gesture because one, I believe, I can't recall why Clint stayed over. I think it was just some dispute with his other apartment, and I was just being a good friend and allowing him to stay on the couch because I didn't know where to go. And Nate, we were planning on moving into a new apartment together, so it was basically like I was waiting for my lease to end.
And were you actively looking for places to live during this time period?
Yes.
All right, let's talk a little bit about Full Sail. Does Full Sail run their classes, I guess, like any other college, where the semester starts in September and go to December? How does it work?
It's not like a semester at all. Literally, your semester is almost every month. You start new classes every month, and your schedule can either be consistent for a whole week or it can completely different change. And the school is open 24/7. Usually you're in class or lab at 4 hours of increments.
All right. So back in May, June, and going into July of 2008, what was your schedule at Full Sail?
I believe that it was not consistent, but I would say that I would have a morning class from 9 to 1, and then maybe sometimes an evening lab or an evening class.
Okay. What would happen at an evening lab?
What would happen in an evening lab?
Yeah, what do you do?
You would do anything that would be pertaining to that month. I can't recall actually what that month was, but I could be in a music studio working on learning music equipment, recording equipment, or just learning the technology for being a musical engineer.
As part of your tuition, did you receive a computer?
Yes, I did.
What type of computer did you receive?
MacBook Pro.
As part of your education at Full Sail, did you take it upon yourself, or were you required to put on either shows or do some sort of events?
They wanted you to get involved with the other kids because potentially these would be other people that you could be doing work with in the music industry. So, yeah, I mean, it wasn't like, oh, you have to do this, but it was a good thing to do, and it was an experience. So,
during the months of May, June, and July of 2008, did you take it upon yourself to try to set up either a small business or something along those lines?
Yes.
What did you do?
What did I do? I've had experience doing DJing, and where does that go? And me and Clint, I should say Roy House, decided we wanted to maybe start our own company, have a DJ company, and do a little promotion for nightlife.
Did that have a name?
I can't remember that name. I think we came through a bunch of different names for the company, but eventually what we did was DBC Entertainment. What became of that?
Did DBC stand for anything?
It was, if you want to get more into that, the people that we brought on as promoters that supposedly they were from Deerfield Beach County, and that's basically what I believe, from what I can remember, that was what it was for.
Now, when did you start actively working in this capacity as a DJ with Roy, with DBC?
Well, with DBC or before? Because we were actually
all right, I'm sorry. Let's start with before.
We actually did start before. We went to Fusion, and we were there for something else. I don't remember. But we met with the owner, and we approached him and said, "Hey, we're DJs. We have experience. We have some contacts with other promotion companies. Maybe if you're interested, we could come in and, maybe do a party on a Friday night." And he was all for it. So that's basically how that started.
When did that start, where you were putting on those shows at Fusion?
I want to say that started, I think we were in talks in the end of May and started in June.
All right. And at the same time, you were taking classes?
Yes, sir.
All right. During this time period, did you own a car?
Yes, sir.
What type of car did you own?
I have a Jeep Grand Cherokee.
What year?
97.
All right, sir. Again, directing your attention to May of 2008, did there come a time when you first became in contact with a person by the name of Casey Anthony?
Yes, sir.
Can you tell the jury how that started? How you met her?
Yeah, I met her on Facebook, simple friend request, and we became friends.
How did you find her on Facebook?
I found her through Facebook. At the time would show you how people in your area or people that go to school in your area, and would literally pop up, and I was like, oh, well, she seems like she's cool, friend request.
Did she immediately respond to you, or did it take some time?
I don't recall.
So talk about, if you would, your first contacts with her. Was it all through email?
Probably through Facebook, solely, if I can remember. I don't think anything more than that.
And did that continue for a period of time?
I would say so.
How long?
I can't recall.
A month, 2 weeks? Anything help you out there?
Probably. Nothing that long.
All right. Did there come a time when you decided to meet?
Yeah, okay. So first time we ever met in person was at my friend's birthday. His name was Dan Howard. This is right around the same time that I was starting up the DJ company.
Was this in May?
This is the end of May.
End of May.
Mm-hmm. Yes, sir. And we were throwing a party for him at one of our friends' houses, and I was inviting a ton of people online and made what you would call it a Facebook event. If you guys are familiar with Facebook, and literally just would send invites to everyone, and that's basically the whole point of that, to get a bunch of people to go. And I got that's when she got back to me to go to the party.
So you were expecting her to be at that party?
No, not until I got a response.
Okay. Well, I'm saying once she responded, you were expecting her to be at the party.
Yes.
All right. While you were talking and discussing, did you learn via Facebook, did you learn that she had a child?
I believe so.
Did you know the child's name at that time?
I can't recall.
Do you recall how old she was?
I just knew that she was a toddler.
So you finally met Casey Anthony?
Yes, sir.
And this is at Daniel Howard's party?
Yes, sir.
All right. What was your first impressions of her?
Pretty girl. I mean, I was kind of going back and forth, and I think she showed up with two of her friends, and we hit it off.
Okay. Do you recall anything? Did you recall anything that you spoke about on that first meeting?
On that first night, I don't recall what we talked about. Probably just, hey, how you doing? Nice to meet you.
Is it fair to say that night went well?
Yes.
Did you make plans to see her again?
I believe so. Not that night, but again, yes, we did make plans shortly after.
So shortly after meeting Ms. Anthony, did you start to see her on a regular basis?
Yes, sir.
How would you see her? Well, put it this way. Did you go to her house and pick her up to take her out on a date?
No, she would come over and show up to my apartment.
Now, when this first started, how often would she come over to your house?
A couple of times.
A couple of times a week? A couple of times? What does that mean?
More or less a couple of times a week.
Right. The first time she came over to your apartment, did she bring her daughter?
Yes.
Did the two of you stay at the apartment, or did you go out?
This is the time that we went to the pool. She brought her daughter over, and we went down by the pool.
Overruled.
Okay. We went down to the pool.
And this is at your apartment complex?
Yes, sir.
Do you remember when that was?
I would say June 2nd.
Do you know what the Arden Villas is? Arden Villas?
That's not ringing a bell too much, no.
Did you, after meeting her at Daniel Howard's party, do you recall inviting her to any other party?
I remember inviting her to a pool party shortly after that.
All right. Did she attend that?
Right.
I'm sorry, yes?
Yes, sorry.
Did she bring anyone with her to that party?
No, sir.
During this time period.
Hello, I'm Tamara Holder. You've been watching the Casey Anthony trial from 6 years ago. This is the testimony of Casey Anthony's ex-boyfriend, Tony Lazzaro, on the stand, and he will be testifying for a little bit longer. I have to sign out. It has been a pleasure to host this wonderful segment of Law News, and Aaron Keller will be stepping in after on the other side of Tony Lazzaro's testimony. Have a wonderful day.
In those areas. Okay, the state may call their next witness.
Thank you, Your Honor. The state would call Anthony Lazzaro.
If that's what falls on a Friday, then yes.
And that was for your showcase.
Yes, sir.
Did the defendant attend that showcase?
Yes, sir.
talk a little bit about how you, once you get to the venue, once you get to Fusion, we heard some testimony about some shot girls. Yes. Who hires the shot girls?
Who hired the shot girls?
Yeah.
It was between a choice between myself, Clint, and the other 2 promoters that were working at the time.
And who would instruct the shot girls as to what their role was and what they should be doing?
It was basically almost everyone told them what to do. Ultimately, it came down to the owner really just giving them, because they would have obviously a bottle, if you're familiar with how shot girls work. So they would have to buy whatever the alcohol is, and then they'd have to hand it out themselves. It'd be their own, what's the better word? Responsible for what they had in their hands. I do recall a time when I said that to help, I guess Casey wanted to help out, and I allowed her to, not allow her, but she just wanted to help. So I was like, oh, well, you could tell the shot girls, help keep them in line or whatnot, what have you.
Did she ever express to you that they had any ideas on what the girls should be wearing?
I don't recall.
All right. Now, in the very beginning of this relationship with Ms. Anthony, were you told by her whether or not she had a job?
Yes.
And what did she tell you?
That she had a daughter.
I'm sorry?
She had a daughter. I don't really remember the...
Okay, I'm sorry. Maybe we're getting lost here in the echo. Did she tell you whether or not she had a job?
Oh, she had a job. Yes. She had a job at Universal Studios.
Did she tell you what she did for Universal Studios?
Some with event planning, I believe.
Something with events?
Yes.
Did she ever, in the beginning part of this relationship, ever tell you any details about her job?
Throughout the relationship, she would always talk about specific things, that she had a job, specific people.
What kind of people would she mention?
I recall Jeff. I recall a couple other girls' names, but I can't remember their names.
Did she ever complain about her job?
I can't remember specifics. Pretty sure everyone comes home complaining about jobs. So she might have.
Did you ever see her with any identification from Universal Studios?
Yeah, she'd walk in the apartment with a Universal badge.
Did it have her picture on it?
Yes.
When you first met the defendant and you met Kaylee, were you ever told by the defendant who was taking care of her child while she went to work?
Her babysitter and her mother. Either or.
Either or? Did she ever talk to you with any specificity about what the babysitter's name was?
At that point, it was Zanny.
And this is in the beginning of the relationship?
Yes, sir.
Did she tell you anything about Zanny?
Did
she tell you? I'm sorry, let me break it up. Did she tell you where Zanny lived?
No.
Did she tell you if Zanny had any relatives?
No.
Did she tell you if Zanny cared for any other children?
Not that I can remember.
Did she ever discuss with you when you first met her what she paid Zanny?
Don't remember.
Did she ever tell you when the nanny would take care of her and when her mother would take care of her?
I don't. It would be either or. She would give specific times of when that she would say that she was with the nanny. I don't recall what your question. Your question is, does she specifically specify when this person would watch the baby and then this person would watch the baby this day? Is that what you were saying?
Yeah.
Oh no, I don't recall about that.
Your Honor, may counsel approach for a minute?
You may. We'll take a 2-minute recess at this time. Okay, state recognized presence of jury.
I do.
Defense?
Yes, sir.
You may continue, Mr. George.
Mr. Lazar, we were talking about June 13th, 2008. You were telling us about a hip-hop showcase that you were doing at Fusion.
Yes, sir.
Correct? To your recollection, was that the first time that the defendant went to Fusion with you?
Yes, sir.
I'm showing what's been marked as State's Exhibit, I believe it's BK. Do you recognize that photograph?
Yes, sir.
All right. What is that a picture of?
That is a picture of myself and Casey.
All right. I notice in this picture, well, are you guys standing or sitting?
You're sitting.
And was that picture taken in June of 2008?
Yes, sir.
All right. Is there a way for you, looking at that picture, able to tell us whether this picture was taken on June 13th, 2008, June 20th of 2008, or June 27th of 2008?
It would have to be the early June, because when I first started promoting, I would always wear a tie. As the month went by, I just aced the tie. So it had to be June 13th.
Is that a fair and accurate representation of what you and the defendant looked like on June 13th of 2008?
Yes, sir.
Your Honor, at this time, the State would move what's been previously marked for identification, BK, into evidence of State's number 5, I believe. 6? Or 6?
These photos, because I believe the last one was only addressed to the other photos.
You can approach the sidebar. Okay, objection will be noted. Objection will be overruled. You may proceed. Mr. George, you are offering that into evidence?
Yes, and just so the record is clear, I believe I misspoke and asked that it be entered into State's number 5. I believe that number should be 6.
Don't worry about what number it is. The
Okay.
clerk will tell us what number it is. Just offer it in the evidence with your identification number.
Very good. At this time, Judge, may I publish it?
Okay, it will be received in evidence over objections. Madam Clerk, would you announce the exhibit number, please? You may proceed, Mr. George. You may publish it.
Thank you, sir. All right. Was this showcase a success for you?
From what I remember, yeah.
Well, you had a few more coming up, correct?
Yes, sir.
Now, after this showcase, did the defendant return to your apartment with you?
Yes.
Did she stay over with you that night?
Yes.
Was this the first time that she stayed over with you?
I believe so, yes. Yes,
Sorry?
definitely, yes.
Okay. Now, did there come a time after June 13th that the defendant began spending more time with you?
Yes, mid to late June, definitely, she would stay over.
All right. Was there a time during this time period, after your Fusion Hip Hop Showcase, where the defendant basically lived with you?
You could say that.
I can say that. Would you say that?
Yes, sir.
All right. Did she come to spend every night with you?
Yes.
Directing your attention to June 16th of 2008, did you see the defendant that day?
Yes.
Approximately what time do you recall seeing her that day?
In the evening.
Was it early evening? Late evening?
Late evening.
Somewhere around there?
What's that?
Somewhere around, I'm sorry.
I would say anywhere after 6:30, 7 o'clock.
Okay. Do you recall going to a Blockbuster video?
Yes, sir.
Did you go to that Blockbuster with the defendant?
Yes, sir.
Your Honor, may I approach with a stipulation?
You may. Mr. Baez?
Yes, sir. I've seen it, and we stipulate.
Okay, y'all want me to read it into the record? You want me to read it into the record, Mr.?
Would you please, sir?
Stipulation between the state of Florida and the defense, Casey Marie Anthony. The copy of the video surveillance and still photographs taken from the video recorded at Blockbuster Video on June 16, 2008 at 19:54.26 hours are true and accurate representation of the business records of Blockbuster Video. The parties have agreed to this fact, and it should be considered as true in your deliberations. Stipulation will be filed here in open court with the clerk. You may proceed, Mr. George.
Thank you, sir. Your Honor, at this time, and unless this was already done, we would move the DVD of the video into evidence.
What is the identification number, Mr. George?
I'm sorry. L.E.
Based upon stipulation, is there any objections, any additional objections? Okay. Noting that and noting the stipulation as to what it purports, but noting the other grounds, it will be received in evidence as what, Madam Clerk? You may proceed, Mr. George. You wish to publish it?
Yes, I do, sir.
You may proceed.
Thank you. No. Sorry again. You know where to stop. Can I just stop it there? Mr. Lazar, do you see what's on the screen there?
Yes.
It's time stamped well, not time stamped, but the marker on it is 20.0.
Okay.
Do you recognize yourself in that video?
Yeah, that's the Marbury jersey.
I'm sorry?
That's my Stephon Marbury jersey, yeah.
And
Stephon Marbury jersey. He was a player for the Knicks. Sorry. Yeah, that's big.
So you recognize yourself.
Yes, sir.
You have your arms around somebody. Who do you have your arms around?
Casey.
Casey Anthony.
Yes, sir.
And this is on June 16th of 2008.
Yes, sir.
All right. When you went to Blockbuster with her that night, how would you describe her demeanor?
The way she was every day.
Which was?
Happy. Happy to see me. Having a grand old time.
On this date, at any time that you saw her that night, did she ever cry?
No.
Did she ever act scared?
Nope.
Did she ever act nervous?
No.
Did she tell you that her daughter had gone missing?
No.
Did she tell you anything about that there was something wrong with her?
No.
Or that something had happened to her?
No.
Was there any difference in this woman's attitude this night than it was for any other previous time that you had seen her?
No.
Did she stay over that night?
Yes, sir.
And from there on, did she stay with you?
Yes.
When she came over during this time period of June 16th, did she bring a suitcase?
I do not recall at that time.
Do you recall any of Kaylee's clothes being there?
No.
Any of Kaylee's toys?
No.
Stuffed animals?
Nope.
Books?
Maybe a book.
Okay. Any toiletries for Kaylee?
No.
On this night, do you recall her speaking with Kaylee on the phone?
Not that I recall.
Do you recall her speaking with her parents on the phone?
Like I said in previous statements, every time she ever would talk on the phone, she'd go outside. That's about it.
Well, this is while she was staying with you, correct?
Correct.
And we'll get to that. But on this particular night, do you recall her calling anybody
No, I do not recall.
while she was with you?
Yes, sir.
Be a fair statement that on this particular, by this date, by June 16th, this was still a rather new relationship.
Yes, sir.
Did you care for her? For Casey?
Yeah.
And as far as the relationship was going right then and there, was it going well?
Yes, sir.
Had you had any fights?
No.
Disagreements?
No.
I'm sorry, she stayed the night that night, correct?
Yes, sir.
The following day, did you spend with her?
Yes, I did.
Did you go to classes?
No, I played hooky.
You played hooky?
Yes, sir.
Why'd you play hooky?
Didn't feel like leaving bed.
Didn't feel like what?
Didn't feel like leaving my bed.
You'd rather spend your day with Casey?
Yes.
During this time period, did you, what was your phone number?
I've changed it so many times. I can't recall that one. It was an AT&T number.
Do you recall whether or not, just to go back for a second, back to the 16th, before you saw her at the Blockbuster, did you talk to her on the phone?
Yes.
Okay. Approximately, any idea how many times?
I can't recall how many times.
Do you know when you spoke with her in relation to when you saw her? Did you talk to her right before?
I would say right before.
During this day, before you went to Blockbuster, do you recall texting her?
Not that I remember.
All right, so June 17th, you play hooky.
Yes, sir.
Do you recall what you guys did?
Stayed in my bedroom.
During that day, was there any change in the defendant's demeanor?
No.
Did she appear to be happy to be with you?
Yes.
Did she so relate that she was happy to be with you?
Yes.
Did she give you any indication that there was anything wrong?
No.
Did she say anything about her daughter?
Not that I can remember.
Do you recall while you spent the entire day with her on June 17th that she attempted to call her daughter?
No.
Do you recall while you were with her on June 17th whether or not she ever called anybody in your presence?
Yeah, not in my presence.
You spend the entire day and night with her on the 17th?
Yes, sir.
How about June 18th? Did you spend the day with her then?
probably went to class.
Okay. When you went to class, what was your understanding about what the defendant was doing?
She would either go to school, go see Kaylee, or whatever she would do. She's a free woman.
Did she say, I'm sorry, did you say she went to school?
Just free. What? She would go to work. She would, wherever she would have to go.
Did she tell you where she had to go?
Not that I can remember. It was just a known fact of where she would go. It was an assumption.
Again, you were understanding she had a job.
I would understand that she had a job, yes.
You had indicated earlier from your testimony that your lease was going to run out at the end of August.
Yes, sir.
Is that correct?
Yes.
Were you looking for another place to live?
Yes.
Directing your attention to June 19th, did you go looking for an apartment on that date?
Yes, sir.
Did you go with the defendant?
Yes, sir.
Do you remember what apartment you went to look at?
Overall at this point.
The place that I originally, where I potentially moved into, Crane's Landing.
Okay. Where is that in relation to where you were living at the time? Is it close?
Yes.
How close?
Around the block, basically.
Okay. And when you went to check out this apartment, who were you planning on living with?
Nathan Lesnovich and my friend Brian.
When you went to check out this apartment, did you bring the defendant with you?
Yes.
Did you both look at the apartment?
No, I did.
How come she didn't?
I believe she didn't have identification on her.
During this time period, where was your understanding about the defendant's living arrangements? Where did she live?
She was living at home.
Did she, at this time, give you any indication that she was not going to be living at home?
Yes, she was always talking about her and Amy was going to get the Anthony's home because they were going to move out, or they were going to go get themselves their own apartment.
Did she tell you during this time period when the Anthonys were supposedly moving out of their home?
I can't recall the exact time, but it was all relevant into that at that point.
It was what?
It was all relevant to that time frame.
You mentioned the word Amy. Who's this Amy that you're talking about?
Amy Huzenga, I believe, was one of her friends.
When you first heard this name, had you met this woman?
No.
So.
No, I'm sorry. No, I met her. She came the night I met Casey.
All right. So the defendant was going to live with Amy?
Yes.
Either in the home or in another apartment?
Correct.
All right. Again, during this time period, did she tell you about her home life? Did she say anything about her dad?
Not at that time.
All right. Did she say anything about her relationship with her mother?
Not that I can recall at that point in time.
Okay. Right now, everything is just pretty good.
Yes, sir.
All right. Well, let's put it this way. By the 18th of June, were you and the defendant sharing secrets? Well, I mean, were you sharing any of your secrets?
Not that I can remember.
All right. This was a new relationship?
Yes, sir.
All right. So June 19th, you look for an apartment. June 20th, this is, did you go to Fusion again that night?
Yes, sir.
Was this another hip-hop showcase?
Yes.
And again, this is something that you promoted?
Yes, sir.
Did the defendant go with you?
Yes, sir.
During this hip-hop showcase, did anything different happen than happened the last time?
Yes. 20th, there was a hot body contest that happened.
Was the hot body contest something that had been promoted beforehand?
I can't recall if it was promoted beforehand, but it definitely was, I want to say, maybe a last-minute decision.
All right. And when you got there, Were there enough people to have a hot body contest?
More or less.
At some point, was the defendant asked to participate in that contest?
Yes.
Who asked her to participate?
I wasn't present for it. I was actually notified by her that said she was going to do it. And I was like, oh, I guess, okay. If you want to do it, you want to do it.
Did you have any objections to that?
Portion to be stricken.
Asked the hearsay to be overruled.
Just testified as to information he was given.
Sir, who gave you that information?
Casey did.
Okay. Objection overruled.
She told you she was going to participate in this contest.
Yes, sir.
Did you have any objection to her doing so?
I can't recall. I maybe hesitated for a second, but I said, hey, if you want to do it, you want to do it. So.
Now, you were actually present for the contest, were you not?
Yes, sir.
All right. And I don't know if we talked about this before, but since this is your showcase, what is your role?
My whole role that I took was basically making sure that nothing got out of hand. That was basically it. I made sure that, no one was harassing the bartenders. Basically like head security, if you want to say, more or less, of the night.
Did you entertain?
No, I did not.
All right. I'm showing you what's been marked for identification B. Oh, actually, I'm not showing you anything. Do you have a picture on your screen, sir?
Yes, sir.
All right. I'm showing you what's been marked for identification BR. Do you recognize that photograph?
Yes, sir.
All right. What is that a photograph of?
That is a photograph of the hot body contest going on.
I'm sorry?
The hot body contest going on.
Okay. Do you recognize Casey Anthony?
Yes, sir.
All right. What is she wearing?
A blue dress.
Is that the same dress that she came to the showcase in?
Yes.
All right. I know the picture's kind of cut off, but can you tell who's singing there?
That is Clint.
Clint House?
Roy House, yes.
And you were present while this was going on?
Yes, sir.
Does this appear to be a fair and accurate representation of the defendant participating in the contest on June 20th, 2008?
Yes, sir.
Your Honor, at this time, the state would move this exhibit BR into evidence as the state's next in line.
Mr. Bias?
Yes, sir. We object. We renew our previous motions and objections of 403, 404.5, and 803.
Noting previous objections, will be overruled and received into evidence.
Thank you, Judge. Thank you. Your Honor, at this time, may I publish State's Exhibit number 8?
You may publish it to the jury.
Thank you, sir. On this night, sir, did you notice any difference in Casey Anthony's demeanor as you had any other previous time that you'd spent with her?
No. No, sir.
At any time during this night, did she ever tell you that her child was missing?
No, sir.
Had been kidnapped?
No, sir.
Was actively looking for her?
No, sir.
Asked you for help?
No.
Did she ever tell you during this night that she needed help?
No.
That something had happened to her?
Nope.
Thank you.
Sir, when you say no, you mean no or yes? When you use the word nope.
Oh, I mean no.
Okay, thank you.
Sorry.
No problem.
Let me backtrack a little bit. You had said that you had had a lot of different phone numbers.
Yes, sir.
During this time frame, did you have a phone number with a 631 in it?
Yes. I only had different phone numbers because of her media harassment.
Because of what?
Media harassment.
All right. But up until that time, you used
Yeah, that was what same. I had one phone number at that time. Yes.
And was that a 631 number?
Yes, sir.
Very good. Thank you. All right. So was that hip hop showcase a success?
Yes.
And the defendant came home with you?
Yes, sir.
Was there, directing your attention to June 23rd, was there a time during that particular date that the defendant notified you that she had run out of gas?
Yes, sir.
Approximately what time, if you recall, did she let you know this?
Mid-afternoon to late afternoon.
Were you in class or were you at home?
I was at home.
I'm sorry?
Home. I was at the apartment.
Had you been to class that morning?
Yes.
What do you recall her telling you when she called you?
That she ran out of gas and she needed to get picked up.
When she told you she ran out of gas, did she sound frantic?
No.
Scared?
No.
Worried?
No.
Angry?
No.
Okay. And she just asked you for some help?
Yes, sir.
Did you have any problem giving her that help?
No.
What did you do?
I went to where she told me she was, and I picked her up.
All right. Where did she tell you she was?
That she was walking on, I can't remember the name of the road. It's the main road that is going south towards her house.
How long did it take you to get there?
I can't recall how long. Whatever would take me from going from the apartment to that area.
Did you talk to her on the phone while you were going to meet her?
I would believe so. Yes.
When you picked her up, did she have, was she on the street?
Yes.
Did she have anything with her?
A backpack.
Was that a backpack that you had seen before?
I can't remember.
After picking her up, where did you go?
She said she had gas at her house. So we went to her house to get gas.
Had you ever been to her house before?
I don't think so. No.
Did she direct you on how to get there?
Yes.
When you got there, where did you park?
In the driveway.
You were driving your Jeep?
Yes, sir.
When you got there, were there any other cars in the driveway?
No.
Upon getting out of the car, where did you go?
To her backyard.
Okay. Did you ever go into the garage?
Yes.
Okay. Did you go to the garage before you went to the side of the house?
Yes.
How did you get into the garage?
She opened it.
How did she open it?
I believe she had a keypad or a garage opener. I can't remember.
When the garage door opened, were there any other cars in the garage?
No.
Did you go into the Anthony home?
If I went through the garage, if there was, I can't remember if there was a door to the backyard or if you had to go through the house to get to the backyard. Either way, we went to the backyard.
All right, I understand you went to the backyard. I'm asking you if you recall ever walking or being inside of the Anthony home.
No, I don't recall.
Right. You went to the side of the house.
Yes.
Where did you go?
To a shed.
And when you got to the shed, what did you do?
We had to open up the shed because the shed, that's where the gas cans were. So, and there was a lock.
Did you use a key?
No, she said she didn't have a key, so we had to break the lock.
How did you break the lock?
With a tire iron from my truck.
Were you concerned about doing this at all?
Yes, I was.
What did you say?
I was like, "You sure you want me to break the lock?" And she was like, "Yeah, it's okay. It's my shed." So.
Did you suggest did you suggest to the defendant that maybe she could call her mom or dad?
Sustained. Rephrase the question.
Sure. Did you suggest any other alternatives other than breaking the lock on the shed?
No, I believed her word.
So you got a tire iron out of your car.
Yes, sir.
Were you the one that actually broke the lock?
Yes, sir.
How many gas cans did you take out of the shed?
2.
The gas cans that you took, did they have gas in them?
Yes.
And what did you do with those gas cans after taking them from the shed?
Grabbed the gas cans, put it in my truck, and then she directed me to where her car was.
When you got to where her car was, did you give her the gas cans?
We took them out, yes.
All right. Who put the gas into the car?
Casey did.
After she put the gas in the car, what did she do with the gas cans?
She put them in the trunk.
And again, what kind of car did she have at this time?
Pontiac.
White?
White.
All right. You saw her put the gas cans in the trunk?
Yes.
When she opened the trunk, could you see inside of it?
No.
From there, where did you all go?
Back to my apartment.
Did the defendant express any concern with breaking into the shed?
No.
When you got back to the apartment, did her mood change at all?
No.
Was she okay?
Mm-hmm. Yes.
You say yes or no?
Yes.
Did you spend the rest of the evening with her?
Yes.
You had mentioned a few moments ago that about telephone calls.
Yes.
Do you recall having or witnessing or being present when the defendant took or answered a telephone call?
No.
What happened when she took a phone call?
She would go outside.
Could you see her outside?
Sometimes she'd be walking around. You could see from my apartment there was like a balcony, and you could see there was a retention pond back there, and then there was like a grassy area, and you could see sometimes her walking around out there.
Did you find it odd that she would leave the apartment every time she took a phone call?
Yes and no, but I didn't question it because I figured it was a private matter, maybe with her mom.
Why do you think it might have been a private matter with her mom?
Sometimes, because she would say sometimes she would have to go talk to her mother.
When she came back from these conversations, was there ever a difference in or a change of mood?
No.
Did she ever give you any details about what they spoke about?
No, never got details.
In your presence, did the defendant ever say to you that I'm going to call the babysitter?
Yes.
And did she call the babysitter? Or did she dial a phone?
She would grab the phone, go outside. That's how she would go to dial phone numbers. So who knows if she actually was on the phone or just speak? I don't know.
That was my next
question. From
question.
my recollection, that she would go outside to use the phone. So.
All right. Did she ever tell you about any arguments that she had with her mom?
I don't remember anything specific.
Do you ever remember her mood drastically changing after she purportedly spoke with her mom?
No, not drastically. It would be what you would normally if you had any kind of altercation with your parents, but not a severe one.
Did she ever give you any details about what they were talking about?
Nor did I want to inquire. It wasn't my business.
Do you ever recall her, strike that. Did she give you any indication about what her home life was like?
It wasn't until later, right before New York, I went back to New York for vacation. She one time mentioned.
Okay. When did you go to New York?
June 30th to the 5th of July.
The conversations or the talks that you had, was that after you came back?
Yes.
All right. Directing your attention to June 26th of 2008, did the defendant spend the day with you on that day?
Yes, sir.
Do you recall anything that you might have done that day?
Not anything specific.
Just hanging out at the apartment?
Mm-hmm.
Yes?
Yes. I'm sorry. Yes.
All right.
Bad habit.
Directing your attention to June 27th of 2008, was there another occasion in which the defendant called you to notify you that she had run out of gas?
Yes.
Approximately what time did that happen?
Midday, right before midday.
Did she tell you where she was?
Yes, she said that she was at an Amscot.
Did she tell you where?
At the end of Goldenrod Road.
Were you familiar with that area?
Yes.
Did you know where to go?
Yes.
And did you go and pick up the defendant?
Yes, sir.
When you pulled into the Amscot parking lot?
Yes, sir.
Did you ever get out of the car?
No.
When you pulled into the Amscot parking lot, was the defendant in the car or outside of the car?
Outside of the car.
When she was outside of the car, did she have anything in her hand?
Bags, groceries.
Was that already in her hand, or did she go into the car and collect it?
No, it was already outside of the car.
I'm sorry, how many bags? What did she have?
Groceries.
Just groceries. You don't have to itemize them for me. All right. When she got into the car, did she express any anger for having run out of gas again?
So the car broke down, and I said, do you want me to look at it? And she said that, no, don't worry, my father will take care of it.
Okay. So she didn't tell you the car ran out of gas, she told you it broke down?
Yes.
All right. Are you mechanically inclined?
Well, no, no.
Do you know engines?
No. I do know some oil. I change the oil, and I check gaskets and see if something's wrong, something's overheating.
And that's what you offered to do?
Yes.
And what did the defendant say when you offered to help look at the car?
That her father would take care of it.
After you picked her up, did you go back to the apartment?
Yes, sir.
Did you drop off the groceries?
Yes, sir.
Later on that day, on the 27th, did you go to the Fashion Square Mall with the defendant?
Yes.
Your Honor, may I approach with another stipulation?
Yes, you may. You had a chance to examine the stipulation which bears your signature. Okay, ladies and gentlemen, I will read you the stipulation between the state and the defense. The copy of the video surveillance recorded at JCPenney's on June 27th, 2008 is a true and accurate representation of the business records of JCPenney. The parties have agreed to this fact, and it should be considered as true in your deliberations.
Thank you, Your Honor.
File the stipulation here in open court.
Your Honor, at this time, the state would move what's been previously marked for identification LF, which is a CD or DVD of the JCPenney video, into evidence as the state's next in line.
What says the defense? As to the issue of relevancy, objection will be denied. It will be received in evidence. Mr. Bias, you got to turn the microphone on if you want to hear. I know.
It was muffled down on the bottom of my papers. We also object to under 403, 404.5, and 803, Judge.
No to those objections. They will be overruled. It will be admitted in evidence. It states numbered.
And Your Honor, at this time, the state would ask to publish states number 9.
You may publish states number 9.
Let's stop it there for a second, if I may. Sir, do you recognize yourself in that video?
Yes, sir.
Where are you?
I am the one. What? I can touch the screen?
I'm sorry, yes. You can take your fingers, kind of like a telestrator.
Oh, cool. All right. There we go. Draw a little circle there. That's where I am.
And how about Casey Anthony? Is she in this?
Hold there.
All right. Thanks. Good. I take it you drove to the mall?
Yes, sir.
From this time that you picked up Casey Anthony from the Amscot, did you ever see that car again?
No.
Did you buy anything at the mall?
Did I personally?
Yeah.
No, sir.
I'm sorry. Okay, this is June 27th. This is, did you go to Fusion again that night?
Yes, sir.
Did you have another showcase?
Yes, sir.
Did the defendant go with you?
Yes, sir.
All right. Sir, I'm showing you what's been previously marked for identification BI. Do you recognize that photograph?
Yes, sir.
What is that a picture of?
Myself and Casey Anthony.
Looking at that photograph, can you tell the jury when that photograph or when you believe that photograph was taken?
July 27th.
Why do you believe that photograph was taken on June 27th?
From previously what I said with the tie. I used to wear the tie. I first started doing those nights, and then I kind of just stopped wearing one.
Was this just a friend that was taking a picture, or was this somebody hired to take pictures?
Well, he wasn't getting paid. It is a friend, but he does do professional photography.
Are these pictures that are taken, or was this picture taken, or if you can tell us, at the beginning of the night or the end of the night?
I can't recall that.
Is this a fair and accurate representation of what you and Casey Anthony looked like on June 27th of 2008?
Yes, sir.
Your Honor, at this time, the state would move what's been previously marked for identification BI into evidence as the state's next in line.
What says the defense?
Got the mic on. Same objection, Judge. Relevance 404.5, 403, 803.
Okay, noting objections will be overruled. It will be received in evidence at states numbered. Want to publish?
I would, sir.
You may publish.
Thank you. All right. On this night at Fusion, sir, was there any noticeable change in Casey Anthony's demeanor?
No, sir.
Was she upset?
No, sir.
Angry?
No, sir.
Sad?
No, sir.
Did she tell you at this time, on this date, that her daughter was missing?
No, sir.
Or kidnapped?
No, sir.
Or that she was looking for her?
No, sir.
Or that she needed help because something had happened to her?
No, sir.
You had mentioned to us a few minutes ago that you took a trip.
Yes, sir.
Where were you going? Or where did you go?
I went back home, had a short little vacation. You know, they used to give them sometimes at Full Sail. I took a short vacation to go home in New York.
What date did you leave?
The 30th of June.
How'd you get to the airport?
She drove.
When you say she, who?
I'm sorry. Casey Anthony drove myself and Cameron to the airport.
Where was Cameron going?
What's that?
Where was Cameron going?
Going back home as well in Ohio.
How did you get to the airport?
In my Jeep.
Did you drive to the airport?
Yes.
When you got to the airport, what was the plan for your car?
She was supposed to drop she being Casey, was supposed to drop my car off back at Sutton Place.
Was there any agreement or discussion about whether or not Casey Anthony would have access to your car while you were gone?
No.
Did you agree to let her use your car?
No, I did not.
Did you expect her to be using your car?
No.
Do you recall having any conversations with her from June 27th up until the time that you were taken to the airport about the status of her car?
Yes.
What did she tell you?
That her dad would take it. That her dad was supposed to take care of it, or he took it to some place. I can't remember if it was a mechanic or the car dealership, whatever it was. She said that her father was taking care of it.
But in any event, you did not expect her to be using your car.
Yes, sir.
We've been talking a lot about Casey Anthony. Just for record purposes, is Casey Anthony in this courtroom?
Yes, sir.
Can you please point her out, describe something that she's wearing, please?
She is wearing...
Accept the stipulation?
No.
Go ahead.
Okay. She's sitting over there, desk, wearing a blue blouse.
Your Honor, may the record reflect that the witness has identified Casey Anthony, the defendant in this
The
case.
record will so indicate.
Thank you very much, sir. Thank you very much, Your Honor. I have no further questions. This witness is subject to recall.
Cross-examination.
Mr. George. Good afternoon, Mr.
Good afternoon.
I want to ask you about these photographs.
Sure.
You realize you're here to testify in a first-degree murder case, do you not?
Yes, sir.
Do you realize that Casey Anthony is standing trial on a death penalty case?
Yes, sir.
Now,
Sustained.
Now, when the first photograph that was introduced, did Casey Anthony talk about murdering anyone?
No.
Did she talk about any murders she had just committed?
No.
Did she talk about murders she was planning of committing in the future?
No.
Did she borrow duct tape from anyone there at the party?
No.
Did she get any weapons, knives, guns?
No.
You see a gun in her dress. Or did you have the opportunity to see her with any weapons on her?
No.
Okay. What about the second photograph? Did she talk about murdering anybody on that day?
No.
Did she talk about somebody she was going to murder in the future?
No.
Did she talk about murdering Kaylee?
No.
Third photograph. Did she talk about murdering anybody on that day?
No.
Did she wear a gun? Or were you in the opportunity to see if she had any weapons on her?
No.
Did she borrow any duct tape from anyone?
No.
Did she borrow any knives from anyone?
No.
Guns?
No.
Did she borrow anything that you think she could use to commit a murder on on any of those three occasions from anyone?
No.
That you could see?
No.
What about when she went to JCPenney with you? Did she buy any duct tape there at JCPenney?
No.
Did she buy any plastic bags?
No.
Did she buy any chloroform there at the JCPenney?
No.
Did she buy any weapons, knives?
No.
Did she go to the sporting goods department and look at the guns?
No.
Now, you had... I want to talk to you now a little bit about... I'm sorry, I forgot the Blockbuster. Did she buy any weapons there at the Blockbuster?
No.
Did she maybe snag a box cutter or something that you could see?
No.
Did she talk about murdering anybody?
No.
Did she talk about any murders she had previously committed?
No.
Okay. No. Well, she didn't buy any duct tape?
No.
Was there any duct tape laying around that maybe they were unpacking videos from?
No.
Now I'd like to talk to you about Kaylee.
Okay.
How many times did you see Casey with Kaylee?
2 to 3 times.
And before you even met Casey, you knew Casey had a daughter?
Yes.
And that was okay with you?
Yeah.
You didn't have any issues with dating a girl who had a child?
No.
And you liked Kaylee?
Yes, I did.
And the times that you saw Casey interacting with her daughter, was it in a loving manner?
Yes, sir.
Did you see Casey be attentive to Kaylee?
Yes, sir.
Did you see Casey ever neglect Kaylee in any way?
No.
Did Kaylee ever go without any food?
No.
Did you see Kaylee wearing dirty clothing?
No.
In fact, most of the interaction that you observed with Casey and Kaylee was that she was a good mother, right?
Yes, sir.
Sustained. Sustained.
Yes, sir. Now, there was an incident where, actually on June 2nd of 2008, you went with Casey and Kaylee to the pool.
Yes, sir.
You spent some time together.
Yes.
And was there an incident where you saw Casey have to discipline Kaylee?
Not that I can recall.
Okay. apologize. If I can have a moment.
Could you be more specific on what you mean by discipline, too?
Sure. If you can give me just a moment, I'll find it. Okay. And when I say discipline, I'm referring to maybe raise her voice at Kaylee.
Oh, yes.
Okay. And do you recall a situation by the pool where she had to raise her voice at Kaylee?
Not by the pool, no.
Do you recall that at all?
No.
If I showed you your statement that you gave to law enforcement on I believe it was September 15th of 2008, would that reflect your recollection?
Sure.
Okay. I'm referring to Bates stamp 1653, counsel.
You may.
Sure. Okay. Oh, sorry. Yeah.
Does that refresh your recollection?
Yes, sir.
Tell the ladies and gentlemen of the jury what happened.
From what I just wrote in my statement, she was going near the pool, and she didn't want her to go near the pool, obviously. Tyler likes to mosey on off sometimes, and she got probably too close to the pool. Too close to the pool.
And what did Casey do when she got too close to the pool?
What every other mother would do. Try to stop her from getting from the pool. Stop, hey, stop, you know?
Was it your impression that Kaylee really enjoyed the pool?
Yes, sir.
And you had an opportunity to see that?
Yes.
Now, when Mr. George asked you if you had an opportunity to share secrets with Casey, there was a secret that she shared with you, did she not?
Yes.
And it was in reference to her father abusing her, did she not?
Predicate's been laid. It's outside the scope of the direct examination, and it's hearsay.
Sustained on hearsay.
Judge, may I have a moment?
You may.
Judge, we would have argued the last objection would be an admission as opposed to hearsay. It's a statement of the defendant.
It's also self-serving. Objection sustained. Let's move on.
Yes, sir. Now, Mr. Lazaro, you were very cooperative with law enforcement, were you not?
Yes, sir.
And this was from the very beginning.
Yes, sir.
In fact, the only people you would talk to was law enforcement, was it not?
Yes, sir.
In fact, you wouldn't even speak to the defense, would you?
I didn't know I had to.
Unless it was at deposition.
Okay.
And you cooperated with their every request.
Yes.
You allowed them to tap your phone.
Yes.
You wore a wire for them with Lee Anthony?
Yes.
And you gave numerous sworn statements, did you not?
Yes, sir.
5 to be exact?
I can't remember.
And you never made any statements to the media?
No.
Despite being harassed left and right by them?
Yeah, I did not talk to the media.
And you never sold any of photographs or made any money off of this case?
No, sir. No, sir.
Now, I'd like to talk to you about the first time Casey ran out of gas.
Okay.
Okay. Now, when you went to get the gas cans and you broke in the shed, you had to do that, right?
Yes.
And that's because she couldn't do it.
Well, she could.
She could?
Yeah.
She could break a lock on her own?
Well, she was a girl. Probably better off if I was doing it.
Okay. I didn't understand your answer. Are you saying she could or she could not?
She could have.
She could have?
Right.
Okay. Well, did you get the impression that, I mean, how much do you think she weighs? 105 pounds wet?
Overall.
Give or take.
Okay. And do you think, well, I'll refer, I'll move on. Let me ask you this. So you got the gas cans.
Right.
There were 2 gas cans.
Yes, sir.
And then at that point, you drove to her car.
Yes.
Did she at any time tell you, stay away from my car? Did she say, or did she kind of lean in front of you so you wouldn't get near her car?
No.
Was she blocking you in any way?
No.
Did she tell you at any time to stay away or you couldn't get anywhere near her trunk?
No.
Now, when you poured the first can into the...
well, she actually poured the gas can.
Okay, when she poured that gas can
Right.
into the tank, you were standing next to her?
Correct.
And how far away would you say from the trunk is the gas gauge?
Here's the car. There's the gas tank. I was standing here. She was standing here.
Okay. So maybe 2 feet away from the trunk?
Yeah, more than 2 feet.
Object to counsel testifying to measurements. That there's
It's cross-examination. He's leading.
I think a predicate still needs to be established.
Overruled?
So about 2 feet?
I would say more than that, probably.
Okay. Now, after she poured the first gas can in, she opened the trunk?
No.
Okay. Was it after the second gas can was put in that she...
I only recall her, I remember her putting the gas in the car, and then she put him away in the trunk, so she had to open the trunk after.
Okay. And when she, at any time, either before, after, or during, did you smell any stench in that car?
No, sir.
Now...
But I wasn't in the car.
I realize you weren't in the car, and I understand. We'll get to that in a moment. Now, she had keys to her car, did she not?
What's that?
She had keys to her
Yes,
car,
sir.
right? Because she eventually drove it away?
Yes.
And so there was nothing to preclude her from putting the gas cans in maybe the front seat of her car.
Right.
Or the back seat of her car.
Right.
But instead, she put it in the trunk of her car.
Right.
And I know it's been a long time.
Yes, sir.
And I want to ask you if I apologize to the court and the jury. I'm just trying to find something. I know under direct examination, well, let me ask you this. Do you recall if you saw the corner lining of her trunk when she opened the car trunk?
No. No, sir.
Would it refresh your recollection if I showed you your sworn statement to law enforcement given on October of 2008?
Sure.
3875 Bates number, reporting counsel, line 12.
You may.
Okay.
Is that the first recollection?
Yeah, I didn't know what you meant by lining.
No problem. Okay, so when she opened the trunk, you were close enough to see the liner.
And you would see where the rubber meets, I guess, and that very edge of the corner. Yes.
Okay. Now, the second time that she ran out of gas, she actually told you she ran out of gas, did she not?
Yes.
Because there was a bit, I thought I heard you testify that she said the car broke down, but she actually told you she ran out of gas, did she
Right.
not?
I'm sorry. I must have misspoken, but yeah, I was meaning broke down, meaning she ran out of gas.
Okay. So just so the jury's clear, on the 27th of June, you came because she ran out of gas, not because her car broke down.
Yes.
And you weren't going to take a look at it because the car broke down. You were just offering to be
I was
helpful.
just offering help in general.
Okay. Now, you came down from New York to testify here, right?
Yes, sir.
And you don't live here anymore?
No, sir.
You don't have any family here?
No. Actually, I do. Fort Lauderdale.
In Fort Lauderdale, but not here in Orlando? Okay. And would it be a hardship for you to come back and testify again?
Yes, sir.
Judge, at this time, I'd like to introduce a photograph rather than have to have this witness come back. If
Yeah, you may. Okay, objection sustained. Your next question.
Yes, Judge. In order to lay the predicate, rather than get a little tricky with the electronics, I'd like to show them the black and white.
What happens is that you're not going to
Correct.
need to lay a predicate based upon what was said, but you can't introduce those now, subject to what I said over here at the bench. So the next area. So you're not going to have.
So I don't have to even lay the predicate.
No, just read the identification numbers into the record so we'll know what you're talking about for purposes of the record, just in case.
Yes, sir. Defense Exhibit Q and Defense Exhibit P.
Okay, thank you.
Thank you, Your Honor. When you went to pick up Casey at the Amscot,
yes,
her car was parked into a parking spot, was it not?
More or less, it was kind of, if I remember, cockeyed.
Okay. And it was at the Amscot off of, was it Colonial Road? Colonial Drive?
Goldenrod meets Colonial, from my recollection of the area, so yes.
And within 20, I guess, that's next door to a gas station, is it not?
I don't remember.
Is there a Sam's Club right next door?
No.
Okay. Judge, may I show the witness the photograph?
Yeah, you can show him the photograph. I don't know where you're going right now, but you can show him the photograph.
If I show you a photograph of the Amscot, would that help refresh your recollection as to whether there's a gas station?
No. Unless it's on there, I mean.
You can approach the witness, but make sure that's not exposed to the jury.
Okay.
After looking at the photograph, did that help refresh your recollection as to whether there was a gas station next to the Amscot?
Does it refresh my recollection? No, but do I see it at a gas station? Yes.
Okay. Now, there was a time where you saw Casey looking at a video on her computer, did you not?
Yes, sir.
And this was while she was living with you. I think counsel's gotten into the entire time that we went from June 16th through.
Overruled.
I wanted to talk about the statement that you gave. Actually, let me restate that. You gave a statement in October of 2008 where they asked you, and that wasn't your first statement, is that correct? In October?
No.
In fact, you had been questioned numerous times.
Yes.
And that was the time when you were actually questioned about the first time Casey ran out of gas, right?
I do not recall if that was the first time.
Do you remember the first time you advised anyone of the time that Casey had run out of gas for the first time?
Don't remember which statement it was. There's a lot of things going on at the time.
Okay. If I can have just a moment to double check.
Welcome back to the LawNewz Network, everybody. I'm Aaron Keller. I'll be with you for the afternoon as we dip back into the archives as far back as 2011 for the Casey Anthony murder trial out of Florida. She, as we all know at this point, was acquitted of the most serious charges related to the death of her little girl named Kaylee. This is one of the anniversaries of the acquittal and the conviction on the lesser misdemeanor charges for lying to police. So we thought it was a good time, when many other courts are in a week-long vacation surrounding the 4th of July, to look back at this famous case. We're going to continue on now with the testimony of the boyfriend, Anthony Lazzaro. He goes by Tony, and we were listening to that testimony for the afternoon. We've got another clip of his testimony, and we'll pick up where we left off.
Thank you, Your Honor. May it please the court, Mr. George. Good morning, ladies and gentlemen. Good morning, Mr. Lazzaro.
Morning.
I want to start off and I want to talk about Kaylee. Now, we talked yesterday about the interaction that you saw between Kaylee and Casey.
Yes.
What I didn't ask you is, did you ever have the opportunity to see Kaylee laughing with Casey?
Yes.
Did you ever see Kaylee hugging Casey?
Yes.
Did you ever see Kaylee run to Casey?
Yes.
Did that affection appear genuine to you?
Yes.
Was she faking that?
No.
Sustained.
Did it appear to you to be a lot of love between Kaylee and Casey?
Objection, same objections, it's speculation.
I think
Overruled.
Yes. And explain to the ladies and gentlemen of the jury what you observed as to their interactions.
From what I can remember, it was completely. She'd have a book. She'd have her teddy bear. We would go down to the pool, teaching her how to swim. Talk about Kaylee. Kaylee liked to Dora the Explorer and could count to 40 in Spanish, which was pretty incredible for her age. And she was a great little girl.
And who taught her how to count to
The Door Explorer. From what my knowledge was her favorite show.
Okay. And how often during that time did you see Casey and Kaylee hugging and showing affection with one another?
Pretty much the whole time.
Okay. Now, I want to talk to you a little bit more about the gas can that you picked up the first time from the shed.
Okay.
Okay. Did it have any duct tape on it?
Not that I can remember.
Okay. Now, as to some of these photos, do you normally, when you promote a club, have photographers there to promote so that way people can see?
Like I said, those are friends of mine, and basically they were going to school for photography, so it looks good for them to have snapshots. It helps them better their work, so when they get out of school, they could, have experience.
And when you promote your club, a lot of that is done online, is it not?
Yes.
And some of these photographs are put online, are they not?
Yeah.
And the photographs are put online so people who aren't familiar with your night at that club can see pretty much what the atmosphere is like.
Sure.
And part of that atmosphere is pretty girls.
And yeah, sure.
And young men such as yourself would prefer to go to a club that has pretty girls dancing.
Sure.
And that's kind of the idea of promotion, is to get people through to the door.
Yes.
Right. Now, and you said that the person who took these photographs was a friend of yours.
Yes.
Okay. And part of that, again, is showing everybody's having a good time.
Yes.
Now, yesterday we talked about, when Mr. George questioned you about you and Casey sharing secrets. Now, I don't want you to tell us what the secret is, but I do want to ask you, was that secret told before Casey got arrested?
Yes.
Okay. And so if an accusation were made that it was made up after she got arrested, that would not be true.
As to relevance, overruled. Sustained as to hearsay.
Don't tell us what the secret is, but it was certainly, definitely 100% made before Casey ever got arrested.
Let me approach you. You may. Okay, you may proceed.
Yes, sir. Mr. Lazaro, your relationship with Casey got pretty intense at towards the June and July time period, did it not? You were spending more
intense. How?
You're spending more time together.
Yes.
You began to care for one another.
Yes.
And in fact, well, let me ask you: did Casey ever tell you she loved you?
Yes.
Did you ever tell Casey you loved her?
Yes.
Now, you would talk all the time on the phone?
Yes.
Even when you weren't together?
Well, if we weren't together, that's when we were talking.
I know. I meant even when you weren't in the same. You were in New York. That's what I meant.
Yes.
Yeah. And when she would go home, even after seeing her all day, you'd talk, text, and so on.
I believe so.
In fact, in one of your statements to law enforcement, you talked about how you would talk till you fall asleep, right?
Sure. Yes.
You used the word that you would talk until you just passed out. Is that correct?
Yes.
Now, it wasn't because you were drunk or anything like that?
No.
Or under any drugs, was it?
No. No.
Okay, that's just a phrase that you use, passed out.
We will, because sometimes later, I usually am one of those people that will pass out on the phone. Not because it's boring or anything, but just talking on the phone is usually not my kind of thing.
Okay. But the two of you would talk at all hours of the night and text each other and everything like that?
Yes.
Now, when this all occurred on July 15th, when the news broke and everything like that, you were shocked.
Well, the news didn't break on July.
I'm sorry, July 15th or 16th. 16th, I'm sorry.
Yes.
And even today, you remain completely shocked over this situation.
Judge, Your Honor, beyond the scope of possible speculation.
Sustained.
The questioning that Mr. George had asked you when comparing Casey's behavior before June 16th and post June 16th, that is something difficult for you to deal with, is it not?
Yes.
Because something's just not right about
Yes.
that. It's bizarre.
Judges, the relevance, Your Honor.
Overrule as to that question.
It's bizarre, right?
Yes.
And you felt that if she would have confided in anyone, it would have been you.
Yes, or her parents.
And she did not.
To my knowledge of her parents, no. And to me, definitely no.
If I can have just one moment, Judge. Now, you talked about during direct examination that any time Casey talked to her parents, she went outside.
To my knowledge, yes.
Okay. And she kept that world separate from your world.
Yes.
I have no further questions.
Redirect.
Mr. Lazaro, good morning.
Good morning.
Just want to follow up on a couple of topics that Mr. Baez had brought up to you. We'll start with some of the things he brought up this morning. In reference to the gas cans, as you sit here today, can you describe the gas cans for us?
Red.
Anything else?
They're just the small hand gas cans.
Were they, when you were asked whether or not those gas cans had duct tape, do you know?
I can't remember.
Okay. So they may have, you just don't know.
Correct.
All right. Mr. Baez also talked to you about communicating with the defendant, and I believe you stated that you would talk all the time on the phone.
Yes.
Either talking or texting or something along those lines.
Yes.
After she moved in with you on the 16th, you didn't have to talk all the time, did you?
Right.
Because she was always there.
Correct.
Yesterday, Mr. Baez was asking you about the circumstances after you obtained the gas cans and went back to the defendant's car.
Correct.
Do you remember that testimony? Do you remember Mr. Baez asking you those questions?
Yes.
All right. And when he did that, he referenced an interview.
Overrule at this point. Let him finish answering the question. Mr. Lazario, do not answer the question until I tell you to answer the question. You may continue.
Do you remember yesterday Mr. Baez asking you questions about an interview you gave to law enforcement on October 16th of 2008?
Okay. Mr. Baez, is that objection?
No objection at this time.
Okay. You may answer the question, sir.
Yes.
And do you remember him referencing a certain page to you and approached you and showed that to you? Yesterday.
Yes. He showed me a page for the AMSCA, when we went to AMSCA.
Okay. I'd like to ask you a couple of questions about that. When you obtained the gas cans, you went back to the defendant's car, correct?
Correct.
When you got out of the car, what did you immediately do? Do you remember what you told Detective Edwards?
We grabbed the gas cans out of my tailgate and walked over to her car.
When you walked over to the car, what did you do with the gas can?
Handed it to Casey.
And what did Casey do with them at that point?
Put it into the car.
At that point, was her trunk open or closed?
Closed.
And where were you standing when she was pouring the gas into the tank?
Behind her, closer to the front of the car.
Could you smell the gasoline?
Yes.
How would you describe the scent of the gasoline? Was it very strong? Was it mild?
The same scent that you would have if you were just finishing up pouring some gas at a gas station.
And I believe you testified there were 2 gas cans, correct?
Correct.
The defendant poured the first gas can into the car?
Yes.
When that was emptied into the car, what did you do with the second gas can?
The second gas can, handed it to her.
Okay. Are you still in the same position?
No.
Okay. Where are you?
Handing it to her, and then I'm actually going to close my tailgate.
All right. So you're walking away from the car?
Correct.
At this point, the trunk is the trunk still closed?
I believe so.
All right. Did the defendant then finish putting the gas into the second gas can, the gas that's in the second gas can, into the car?
Yes, sir.
All right. When she is done doing that, what are you doing?
I saw her walking back to her car. I was right near her car because my car was parked here and she was parked right there.
Okay. She's behind your car?
Behind me. I was in front of her.
Okay.
And I saw her open up the trunk.
All right. Now, from that vantage point, the trunk is open. You're looking at the top of the trunk, correct?
Sustain, rephrase the question.
Sure. You're in front, you're at the back of your car, but at the front of Ms. Anthony's car. Is that what you're saying?
Correct. I started to walk back to see what was going on, to see if she was done with everything.
Okay.
And that's when I saw when I say that the edge of the corner in my statement, you know how cars, when the trunk goes up, you can see underneath the trunk a little bit, you could see the rubber lining of the trunk. That's what I saw.
When you say the rubber lining of the trunk, are you referring to
where the trunk actually comes down and meets and seals?
Okay. So could you see into the trunk?
No, I could not see in the trunk.
Again, Your Honor, thank you. I have no further questions of the witness at this time, subject to recall.
Any recross into those areas? You may proceed.
Mr. Lazaro, when the police questioned you about this specific incident,
yes,
you knew that the trunk of the car was a significant issue in this case, did you not?
Correct.
In fact, you had seen it on the news many times.
Yes, sir.
And seen it reported many times.
Yes, sir.
And despite all of that, you told them that there was no smell.
Correct.
And during this questioning, there was even a time when they were trying to ask you to close your eyes and to try and picture it. Do you recall that?
Yes, sir.
Okay. And that still didn't waver your testimony.
Correct.
And you still told the truth.
Yes, sir.
No further questions.
Welcome back, everybody. We are listening to some clips from the archives going all the way back to 2011 from the Casey Anthony trial in Florida. We all know she was acquitted of the most serious charges related to the death of her baby, Kaylee Anthony. But we're going to continue on. This is around the time of the anniversary of the acquittal for the most serious charges, convictions on the lesser charges, misdemeanors related to lying to the police. We were just listening to the testimony of Tony Lazzaro, a boyfriend, and we're going to go now to listen to some more testimony from George Anthony. He returned to the stand to talk about the type of duct tape that was found on the little girl's skull. It turned out that he had a similar type of duct tape on one of the gas cans that he had in his house or in his garage or whatnot. So that duct tape was an issue in the case because it was alleged that the type of duct tape was very specific and that not many people had access to it. Let's listen in now to George Anthony on the witness stand.
George, middle initial A, last name Anthony, Anthony.
Good morning, Mr. Anthony.
Good morning.
I want to speak to you today about the date of June 24th of 2008. On that particular date, were you home in the morning of that date?
Yes.
Now, was your schedule on that date different than on a normal work day?
Yes, I had made some plans to do a couple things around the house, meet my wife to deposit a check, and go to a job interview later that afternoon.
So you, to prepare for that, what did you do?
Well, like any other time, I go to my side shed, which is on the south side of my home, and as I walked down towards the shed to open up the door, I found that the lock had been broken.
Please display for the witness. This will be State's Exhibit LJ for identification. I'll show it to counsel. Do you recognize this, Mr. Anthony?
Yes.
Do you recognize this to be a diagram of your home and the surrounding property, particularly the backyard?
Yes.
And do you recognize it to be a fair and accurate depiction of the layout of your house and your yard?
Yes.
All right. Would it be helpful to you in describing to the jury sort of what happened to use this diagram to kind of explain where the shed was and various things?
Well, where I kept my lawn equipment.
Let me just stop you for a second. Would it be helpful to use this to kind of point out to the jury?
Yes.
Okay. This time you ought to move to evidence State's Exhibit LJ.
What says the defense? Basis of objection?
Prior disclosure, I don't have any. It's the first time I've seen this, Judge.
Could we approach?
Yes. You may proceed. Okay. There being no objections, it will be received in evidence as states numbered.
And I'd like to publish it to the jury and allow the witness to use it to explain.
You may publish it to the jury.
All right, sir. As you're going through and telling us stuff, I want you to just kind of be able to refer to the diagram, okay?
Yes.
So you said you went out to the shed, which contains your, I guess, lawn equipment.
Lawn equipment,
okay.
Yes.
Could you just, and I think you should be able to touch the screen and make a little circle. Just circle which shed that is. Okay, so that's the one at the bottom right corner of the diagram.
Yes.
Okay. Now, let's just orient a couple of the things here since we've got the diagram up. There's an item up on the top right that says Playhouse. What is that?
That's Kaylee's playhouse. That's that we got for her just prior to her second birthday.
All right. And obviously there's a circular item that says pool. Is that an above-ground pool?
Yes.
And the two items that are shed on the left, those are sheds holding different purposes?
The one shed we have are bicycles inside, rafts for the beach. The other one just has some other miscellaneous plant things, things for our pool. Just
all right. And
items.
The patio that's depicted here, is that a enclosed screen patio?
It's an enclosed screen patio.
All right. So you go out to the shed to start your lawn work. What do you find?
I find that the lock had been broken off of the shed. right side door was partially open, about 2 or 3 inches.
And what type of shed is it a wood shed, metal shed, plastic shed?
It's plastic, fiberglass. Rubbermaid is the brand of it.
Okay. One of those you can like buy at Home Depot or Lowe's and
yes,
put together. All right. So what kind of lock was on it?
Just a small, like a master key type lock, nothing extravagant at all. I just took one key to open it up.
And was the lock still on it, but was the lock itself broken, or the shed latch was broken? What was? Well,
the shed had a 2 eyelet plastic connection that went to it, and I just slid the lock itself between it just to lock it.
Okay, sort of a hole in each door. You stick the lock through the middle.
Yes, sir.
And was the shed part broken, or the lock itself broken?
Just the shed part. Just the plastic eyelet pieces were broken.
All right. So, did you open the shed to see if anything? Pardon me. If anything was missing?
Well, first thing I opened up the shed and I looked to the right, I automatically seen the lock itself. The lock was inside of the shed, which I thought was somewhat unusual. And I just did a quick scan, and I seen the lawnmower was there, other tools and stuff that I'd be using, the blower, the edger, also a generator I have in there. And I looked over to my left where I kept the gas cans up above the ground, and both gas cans were gone.
Now, were any of the actual power tools missing? The lawnmowers, edgers, any of that more expensive
No, they
stuff?
were not, which I found somewhat unusual.
So just the gas cans?
Just the gas cans.
Okay, so what did you do in response to that?
Well, first took a step back and just shook my head and wondered, okay, why just take the gas cans?
Okay.
When there was other things more valuable to me, inside there.
Sure.
I immediately just went and I said, well, I need to make a report on this because, again, this could be conceived as hearsay, but neighbors do talk, and we know that there has been minor thefts, gas taken from vehicles, so on and so forth in the area.
All right.
So I just thought, well, I'll at least call and make a report. If the gas cans are ever found and make a description of them, I'll get them back.
All right. And did you, what agency did you call?
I called the Orange County Sheriff's Department because we're in their jurisdiction.
And approximately what time of the day would this have been?
I'm going to say it was probably close to maybe 10:30 in the morning, and I know within about 10 minutes after making the initial report, I had a deputy show up to my house.
Okay. Was it just more than one deputy or just?
Just one deputy came to our front curb area. Very nice gentleman. I explained to him what happened, and he explained that there have been thefts in the neighborhood.
Okay.
Things like that.
Did you make a report, fill out paperwork to make a report of the theft?
I finished. I filled out a report, signed it, gave a brief description of what the gas cans looked like. He said, is there a value on them? And I said, probably in the same neighborhood, maybe between gas and the gas cans replacing, maybe $50. I said, could be more, could be a little bit less, but at least that.
And did he, make an extensive investigation, dust for fingerprints, take DNA samples, anything like that?
No, he just said he would make the report. He would go ahead and have it available for me if I want to stop by.
All right. So how long was the deputy there?
5-10 minutes. It wasn't a real long report.
And did he leave you some paperwork to document that you had made the report?
Yes.
All right. So what did you do about your plan to do yard work?
Well, I sort of had to put that on hold because I knew I'd have to go out and purchase new gas cans to get the job done.
Did you actually go out and buy new gas cans at that point?
Yes, I went out and bought 2 more plastic gas cans, but I also went and alerted my next-door neighbor, the Bruner residents, who just had moved in just about 3 years prior to that.
That would be Mr. Berner?
Yes, he was here yesterday.
All right. So did you get your lawn mowed?
Pardon me?
Did you get your lawn mowed that day?
As a matter of fact, I did not get my lawn mowed that day.
Okay. Did there come a point in time, up until this point, from June 16th that we talked about previously to this date, June 24th, had you seen your daughter, Casey?
I can't remember seeing Casey come back, to our house at all. I don't remember seeing her from the last time I saw her on the 16th till I made the report.
So on the 24th, did you see your daughter?
Yes, I did.
Okay. Approximately what time was that?
shortly after 2 p.m. in the afternoon.
Now, is that a time where, on your normal schedule, you would have been already on your way to work?
Within that 2 to 2:15 time, 2:15 p.m., I would have been leaving for work, yes.
But you were there because of the interview?
Yes, because my interview wasn't until 6 p.m. that evening.
So, tell us what led up to your seeing Casey.
I was just inside my living room area. I just had come home after depositing a check with my wife at our local bank, and was just sort of easing into my thought process of what I was going to be doing this interview. It was a great opportunity for me, and just trying to feel at ease for the next couple hours or so.
Sustain.
So you were in your living room?
Yes.
Okay. Just sort of put a little spot on your living room. I guess it's pretty obvious, but right there. Okay. So you're in your living room. Tell us about what happened next with you're seeing Casey.
Well, after being home just a few moments, I heard the garage door come up, and next thing I know, here's Casey coming in the house.
Now, was your car in the garage?
Yes.
All right. So you hear the door come up, and obviously your car is in there. So, are you concerned at all about who's coming in the middle of the afternoon?
I was concerned because I knew it couldn't have been my wife because she'd still been working because I just had saw her previously. And
okay. So when you first see Casey, let me just clear this diagram here. When you first saw Casey, where was she? Just put a little circle on the diagram.
I first saw Casey just right near the front door area.
Right. And she was coming in from the garage through this. What is that room between the garage and the living room?
Wherever the AC unit is at, if I'm right. Point right there, we have a little hallway that comes in from the garage.
And is that where she came through?
Yes.
Okay. Were you surprised to see her?
Yes, happy. I mean, I was glad to see my daughter. I haven't seen her for some time, and just...
What was her reaction to seeing you?
Somewhat of surprise on her part.
Now, pardon me. Tell me about, did you have a conversation with her?
Yes, I did. I asked her how she was doing, what she's doing there. I asked, where's Kaylee? And she says, Dad, I only got 10 minutes. I got to get my clothes. I got to take off and go to work. I said, oh, okay. I mean, then I did ask some a little bit more about her and, schedule. I asked some a little bit more about Kaylee, where's she at? I haven't talked to her. We haven't seen her. Has Mom been talking to you? And she was a little evasive with me, but again, she said she had 10 minutes. I said, okay.
Did you just assume she was rushing somewhere?
She was rushing to get some clothes to go to work. And I said, okay.
Now, upon seeing Casey and upon what you told us about early in the morning, did you become to suspect that she might know something about these missing gas cans?
I have felt on different occasions that the gas cans or gas has been used without my knowledge from different times, and I was always just wondering, it just doesn't evaporate that quickly, especially when it's a concealed area that I have it in and locked and things like that. I did ask Casey about it.
Okay.
And she said, Dad, I don't know what you're talking about. And I says, well, it's really wild. As I said, I go to mow the grass this morning, and I said, I don't have any gas for the lawnmower and for the edger and stuff. She says, oh, Dad, she says, I don't know what to tell you. I said, okay. And I sort of just let it go for a moment. But then again, I've seen some indication on her car where there were like spill marks and stuff like that whenever...
You're talking about in the past?
In the past, yes. Okay. And I've seen spill marks on the particular Sunfire she has.
Well, I don't want to go too deep into why you were suspicious. The question, I guess the point was that you thought maybe she had taken the gas.
Yes.
All right. So what did you do in an effort to investigate that?
Well, I just wanted to, I guess, maybe conduct my own little, I don't want to say the word investigate. I just wanted to question her a little bit more about some things. So I decided, well, I was planning on that weekend changing the oil in my wife's car, rotating the tires. I do that stuff at our home. And inside of Casey's car and my wife's vehicle, I have these little metal triangular triangular things that you support with your tires with when you jack your car up that the car doesn't move. Well, Casey had one, and I put it back there, so I knew it should be there. And
like something to keep the car from sliding back while you're working on it. Okay.
So I inquired about going out and getting it. I said, Casey, I need to get something out of your car. Her conversation to me was, what do you want to get out of the car? I said, that little metal type block, that little triangular block. I said, I need that, again, like I said, to work on her mother's car for the weekend. Dad, I'll get it for you. I said, no, Casey, I know where it's at. I got an extra key. I would just go out and get it.
So you had a key to her car?
Right. We've always kept at least 2 or 3 extra keys for each one of our vehicles in case we get locked out.
So you could have gone out and opened the trunk while she was getting ready or whatever? Okay.
So after just maybe a little bit of back and forth, talk here and there, I mean, it was very cordial, very nice. As I'm starting to walk down our little hallway to go out through the garage because the garage door is open, Casey just brushes past me very quickly, says, Dad, I'll get it. I'll get it out of the car. He says, Casey, I'm capable of going out and get it. So as she almost nearly runs to the back of her car, and I'm walking, just thinking, okay, here we go, a little funny time here between her and I. As I get towards the end of the car, right at the passenger rear, just where the taillight and stuff is at, Casey opens up the trunk, throws the trunk open, reaches in and grabs the gas cans. She said, here, I hate to say this, here's your fucking gas cans, and places them down on the ground and slams her trunk. I didn't know what to say at first. And I said, why? She says, I needed them. I've had over. Good. Dad, I needed them. I've been having problems with the car, so on and so forth. I said, this makes no sense to me. She says, well, I've been taking a trip. She said, I've been needing I run low on fuel. I don't have money or this. And I said, whatever the reason is, I said, I don't want to get upset any more than I already am. I said, and you don't need to get upset before I go into work. I says, we'll talk later. So I picked up the gas cans, and I went in to where my garage door was, and I just set them on our little freezer that we had, and just told Casey, I said, listen, we'll talk later. Because I was just, I don't know, I guess the word mortified, I guess, could be. It's like, I know that in the past they had been missing or used, and now finally when I caught her with them.
Well, let me stop you because I don't want to go too far into the past. Suffice it to say you were a little annoyed about this. Okay. As her car, was it in your garage or was it on the driveway?
Is in a driveway parked about right in the middle of the drive itself.
Now, when she opened the trunk, did you look in the trunk?
Never had a chance to.
Okay. Now, when you were standing there at the trunk, did you smell anything unusual?
The only smell that I had was the smell of gas from these gas cans. That's the only thing I had at the time.
Okay, that's the only thing you remember?
Yes.
All right, so you got your gas cans back. What did Casey do then?
She abruptly got into her car, backed out of the driveway, and I didn't see her again.
Now, during any of these conversations with Casey, did you mention to her that you had called the police?
I had told her about that. I had made a report, and she said, well, yeah. She says, I talked to Mom. Mom knows about it. I said, okay, Mom knows about it.
Had you told your wife during the interim hours about the gas cans and the police report and all that?
Right after I'd made the report with the Sheriff's Department, I called Cindy briefly, and I just it sort of made her chuckle for a second and made me sort of chuckle. And I said, guess what? I said, someone broke into our shed and took our gas cans.
Okay. You said somebody broke in and you told her about the break-in?
Yes, I told Cindy about that, yes.
All right. Now, let me just... Okay, could I have State's Exhibit AJ, please? Now, sir, would you look at State's Exhibit AJ? Let me get rid of the annotation here. Is that one of the gas cans that we've been talking about here?
Yes.
And it's an older metal gas can?
Yes.
How long have you had it?
25 years at least. That I've had it for quite some time.
Now, in this photograph, it has a piece of duct tape over the over a portion of it. Do you see that?
Yes.
Now, was it your habit to place a piece of duct tape on this can for some reason?
The only reason that piece of duct tape is on there is because the plastic cap, it's a vent cap that is generally on any type of gas can or something like that to vent when you're pouring it out, was gone. When Casey brought those back to me, brought this one and the other smaller one back to me, it was gone. So I did place that particular one back on there because I didn't want a gas smell out in the shed or inside the house.
All right. May I have State's AK? And you see State's Exhibit AK, which is being shown to you. It's a photograph taken at a later time, obviously, but is that the other gas can we're talking about?
Yes, it is.
All right. Could I have a State's Exhibit? Let's see. D? Yes, State's Exhibit D, please. Looking at State's Exhibit D, do you recognize this as a photograph? Do you recognize what this is a photograph of?
That is our Pontiac Sunfire.
Now, when you say ours, clarify its legal ownership for us for a moment.
The Pontiac Sunfire is in my name and my wife's name. We have title to the vehicle.
And at the particular time that we're speaking of, which is June 24th, whose car was this as far as use and possession?
Was Casey's car.
No further questions.
Cross-examination.
Judge, we would request the morning recess at this time. That's possible.
Okay. We will take a 15-minute recess at this time to 10 minutes past the hour. Okay, you may be seated. Okay, Mr. Anthony, you may resume the stand. Okay, let the record reflect that the defendant is present, along with counsel for the defendant, assistant state attorneys, both sides ready to proceed.
Yes, sir. Yes, sir.
Okay, let's return to jury. Okay, members of the jury, I will talk with you at the noon hour, okay? All right, Mr. Baez, you may proceed.
Please, court. Mr. Anthony, you testified under direct examination that you knew Casey would take gas from the gas cans.
I had suspected that in the past, yes.
And you had actually caught her and confronted her about it previously.
We had a discussion about it, yes.
And in fact, you told her, if you need gas, I will give you $10 for it. Don't take gas from my gas cans.
Yes.
And it would upset you that Casey would take gas from the gas cans prior to this ever happening.
Yes.
Now, on June 24th, you haven't seen your granddaughter for 9 days.
Yes.
And you lived with her all your life, all her life, rather.
Yes.
Never went 24 hours without seeing her.
That, yes.
And on June 24th,
okay, let's go off the record for a second and see what's going on.
I was just picking up yours.
Thank you, Your Honor. Mr. Anthony, you stated the last time you saw your granddaughter was on June 16th, correct?
Correct.
And on June 24th, you called the police.
Yes.
And you called the police to report gas cans missing.
Yes.
Not your granddaughter missing.
Correct.
Is that a yes, sir?
My granddaughter was not missing at that time.
My question to you is, not your granddaughter missing. Is that correct?
Ask and answer.
Overruled. My granddaughter was not missing at that time.
I didn't ask you that, sir. I asked you whether that you didn't call the police to report your granddaughter was missing on June 24th. Did you, sir?
I didn't call about my granddaughter being missing on the 24th of June.
So
I
the
called
answer
a
is
reference to a gas cans being taken from my shed.
So the answer is yes.
Yes.
Now, when you had the police officer there, and you were talking about these gas cans, did you tell this police officer, my granddaughter's missing?
No.
Did you tell him, you know, my daughter has been basically not telling me the truth as to where she is?
Objection. Argumentative. Assumes facts that are not in evidence.
Overrule at this point, Mr. Ashton.
Did you tell that to the deputy when he arrived?
No.
Did you tell the deputy, even though I'm reporting these gas cans missing, my daughter has been taking gas in the past?
No.
Did you tell the police officer, I even confronted my daughter about taking gas in the past?
No.
Did you call your daughter and ask her, hey, did you take gas?
No.
You didn't do any of those things?
Did not.
Instead, you picked up the phone and called the police?
Yes.
Now, this alleged argument that you had with her, you stated that she basically came in, was in a hurry.
Yes.
And she told you she had to go to work.
Yes.
And you told her you needed to get something out of her trunk.
Yes.
And she didn't want you near her trunk.
Yes.
And she opened the trunk.
Yes.
And you didn't smell anything.
Yes. Didn't smell anything.
And you said, I hate to say this. Here's your fucking gas cans. You said that, right?
That's what she said to me.
But that's what you testified to.
Yes.
Now, when she gave you these gas cans, they did not have any duct tape on it, did they?
Had no duct tape whatsoever.
And before that, actually, you could see in her trunk, could you not?
I could not.
I'd like to refer counsel to Bates, page 7921.
Could I have the date of the statement?
July 30th, 2000. Sorry.
Remind you one more time. When you speak, speak into a microphone. Walking around and talking, the court reporter cannot hear you. So if you're not at the podium, you're not with a microphone on, do not speak. You may continue.
Yes, sir. Mr. Anthony, do you recall giving a statement to the FBI on July 30th of 2008?
I don't remember the exact date, but I talked to the FBI and
you talked
numerous
to
times.
An agent, Scott Boland. Do you remember speaking to Agent
I remember who Scott Boland is, yes.
And do you recall that they videotaped you?
I'm sure we were videotaped numerous times, yes.
And page 44, line 21 and 22.
Find it.
Yes, sir.
Thank you, sir.
May proceed.
When Agent Scott, do you recall Agent Scott Bowling saying, okay, when she popped the trunk, were you back at the back of the car? And you answered, yeah, there was definitely, I could see clothes back there. Do you recall making that statement, sir?
I don't recall making that statement, but presumably I guess I did if it's written down there in written word.
So your testimony under direct examination that you couldn't see what was in the trunk of the car was not true, sir?
Objection.
Overruled.
You may answer.
I don't recall exactly if I saw clothes in their car or not. I was at the passenger rear corner of the car when Casey pulled the gas cans out.
You know that the trunk of this car is an issue in this case, do you not, sir?
Absolutely, I know that.
And you know, by coming and testifying for the prosecution, that you couldn't see in the trunk of the car would give the impression that you weren't close enough to smell it.
Objection.
Don't you, sir?
Argumentative. Sustain as to that question.
If you testified, sir, under direct that, well, strike that. Mr. Anthony, you actually were close enough to smell the trunk of that car, were you not?
The only smell that I had was the smell of gas cans when they're placed on the ground in front of me.
And you did not smell any smell of human decomposition on June 24th of 2008 in the trunk of your daughter's car?
Did not.
Now, you just testified that when Casey gave you the gas cans, it did not have duct tape on it, correct?
Which one are you talking about, sir? There's two of them.
When she said, here's your fucking gas cans, it did not have duct tape on it.
Which one are you referring to?
Neither. Neither one of the gas cans had duct tape on it.
Again, you're not being specific with me. I'm not trying to be argumentative, sir. You're not being specific with me.
Right. Can you see on your screen?
Yes.
That gas can?
Yes, sir. And if you would describe that as being one that was a cylinder shape, right. I would agree with you. We wouldn't have had this.
Okay.
Moment.
Is that clear enough for you?
Yes, sir.
That did not have duct tape on it, did it not?
When my daughter gave it back to me that day on the 24th outside in our our driveway area, it did not have a piece of duct tape on it.
Okay. And we're clear about that?
Yes.
Crystal clear.
Objection. Argumentative. Ask and answer.
Sustain.
Now, Mr. Anthony, this photograph was taken by law enforcement, was it not?
Yes.
Okay. Now, she gave this gas can back to you on the 24th, correct?
Yes.
Now, the reason you called the police is because you had to mow your lawn.
Yes.
And there was no gas.
Yes.
And between the 24th of June and August 1st, you had to cut your grass.
Probably did.
In fact, you're pretty religious about it. You cut your grass every week.
Not every week, every other week, every 10 days. It just depends.
referring to the deposition, Mr. Anthony's deposition. August 5th, 2009, counsel. Okay. Page 199, lines 14 through 17. Mr. Anthony, do you recall making this?
Your Honor, if I may just have a moment to look at it?
Sure.
Just a second. Okay.
Mr. Anthony.
What's the objection?
It does not qualify as an inconsistent statement.
12 through 17?
Yes, sir.
Okay, let's approach the bench. You may proceed.
Mr. Anthony, you try to mow your lawn every week or at least every 10 days, do you not?
Yes.
And in fact, during that time period from June 24th to August 1st, you did mow your lawn.
I'll have to maybe agree or not agree with that. I'm not really sure. I don't write that stuff down on the calendar.
How many days is from now? On June 24th, your lawn needed mowing, did it not?
Yes.
And that's why you were out looking for the gas cans. That's something funny, sir.
Your question is sort of funny to me. I mean, to have my mower run, it has to run on gas. So I'm just sort of just chuckling a moment about that. But yes, I'll agree. Yes, I mowed the grass. I wanted to mow the grass that day. I didn't have fuel for the lawnmower to mow it with.
So you mowed your lawn. Obviously, the grass was high on June 24th, enough to need mowing.
Yes.
And between June 24th and August 1st, that's 6-7 weeks, right?
No, sir. It's only a few days.
You forget the month of July?
No, starting it from month of July. You said weeks, sir, and first you brought it up to August 1st. It's a month, maybe 5 weeks. I'm sure I cut the yard sometime in July, end of June.
May I ask the witness to stand down, Your Honor?
Witness may stand down. Okay. Make sure there's a break between the question and the answer, and make sure that the answer, the court reporter can hear it. Please face the court reporter when talking.
Your Honor, could I ask Mr. Bias to step to the side so that I can see what's being
You may want to move so you can see.
Yes, sir. Thank you.
Can you please put down the date that you last saw Kaylee? Can you please mark the day you needed to cut your grass? And then can you please put police report on the 24th, the same day? Can you please mark the date you informed law enforcement of this gas can incident with your daughter?
Your Honor, counsel has placed the July over the June, so we can't mark the June date because the July is up.
No, it's already been marked.
I'm apologies, maybe I'm missing the question. The question was the date you informed law enforcement, which was, he just testified to you.
After your daughter, can you put down the date your daughter, your granddaughter was reported missing? Can you put down the date you told law enforcement about this argument you had with Casey over the trunk and the gas cans?
I don't know when I had given that information.
Did they confiscate the gas cans immediately after you told them?
You have to come up with the dates, sir. I have no idea.
On August 1st, 2008, did law enforcement collect gas cans from your home?
If I might look at that photo, I can probably give you a better idea.
Yes, sir. If that refreshes your recollection, go ahead.
That photograph shows that cylinder gas can on August 1st.
And on August, did you go with law enforcement to your home to collect the gas cans?
A second time I did, on another particular date.
When you told law enforcement of this argument, when was that?
I have no idea. I have no idea when we first discussed that. I don't have it. I'm not a human calendar. I don't have anything in front of me to show me. You might have that information, or the state might. I'm not trying to be argumentative, sir, but you're throwing stuff all over the place there.
On August 1st, July 30th, did you tell the FBI when you met with them about this incident with your daughter?
That's a possibility. I don't have the records in front of me. I don't have any indication of what I said at those different times.
I'll take that for you. If you have a seat, I'll get you that. I need his. I'm not, Judge.
Okay. You may.
Showing you, Mr. Anthony, your statement given to the FBI on July 31st. Can you turn to page 43, please?
I'm sorry, I couldn't hear. 43, is that?
I would direct you to lines 21 through 25.
Okay.
Having read that, does that refresh your recollection?
Objection, Your Honor, as to what?
As to you telling law enforcement about this incident.
I don't believe he's indicated a failure of recollection. I'm sorry, speaking of objection. I have an objection. I would need to explain to the bench.
Let me try and
rephrase the question
to move this along. Mr. Anthony, do you recall telling anyone about this gas can incident before July 31st, 2008?
Yes, because I made a report on the 24th of June.
Let me rephrase that. Since Kaylee was reported missing, did you make any statements to law enforcement prior to July 31st, 2008?
You're trying to confuse me here. Yes, you are, sir.
No, sir, I'm not.
We're talking about a gas can. You're talking about my granddaughter. So be specific with one or the other, sir, and then I'll be more than glad to get through this with you.
I'll rephrase the question.
Thank you.
You need to go to the microphone if you're going to ask them questions.
From July 15th, 2008, that was the day you reported your granddaughter missing, right? She was reported missing on that day.
Yes.
And this statement was on July 31st, 2008. Do you recall making any statements about the argument with Casey prior to that?
If you're talking about what's here in the printed word about the gas cans,
That's what I'm referring to. Yes, sir. This argument, this alleged argument that you just finished testifying about for almost an hour, did you tell anybody about that before July 31st?
I'm not sure when this was exactly done, sir. I'm not sure when this deposition was taken through. You have to be specific with me, sir. Give me a date, and I'll answer.
I'm giving you a date, but my
no, sir. You are badgering me. You're trying to get me upset, sir.
Listen.
No, wait, Mr. Anthony. Did you finish answering the question, sir?
Yes, Judge, I did.
Okay, question.
Did you give law enforcement or tell anyone in law enforcement about this alleged argument before July 31st, 2008? Do you recall?
If I may answer your question as politely as I possibly can, according to what I can see here, I did give information about the gas can and about having an argument with my daughter on the 31st of July. It's right here in printed words, sir. It's right here.
Okay. Can you come, please, and write down the day you explained the arguments?
Remain seated, sir. Now, do you have something to ask Mr. Baez?
Yes, sir. May the witness stand down.
Witness may stand down.
Can you please mark on July 31st argument, or date of reporting argument, please? Can you please put a 1 next to the 31st so we know that that's August 1st, Friday? Little box. Have a seat. No, sir. From June 24th to August 1st, when the gas cans were collected, did you mow your lawn?
Yes, I'd purchased some other gas cans along the way.
Did you use those gas cans? Put gas in them?
No, I did not.
Are you certain?
On a scale of 1 to 10, I'd probably give myself probably a 9.9.
Okay. And since you didn't use them, you probably didn't put any duct tape on that gas can since you mowed your lawn from the 24th to August 1st, right?
I just answered your question. I'd purchased other gas cans. I don't believe I used them after that.
So you wouldn't have probably put a piece of duct tape on that gas can.
Objection to speculation.
Overruled. The question, sir.
If I can reiterate here, this piece of tape that's on this can right now, I'm probably the one to put that on there prior to it being taken, because the simple fact is, I'm going to get very technical here for you. Whenever you have gas inside of a can and it gets a very fumy type thing, it could explode. So I probably put that in there when I set it aside. I'm just speculating probably what I did. You're going in an area, sir, that my life and my wife's wife...
Judge, I'm going to object to this narration and ask that it be stricken.
Overruled.
Mr. Anthony.
You want me to witness? Finish answering the question, sir.
My life and my wife's life, when this started for us, we were running on fumes, going day by day, just trying to find my granddaughter. And some of these things that you're asking me to be specific on, I'm trying to do the best I can. Is there some things that I might not remember exactly? I think that happens to anyone. But when you get into this thing with you and I, sir, you're going off in a way to get me more upset, and I don't think that's fair. I'm just asking you, treat me with a little bit of respect, and you'll get respect back. That's all I'm asking.
Mr. Anthony, would you like to answer my question now?
Objection to counsel's commentary.
Sustain.
Would you like the...
Next question.
Do you remember my question, sir?
No, sir, I do not.
Can Your Honor, may I ask the court reporter read back the question to the witness?
Court reporter may read the question back.
Question, so you wouldn't have probably put a piece of duct tape on that gas can?
And your answer to that question, sir?
To store that gas can in my shed, after receiving it back, I would have put a small piece of duct tape on it to cover that vent hole so it wouldn't have a fumy smell inside of my shed.
And you just testified a moment ago that you put that piece of duct tape on that can, did you not?
I'm presumed that I'm the one to put that on there.
Okay. Deposition page 160, line 11 and 12. May I proceed, Your Honor?
Just a second.
Sure. Do you recall giving a deposition on this case, sir?
I've given numerous depositions on this case.
On August 5th, 2009.
Can you give me a location where this was held?
At the State Attorney's Office.
Yes, I remember that.
I was present.
Yes.
Mr. Ashton was present.
Yes.
Your attorney, Brad Conway, was present.
Yes.
You took an oath.
Yes.
To tell the truth.
Yes.
The whole truth and nothing but the truth.
Objection. Argumentative and editorial commentary.
Sustained. Rephrase the question.
You took an oath to tell the truth, sir.
Yes.
And do you recall being asked a question by Mr. Ashton? Now, the gas can appears to have a piece of duct tape on it. Do you recognize that? And do you recall giving the following answer? I didn't put the duct tape on there.
Okay, we can clarify this right now. This gas can...
My question, sir, is do you recall making that statement?
Interrupted.
Sustained. Let him answer the question. Mr. Anthony, you may answer the question, sir.
I'm trying to clarify. This gas can was taken from my residence on 2 occasions. The second occasion that you're referring to, that it was taken, when I had seen the photograph of it, there was a larger piece of duct tape on there. I did not put that on there. If that's what you're talking about, sir.
I'm referring to this piece of duct tape in the image standing that is right before you, sir.
But, sir, this is not the one that I was shown on August 5th of 2009. This is not the photograph that I was shown.
If I can have just a moment, Judge. Page 163, lines 8 through 20. Sir, do you recall the first? Yes, sir.
All right.
Objection, Your Honor. Not an inconsistent statement.
Just a second. Mr. Baez.
It's giving the date there, Your Honor. May we approach?
No.
I think it's fairly clear.
Well, you can ask them a question about the date, but you don't need to read the deposition.
Do you recall?
Remember, this image that y'all keep referring to is not in evidence.
Yes, sir.
So it's kind of hard to question somebody about something that's not in evidence at this time.
At this time, yes, sir.
Proceed.
Mr. Anthony, were you not advised that this photograph that's in front of you was identified with the date during your deposition?
Again, sir, this particular image of this particular photo was not shown to me in your presence and in the state attorney's presence on the August 5th of 2009. This was not shown to me. There was another photograph of a gas can that could have been this one that was more filthy dirty because of powder from like fingerprints and stuff like that, and a larger piece of duct tape being on it. This is not the one that I was shown in August 5th, 2009. This is not it.
May I proceed, Judge?
You may proceed.
Do you recall being asked a question by Mr. Ashton? This photograph was taken on August 1st.
Same objection.
May I finish the question, Judge?
Approach, folks. You may proceed.
Yes, sir. Mr. Anthony will return to this photograph at a later time.
Objection to counsel's editorial commentary.
Overruled. Let's proceed, gentlemen.
Now, Mr. Anthony, was it your testimony? Well, let me ask you this. When you gave the gas cans to the police on August 1st, did the gas cans have duct tape on it?
Again, you're asking for cans. Be specific and say a can or give me a description, sir. I'll help you any way I can.
The cylinder gas can that you've had for 20 years that is almost a part of you, when you gave them that gas can, did it have duct tape on it?
Well, this photograph shows it for August 1st of 2008. Yes, it shows that it's on there.
So is that your testimony today, sir?
Yes.
I refer counsel to page 210. Lines 1 through 11. Now, Mr. Anthony, the can that you are looking at right now, that's the one that's 20 years old and is sort of a part of you.
Did y'all hear anything that I said at sidebar?
Yes, sir. I'll rephrase the question.
Okay. Let's take the jury out.
All rise for the jury.
You may be seated. The cane, which you keep referring to as what's the exhibit number, Madam Clerk, for identification?
Your Honor.
Do not interrupt me, sir.
It's AJ for the record.
AJ? Okay. The state's exhibit AJ is not in evidence, as I said at the sidebar conference. Until it's in evidence, you can't question somebody about a photograph that is not in evidence. The only questions that you could talk about are foundational questions. I don't know how many times I have to tell.
Maybe I can be excused during this argument.
No. All I'm saying is move on to another area. It is not in evidence. When it goes in evidence, then you're free to question him, but the item has not been introduced. How are you going to question somebody about something that's not in evidence? You're questioning about a photograph that's not in evidence.
I would like to proffer to the court at sidebar or outside of the witness's presence how I intend on referring to this. And
Sir,
how I intend on
I am not coming to sidebar on this item now. The one thing we can do is let you proffer Mr. Lazario's testimony, since I've taken the jury out at this time. As to that, Mr. Anthony, you can step down for the moment, sir. Return, Mr. Lazario. No.
Your Honor, I don't believe that Mr. Lazario is currently here. He knows to come back.
Who told him to leave? I asked that he remain outside.
Your Honor, it was requested of me if they could get an early lunch. I anticipated not needing him before the lunch hour actually started, and okay. I apologize.
Let me make myself abundantly clear, folks. I asked him to remain outside. The defense had requested to proffer his testimony. So don't do it again. Yeah, Mr. George is just informing me that he left. Does the state intends to introduce this photograph? You didn't at the time.
Eventually, yes, sir. When it's properly authenticated, we have a full explanation of how it came to be. My understanding as by way of proffer is that Mr. Anthony wasn't present when this photograph was taken.
Mr. Bias, you can question about cans all day long, but you cannot question him about that particular photograph, which is not in evidence. Okay, if anybody needs to take a break, you got 5 minutes to take a break. After that, we're going to charge on through until noon. We'll be in a 5-minute recess. Couple of housekeeping matters. I have a couple of questions from the jurors that I got this morning. The first question reads as follows. Are the first 12 jurors the one who decide the case, or is a new order picked at the end of the presentation? Question 2. At the end of the presentations, are the alternates allowed to go home? My proposed answer to both of those questions is at this time I cannot answer your questions concerning questions 1 and 2. that's something they don't need to know at this particular stage. Any objections from the state or the defense? He agrees.
That's fine. I agree also perhaps with an additional suggestion that all of the need to pay, the most careful attention and something to just encourage them, each and every one, to be attentive. Sorry, my mic wasn't on. I apologize.
Okay. The other one is basically a couple of housekeeping things. They want to arrange to watch the Tampa Bay Lightning game Friday night in the common room. So I'm having to make sure that what network it's on and whether or not they run any news on that particular network. And the other one was they wanted pretzels in the break room. The other question that they had, some of them apparently they keep diaries or daily journals that they've kept throughout their life, and they want to know can they continue to do that, or whether or not they should or should not do that.
My only suggestion would be if they want to write about something other than the case, since obviously when they're taking notes here, they're told to leave them and that they will not get them back. Going back to the hotel and then writing what they remember happened during the day seems to violate that.
Yeah, it does.
I would agree with Mr. Ainberg.
Okay. And the other items just basically have to deal with some other issues that I need to talk with them, but I take a court reporter back with me. Just common questions about security that I'm not going to discuss here. On their first two questions, when they come in, I will answer that in open court, and I will tell them about the lightning, the pretzels, when I talk to them with those other subjects. Okay, let's return the jury, and then we'll return Mr. Anthony, but let's return the jury first. Okay, let's stay recognized, President Jury.
Yes, sir.
And the defense. Okay, members of the jury, some of your questions that you wrote to me, I can answer here. The balance of those questions I will answer at noon for you back in the jury room. The question that you had about the first 12 jurors would be the one that would decide the case. And the second question at the end of the presentations, are the alternates allowed to go home? Members of the jury, these are questions that I cannot answer for you at this particular time. As I told you earlier, all jurors, and we have not openly told you who are alternates and who are not alternates, are to pay close attention to all of the evidence during the trial. It's no secret that it's a long trial. May or may not be as long as we thought, but I won't know that until probably the end of next week. So don't worry about that. Worry about paying close attention to the evidence, and we will get you back home to Pinellas County as soon as we can. The question for those of you who keep journals or diaries, remember what I told you at the beginning. You may take notes. I also told you that you can take notes on the trial in here and not to take notes away. Consistent with that instruction, if you keep a journal, you need to talk about everything in your journal except what occurs in this courtroom of things dealing with the trial. So if you had a show that you watched or had a nice walk or a conversation with some juror you want to chronicle, or friendships you've made or not made, you can write that, but you can't write anything about the trial in your journals, okay? Because what happens with your notes, once you leave your notes here, all the notes are placed inside of an envelope. Those notes are taken and secured away at night. So when you leave out of here, what happens, they are immediately taken out. They're placed inside of an envelope, and then they're locked into a vault overnight. So that's what happens to those. The other things I will talk with you back in the back. Hopefully at the end of the day I will have an answer about the Lightning. For those of you who are interested in the Tampa Bay Lightning and the hockey game. Okay, let's bring Mr. Anthony back, please. Okay, you may proceed, Mr. Bass.
Yes, sir. Mr. Anthony, I want to ask you a question. I want to be clear about it, so I'm going to... it's going to be a little bit of a long question. So this jury can be absolutely certain. The round cylinder gas can that you have had for over 20 years, when you gave it to law enforcement on August 1st, did it have a piece of duct tape on it?
Yes.
And you're 100% certain of that?
Yes.
Okay. Now do you recall after your granddaughter was reported missing on the 15th, and your daughter was arrested on the 16th, correct?
Correct.
And on the 17th, a detective came back by the name of Appy Wells came to your home. Do you recall that?
Objection. See scope of direct.
Relates to the gas can, Judge.
I'm sorry.
Sustained, that wasn't a question about a gas can.
I'm getting there.
But it wasn't a question about a gas can, sustained.
On July 17th, 2008, did Detective Appy Wells search your shed?
I don't remember.
Do you remember Detective Appy Wells coming to your home the day after your daughter was arrested?
No, I do not.
Do you remember you giving Detective Wells a tour of your backyard?
At some time, I'm sure I did. If you're asking for a specific date, I don't remember. Again, this is when everything was happening. We had so many people around us.
Do you remember if you opened the shed where these gas cans were held at any time for Detective Wells?
Not presumably him, but I know I opened the shed up within probably one of those first few days, because we had the cadaver dogs at our house. We had law enforcement, media, everywhere.
That shed where these gas cans are stored, how many shovels are in there?
Objection. Exceeds the scope of direct.
The shed has been brought up, Your Honor, and discussed during direct examination.
Overruled.
How many shovels are in that shed?
3 or 4.
So you have 3 or 4 shovels in that specific shed?
Yes.
And would that these gas cans are stored in?
Yes.
You also have expensive lawn equipment, right?
Yes.
Mowers, weed eaters?
1 mower, 1. Yes, I'll agree.
When you showed the shed to the detective or whomever you showed it to, did you inform them of the argument that you had with your daughter on the 24th?
I probably did share that with them. I don't know. I don't remember.
You don't recall, or you probably did. Can you give us a clear
I just
answer?
told you, sir. I don't remember if I did or not. There was just a lot of things that were talked about and shown.
The first night that your granddaughter was reported missing, you spoke with detectives, did you not?
Not on the 15th, I did not, no.
You didn't speak to Detective Melich that evening or the early morning hours of the 16th?
On the 16th, I did.
And you told him about the smell of the car that evening, did you not?
Objection. Exceeds the scope of direct.
Sustained.
Did you tell Detective Melich about the gas cans and the argument you had where your daughter wouldn't let you near the trunk of the car when you spoke with Detective Melich that evening?
Objection. Proper impeachment. I'd like to explain more to the bench.
Overruled.
I don't remember saying that to him, no.
What about the 16th? Did you talk to detectives the 17th. Did you talk to detectives on that day?
I had talked to Orange County Sheriff's detectives numerous times that first week or two.
And on all of those dates, who did you tell about this argument before the 31st?
Improper impeachment, and I would like to explain to the bench.
Sustained.
Did you ever tell anyone from law enforcement prior to July 31st about the gas can fight with your daughter?
Objection. Improper impeachment.
Not impeachment.
I would like to.
Overruled. You can ask the question.
I probably did in some course of one of those days. Possibly I did. I don't know. I don't remember of every bit of conversation I had with law enforcement, FBI. I don't remember all those things.
So you can't recall?
I answered at least 3 times. He does not remember. He can't recall. Move to another area.
Yes, sir. Now, Mr. Anthony, you've had the opportunity to sit in the courtroom throughout all the testimony, have you not?
Yes.
In fact, you asked your lawyer to...
Mr. Baez, do not go there. Next question.
You were specifically excluded from the rule of sequestration?
Mr. Baez, approach the sidebar. You may proceed.
Judge, I have no further questions of this witness at this time.
Okay. Witness may stand down. You have any redirect? Okay.
Yes,
you
sir.
may proceed.
Thank you. Mr. Anthony, the gas can that Mr. Baez spent a good deal of time talking to you about that you gave to law enforcement on August 1st, did they give that back to you the very next day?
It could have been the next day or the day after. I'm not really sure, but it came back fairly quickly.
At the time in July and August of 2008, did you have any idea that that gas can had anything to do with the death of your granddaughter?
No, I did not.
In December of 2008 that its importance become clear?
Objection, Judge. This goes beyond the scope of cross-examination. We didn't discuss anything on the subject.
Overruled. Could you ask that again, please?
In December 11th and thereafter, did the significance of that gas can become clear?
Yes.
Did you keep possession of that gas can from when they gave it back to you in August until they took it? I'm sorry, let me ask this question. Did they take it from you a second time in December?
Yes.
And did you keep that gas can in your shed along with all your other garden tools from August to December?
Yes.
On August 31st, when you mentioned to the FBI about this incident with the gas can, was that in the context of a several-hour interview about?
Overrule at this point. Let him finish answering the question. Mr. Anthony, do not answer the question until I instruct you to answer. You may continue.
Was the subject matter that the FBI talked to you about a very broad range of subject matters?
Is there an objection to the question as formed now?
Yes, Judge.
What is the objection?
Leading.
Overruled. You may ask the question. Yes.
Did they ask you about everything that happened between June 16th and July 15th?
Yes.
And is it in the context of that you mentioned the incident of the 24th?
Yes.
June 24th of 2008, did you believe that your granddaughter was alive and well and being cared for by your daughter?
Yes.
Did you have any reason on June 24th to suspect that your granddaughter was either dead or missing?
No.
When did you first learn that what you thought on June 24th was wrong? That in fact she wasn't in the care of your daughter?
On June 24th, I didn't see Kaylee with Casey.
But when did you first learn that there was a possibility that on June 24th, your granddaughter was at the very least not in the care and custody of your daughter?
Through conversation I had with my daughter that someone else was watching Kaylee.
That was then?
Yes, sir.
But you still thought that your daughter was aware of where she was?
Yes.
Did you learn on July 15th that what you had thought on June 22nd, 24th was in fact not the case?
That was not the case because Kaylee wasn't with us. Kaylee wasn't home.
I may have just a moment.
Okay, read crosses to those issues and those issues alone.
You knew on June 24th that these gas cans would become an issue in this case, didn't you, sir?
Objection argumentative.
Sustained. Not on June 24th. Objection was sustained. Rephrase your question.
You know that these gas cans are a significant issue in this case, do you not, sir?
I do now.
And it was you who reported these gas cans missing on June 24th, knowing that your daughter had taken gas many times before.
Yes.
And knowing that you never even called your daughter to see if she had the gas cans?
That exceeds the scope of redirect and asked and answered.
Sustain as to asked and answered.
But yet you sit here today, sir, and claim that when you reported these gas cans missing on June 24th, you had absolutely no idea that you would be reporting to the police about a piece of significant evidence in this case.
Argumentative, asked and answered.
Overruling and answered for the last time.
On the 24th of June, 2008, I did not know that a few weeks later that my granddaughter would be reported missing. If that's answering your question, sir, that's the best I got at the moment.
Despite that you haven't seen your granddaughter in 9 days and she lived with you every day, right, sir?
Argumentative, asked and answered.
Sustain. Okay. This may stand down. Thank you, Mr. Anthony.
I've got a jury trial in Benton on Tuesday, which I will continue in deference to this case if there's something that we need to. I want to avoid any disputes. So I'm saying I can take up discovery matters, whatever we need to do. Not available next Wednesday. I can be available next Thursday or Friday. The following week, I can be available July 3rd, and then after that, we're a little close to trial. Potentially, I could be available the 5th. That's the day before we finish our jury selection. I will let the press know there will be no cameras on the 6th.
Welcome back to the LawNewz Network. We're sorry that we jumped from one courtroom to another very quickly there for some reason, but we've been listening to clips from the Casey Anthony trial from the archives in 2011. We all know at this point that she was acquitted of the most serious charges related to the death of her daughter, Kaylee, but she was convicted on some lesser misdemeanor counts, only one of which eventually stuck on appeal, related to giving bad information to the police. Julie Rendelman is here with me, and she's been with me on a couple of client phone calls and whatnot, but listening into some of the testimony, we know that you work around the clock. Yes. Your website says call anytime, day or night, 7 days a week. I'm just making it up. I'm assuming that that's what's going on. So a lot of emphasis here about these gasoline cans, and the theory goes that the initial testimony from the father was that he came home, the lock on his shed or garage or whatnot was broken, and that he ultimately realized gas cans were missing. He had to go buy new gasoline cans. It turned out that his daughter Casey had the gas cans, threw kind of a fit about returning them at some point. And we started to see photos of the gasoline cans with duct tape on part of them for some reason or another. And the theory goes that the duct tape from the gas can somehow wound up on little Kaylee Anthony's skull or mouth or somewhere in there when the girl's body was found, and that therefore the chain of custody of the duct tape could have gone from the gas can in the garage to Casey Anthony to Kaylee Anthony. But we saw a lot of pushback there in the last couple of minutes about why this didn't come out sooner. What do you make of it all?
I guess he's trying. I mean, look, I admit I'm one of the few people that maybe didn't follow the case at the time it was going on.
You and me both. I was in law school though, so I had an excuse.
I was not in law school. I don't know what I was doing on those weeks. But you know, it almost sounds. Look, he's questioning obviously he's questioning the credibility of the father, because one of the things he's saying is, if you thought it was so important, why weren't you telling them about the interaction, or kind of the hostile interaction you had with your daughter in regards to the fact that she didn't want you going into the car to get the cans? What did she have to hide there? That kind of thing. And so he's making, obviously, which seemed to be kind of one of the big crux of the case, was questioning the credibility of the father of Casey Anthony, and in a way maybe somehow indicating to the jury that he may have been the one responsible for the child's death. And so by questioning him in these areas, he's potentially poking holes in the case regarding Casey Anthony.
Now, you've got the defense tactic here right out of the gate in the opening statements to point the finger at that man, the father, and say he had sexually abused Casey from her early days. So the minute he gets up on that stand, the jury automatically hates him. And we've seen this tactic in other subsequent Jose Baez trials.
Right.
Does it seem to be a winning tactic to find the person that's the easiest to somehow demonize, to take the jury's attention away from the defendant and slap it on some witness?
It is, and it is a winning tactic.
You seem to be admitting to doing this.
No, actually,
Okay.
one of the things that kind of, and it was interesting, you at some point you were listening to the I think it was the co-counsel on the case, one of the gentlemen talking about, one of the differences between being a defense attorney and a prosecutor is kind of the rules of evidence and the rules of ethics are a little different for a prosecutor than they are for a defense. And the question becomes kind of how far are you allowed to go as a defense attorney? Because, when anyone looks at this case and they start to talk about the idea of whether or not there was any evidence that the father sexually abused Casey Anthony, it seems to me that everyone agrees that there was absolutely none. It was just kind of a speculation that he threw out there with perhaps a little rumor, and perhaps there's more that I'm unaware of, and seem to kind of focus in on that from the start. And so some do start to question, well, is that right for a defense attorney to be allowed to do that if there's not a good faith basis? Now, obviously, he would argue, well, there was a good faith basis. Either the client told him or someone else had told him, so at least he had the right to bring it up. As to how far you're allowed to take it, I think it's up to the judge at that point to kind of quash it, because at the end of the day, especially in this case, nobody testified that she was abused. So you kind of, it's imperative for the prosecutor and the judge to make it clear to the jury that they have to understand that it's not the question, it's the question plus the answer. It's not the opening, it's what the evidence is.
Yeah, and I have to look back at it and say, okay, she's subsequently been complaining about the poor quality of her life, but her defense tactic more or less severed her ties with her family.
Permanently.
I mean, that just left so much bad blood on the table that even if you take away from it the family stress of losing little Kaylee, look at the defense tactic. And it sounds like they had a pretty rocky relationship, even if we're to take the father's testimony at face value. He's specifically saying in this clip that we just listened to that she was relatively nasty to him when she finally returned the gasoline can. So maybe there just was already enough bad blood on the floor that it didn't matter what she threw out in front of the jury at the trial. But I mean, look at the upshot of it.
But again, I didn't follow the case, so I do wonder. I'm still not sure how. Even if it was true that the father sexually abused Casey Anthony, how that would have been relevant to the story of the child. There was no allegations that he sexually abused the child, and so the issue to me seemed to be whether or not the child died by accident at the hands of the grandfather, or by accident at the hands of Casey Anthony, which was one of the biggest issues of the case because of the autopsy not being able to delineate kind of the cause of death. But I'm not sure how the idea of the father abusing Casey Anthony or not abusing her has real relevance to me in terms of how the story goes.
I'd really have to go back and listen to the way it was specifically argued, but it seems ultimately to be another measure of scapegoat defense. Well, I can't tell right or wrong because this is what happened to me. This messed up my ability to process and deal with things. It was an accident, and I can't deal with it because it was an accident that happened at the hands of my father who abused me. And then look at what the father did to the daughter, and I just broke down and couldn't process it, couldn't call the police, lied to the police about it. That sort of trajectory seems to be what Jose Baez was cutting through.
Right, exactly, except that you again have to go back to the fact that she didn't testify on her own behalf, so there was absolutely no evidence of that. And so again, when you're speculating before a jury, again, it's up to the prosecutor, and look, he did a good job of getting in there that of which, quite honestly, even after we talk, really has no relevancy because there's no evidence of it. Look, you ask a witness a question. You ask Mr. Anthony, did you abuse your child? If the answer is no, what else are you left with? You're kind of done at that point because there's no other witnesses that are going to come out and testify to it.
Well, see, this is the thing that the juries need to key in on, too. I mean, if I'm sitting on that jury, And I remember this because I served on a jury trial when I was in my very early 20s. I was right out of undergrad, and it was a civil case. But I remember the judge specifically telling us the instruction that we always hear, and with me, it stuck, where the judge said, argument is not evidence. If they, in other words, I took it to mean if they say something and it doesn't come out of a witness's mouth, then I could just assume that it didn't even happen.
Right.
So mentally, I was used to working as a journalist at that point and taking a set of facts and saying, okay, which ones are garbage and then which ones are probably relevant. And if I had been sitting on that jury, I would have just turned around and said, hey, look, if you're not presenting evidence that there was actually abuse, I'm going to assume it didn't happen and you're trying to pull the wool over my eyes.
But you're also, I agree with you, but you're also assuming that the basis of the jury not finding her guilty of the most serious charges is because they believe that. And we go back to one of the issues which, you know, Baez had going for him from the start, which you don't have the cause of death. And so when you don't have the cause of death and you can't rule out that this happened by accident and she just chose, you know, to not come forward with regards to the truth about that, then you're, you know, you're kind of, I have to be honest, you know, he's in a very good position, at least with the top counts, because how is a jury, you know, it's hard for a jury to find someone guilty of a top count when you don't have proof of any type of intent.
Well, Beth Karras, who is a host here at LawNewz and who was covering this case, was in the courtroom, said this morning that one of the jurors who did come out said we had to vote to acquit, but we didn't think that meant not guilty.
Sure.
You know, so it seems based on that comment that the jury thought something was up, but that it just hadn't hit the proper burden.
Right, right. Which
it wasn't beyond a reasonable doubt.
Sure, which is, you know, look, when any time when a defendant wins or is acquitted of a case, the question becomes, well, did the defense attorney win or did the prosecutor lose? And I mean, it's kind. I mean, they're all the same thing. But did the defense attorney do such a stupendous job that, you know, no matter who the prosecutor was, they were going to win? Or is it just the prosecutor didn't do a great job? Or is it a blend of the two? I don't really have the answer. But, you know, when you have a defense attorney that's raising issues that kind of are these red herrings that don't really seem to really be relevant to kind of focusing on the main point, then you have, as a prosecutor, the obligation to get your jury to understand, just like you said, as a juror, to kind of ignore those things that are being purposely thrown at you to try to throw you off.
Yeah, well, we're going to continue listening to some of the testimony of the father. We've got another clip where he gets into another area of testimony here. This is clip 7. He starts talking about Casey Anthony's car being towed and getting it back, and the process of that uncovered a disturbing smell. The accusation is that the smell was the decaying corpse of little Kaylee Anthony in the car. But that also led to some tough cross-examination. We'll be able to get into this a little bit before we wrap up the day today.
George A. Anthony, George, middle initial A, Anthony.
You may proceed, Mr. Ashton.
Thank you. Good afternoon again, sir.
Good afternoon, sir.
I want to direct your attention to the middle of July of 2008. During that period of time, did you learn that the vehicle that we discussed earlier that you owned but your daughter drove had been towed?
Yes.
Tell us how it is you first learned of that fact.
I had learned of that fact for getting a notice from the United States Postal Service that was placed on our front door.
Do you recall when, did you find the notice or did your wife find the notice?
My wife is the one that located the notice at the front door.
And when did she inform you of finding this notice?
I believe it was Sunday the 13th of July. We had been outside working.
Now, you said you found it on your front door, or she found it. I want to ask you if you didn't find it. So she indicated where she found it.
Yes, at our front door.
Is the front door of your home the door that you normally use for ingress and egress, coming and going normally?
Absolutely not. We go through our garage.
Now, so it was found, you said, on, you believe, Sunday.
Yes.
Do you recall what the notice said?
On the upper right-hand corner, it said the sender's name was Johnson, and it was addressed to both of us. It was a yellow, just a normal United States Postal Service notice that we had a certified letter at the post office.
This was on Sunday. Could you go to the post office on Sunday and retrieve it?
Oh, no.
And at the time you saw it, did you have any idea of what it was or what the certified letter was?
No, because I had looked at the name. I didn't recognize the name of anyone that I knew. And
all right. Now, so what did you do anything on Sunday in regards to this picking up this document?
No, I just mentioned to my wife that I would just go see what it was about on Monday.
All right. So Monday came along. Did you do anything about it on Monday?
No, I could not, because I just had started a new position with another company and had some work issues to go take care of, and I decided I would go ahead and do it the next day.
Was this the job that you talked about going to the interview for on the 24th?
Yes, I had gotten a
got
new
the job.
position.
All right. So you didn't go on Monday. On Tuesday, did you have a chance to go and follow up on this letter?
Right. Tuesday morning, I'd awoken. My wife had went to work. I had a couple errands to run, and I decided to go to the post office. And overall,
all right. When you went to the post office, were you able to collect the certified letter?
Yes.
Pardon me. Approximately what time was it that you were able to collect the letter?
Sometime right about noon time.
Right. When you opened the letter, what was it?
Well, on the envelope itself, I saw Johnson's Towing Service, a local address addressed to my wife and I, and opened it up and noticed that there was a notice that our vehicle had been towed.
Do you remember whether the off the top of your head, whether the letter said where the vehicle had been towed from or when?
I do remember something about an address and being towed on the 30th of June, 2008.
All right. But you don't right now remember the address?
No, I don't.
Okay. So you get the letter. What goes through your mind when you get this letter saying that it was towed on the 27th? Or 30th, I'm sorry.
Being concerned because I took a step back a second, thinking I was believing that this vehicle was at another location, was in my daughter's possession, and it just caught me a little bit off guard, like, why didn't we hear about it prior to this?
Where did you think the vehicle should have been at the time when it was being towed from whatever that location was?
The last I knew was in my daughter's possession, and she was possibly in Jacksonville, Florida with it.
And was that something that you were told by your wife?
Yes.
All right. So you got the letter, read it. What did you do next?
Immediately I called my wife, and I informed her where the vehicle was at, and I said I was on my way to that location to find out more about it.
And did you then travel to Johnson's?
Yes, I arrived at Johnson's Towing probably within just a few minutes because it's not that far away from the post office, and I inquired at the front reception area about our vehicle.
And what were you told?
That there was a normal procedure when a vehicle is towed. This letter gets sent out. I was a little upset about this charge of over $500. We live within a mile and a half of this location. I just asked a bunch of different questions, and yeah, I was a little bit upset because it didn't make any sense to me why we hadn't gotten a notice even quicker, or just a regular phone call like, we have your car.
Was that because it had been, I guess, a little over 2 weeks that the car had been sitting at the wrecker service?
Right, and considering how close it is to our home, it just would seem like a courtesy.
All right. So what did you do next?
Again, I reached out to my wife and explained to her how much it was. And she said that, okay, she says, I'll go ahead and stop at the bank. We'll get the money and we'll go and pick the vehicle up. I said, well, let me go home first. Why don't you come and pick me up, and we'll go down and get the car.
Now, did they tell you that you had to bring any documentation with you to pick up, to reclaim the car?
Well, besides our driver's license for identification, we also had to bring a title or copy of title with us to show ownership.
And is that something that you had with you as you stood there on your first visit, or that's something you had to get?
I had to go back I had to go back home, wait for my wife, and we came back with that.
Right.
That item.
Did you make any assumptions about why the car was left someplace? In other words, what could have happened to have had the car being left someplace?
Oro.
I mean, there's a lot of different things that ran through my mind is why I didn't get a phone call earlier about it, either from the tow yard or possibly even from my daughter. I was just, again, I was at a loss for words. Like,
my question was a little convoluted. Did you bring a gas can from home with you?
Just because in the past I've had some experiences with have a vehicle towed or had to go pick a car up from a friend or whatever it might be, and it was always just a common thing to bring some gas along.
And did you bring some gas along on this occasion?
Yes.
All right, so you went home. Did your wife pick you up at your house?
Yes, I waited for my wife. She arrived within a short period of time, and I had the title and some gas, and we went to the tow yard.
And can you tell us what happened when you got to the tow yard?
Well, again, we met with the same receptionist at the front tow yard, at the front glassed-in area, and we were both asked again the same questions over. Why did it take so long to be noticed? Why was it so much money? Sure, we were both very agitated because money for anyone is at a premium anytime, and that $500 some is just something we didn't understand how it could be so expensive.
Right. Did you stay there and talk to the people about the money, or did your wife do that and you did something else?
Both of us, to a point, did. I do remember a gentleman coming to the front glassed area with the receptionist lady and basically was starting to handle the transaction with us. And I remember we came of some kind of agreement that we would pay a certain amount. It wasn't that exact amount that they had first requested to make us happy or just possibly just to get us out of there.
Would it be fair to say that Cindy was rather forceful with the folks that were there?
Well, I believe so. She took more of the conversation because I was, I think, probably more irritated at the inconvenience for both of us having to take time to be there, and it's just a bunch of different things to go through.
Now, so you said a gentleman came to the window. Did you at some point leave with him?
Yes, I'm not sure how long it was. We'd had the conversation, but I do know that after we had made the transaction to pay for the vehicle, I was escorted to the car.
Now, as you approached the car, and again, by the car, we're referring to, let me not assume, did the gentleman take you to the Pontiac Sunfire, the car your daughter drove?
Yes.
As you approached the vehicle, did you smell anything?
Within somewhere probably close to about a 3-foot area of the passenger side of the car, I did smell a pretty strong odor.
What thought did that odor place into your mind?
I was very concerned about the odor. I had smelled something like that some years prior, and I was concerned.
What thought went through your mind?
That particular smell, whenever you smell it, it's something you never forget. It's a very distinct odor.
But was there a concern that came into your mind as you smelled that odor? Maybe I should be more specific.
My mind did race somewhat to the point as because I hadn't seen my daughter or my granddaughter for some time. I did worry that I did worry about for my daughter or my granddaughter, or both at the same time.
Do you have a thought that they might be in the trunk or in the car, dead?
I was hoping that wasn't the case. I was hoping that everything was okay. I was I didn't want to believe what I was smelling to a point. I was trying to not think too much ahead of myself.
The odor that you were testifying a moment ago that this reminded you of from your past, was that the odor of a human corpse?
Yes.
Now, when you got to the car, did you have keys?
Yes, we have, for each one of our vehicles, we have at least 2 or 3 different sets of keys that we keep for each vehicle. And yes, I did have a set with me.
Was that a spare set?
Yes.
Is that what you're saying? All right. So when you got to the car, what did you do?
I had first made a quick look at the car and see if there's any damage to it. I didn't see anything towards the passenger side or walking around to the front of the vehicle. I did reach towards the driver's handle, and I knew I could see the vehicle was locked, and I did put the key in to unlock it, and just made a quick look in.
Welcome back to the LawNewz Network, everybody. I'm Aaron Keller, and we're going to wrap the day up for here. We've been replaying clips from the 2011 trial of Casey Anthony. Her father's on the stand, and Julie, this is where things really started to get weird, because the father's talking about this very strong odor in the car, and he said he had smelled something like that years before. It sounded like a decaying body. This was one of the critical pieces of testimony for the state's case, because if the father smelled what smelled like a decaying body in the back of a car but couldn't really get anywhere to see it, it would suggest that there's a decaying body in the trunk of the car.
Well, or that there was at some point a decaying body.
Yes, or there was something related to it.
At some point. And I think the mother also at some point calls the police to say that there's a smell at the car, if I remember correctly as well. I mean, I think what's interesting about this, and it depends on whether you believe him or not, but remember that Casey Anthony is his child. So, as a parent, regardless of the fact that you've lost your grandchild, you also don't want to lose your child. And so, one would argue that he's hesitant to kind of talk about some of the things he smells, because by saying he smells a rotting corpse, it actually implicates his own child. And so that might be the reason why, arguably, the prosecutor has trouble kind of getting those specific words out of him. Some might argue that he's acting, and therefore he's just making it seem as though he's trying to protect his daughter, but maybe he's really protecting himself, but
well,
again,
we know which side argued which side, and
right.
Apparently it was, or presumably at least, it was the defense's side that stuck, or at least raised enough reasonable doubt for Casey Anthony to be acquitted of all the most serious charges.
Right. No, I know, but again, you always have to wonder, what the jury was thinking. And you had said, Beth Kara said, at the end of the day, they may have thought she did something. They didn't think there was enough evidence. And so the question becomes, well, did they not think there was enough evidence, or did they think someone else did it? And we go back and back to the fact that, and by the way, it's lucky for everyone involved, arguably, that the body was found so decomposed, because had the body been found sooner, we may have had a very different result in terms of kind of what that autopsy had revealed.
Well, a lot of what ifs about this case, which is why we're still talking about it here 6 years after the fact. But our time is up for the day. So, yes. Julie Rendelman, it's always nice to see you again.
You too.
Party hard tonight.
Oh, please.
All right. You said that you had to go out and meet
No, I
friends.
didn't. I did not.
All right. Well, we're going to wrap the day up here on the LawNewz Network. For Julie and her friends and myself and the tech team here, this is Aaron Keller. A reminder that we're on the air from 9 to 5, Monday through Friday. We take holidays off, though. That's why we didn't see you on Tuesday. And we stay late when we have a late live trial somewhere where they run after 5 o'clock. We're hoping to have a live trial for you next week. Again, most courts were in recess throughout the week on major trials because of the federal holiday. So we're working out the details for next week now that the Holly Bobo case has been delayed yet again. So for now, this is Aaron Keller at the LawNewz Network. We'll see you back here at 9 a.m. tomorrow.